into that courtroom for opening statements. Moving over to Jacksonville, Florida. Today marks day one of jury selection for defendants Alan Wade and Michael Jackson, not to be mistaken, of course, with the pop singer. Both defendants were previously convicted of the first-degree murder, kidnapping, and robbery of retired Florida couple James and Carol Sumner back in 2005, and they were both subsequently sentenced to death. However, both of their sentences were thrown out after the state legislature passed in 2017 a new rule requiring a unanimous jury to recommend the death penalty. So with a jury now in the works this time, the defendants will have a second try at sentencing, and we're going to keep everyone updated on how that progresses throughout the show. But we also have a new development out in Ben Hill County, Georgia, that we have to talk about. This is where defendant Ryan Duke will now face another trial. Now, you might recall that in Irwin County, Duke was acquitted back in May in a trial that we covered here on the network for the 2005 murder of Georgia beauty queen Tara Grinstead, but he was convicted of concealing her body, and he's now serving out the rest of his 10-year sentence with 5 years already served. But according to a new indictment released on Friday, Duke will face another concealment charge, hindering apprehension or punishment of a criminal, 2 counts of concealment of facts, and 2 counts of tampering with evidence in Ben Hill County for this case. Now, I'm also going to add that co-defendant Bo Dukes, who was previously convicted of concealment in this case, will also face an additional concealment charge in hindering apprehension or punishment of a criminal in Ben Hill County later on this month. So this saga, this story does not end. And we're going to break that down later on in the show. But right now, I want to talk about some new developments that are happening in the Johnny Depp Amber Heard saga. As the whole world watched on Wednesday, including 3.5 million people live on our YouTube channel, Depp won his defamation lawsuit against his former spouse Amber Heard, who wrote a 2018 op-ed in the Washington Post dubbing herself a domestic abuse survivor. Heard also walked away with a monetary award in the trial after the jury found one of her countersuit claims against Depp to be defamatory. Now, before we break any of this down, and there's clearly a lot more to get into, let's just take one more look at how the verdict went down in court.
As against Amber Heard, we, the jury, award compensatory damages in the amount of $10 million. As against Amber Heard, we, the jury, award punitive damages in the amount of $5 million. 1. As to this statement, appearing in the April 8, 2020 online edition of the Daily Mail, quote, Amber Heard and her friends in the media use fake sexual violence allegations as both a sword and shield, depending on their needs. They have selected some of her sexual violence hoax facts as the sword, inflicting them on the public and Mr. Depp. Do you find that Ms. Heard has proven all the elements of defamation? Answer, no. 2. As to this statement appearing in the April 27, 2020 online edition of the Daily Mail, quote, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt did not do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911, end quote. Do you find that Ms. Heard has proven all the elements of defamation? Answer, yes. Has Ms. Heard proven by a greater weight of the evidence that, question, Mr. Waldman, while acting as an agent for Mr. Depp, made or published the statement? Answer, yes. Question, the statement was about Ms. Heard? Answer, yes. Question, the statement was seen by someone other than Ms. Heard? Answer, yes. Question, the statement was false? Answer, yes. Do you find that Ms. Heard has proven, by clear and convincing evidence, that the statement by Mr. Waldman was made with actual malice? Answer, yes. 3. As to this statement, appearing in the April 27, 2020 online edition of the Daily Mail, quote, we've reached the beginning of the end of Ms. Heard's abuse hoax against Johnny Depp, end quote. Do you find that Ms. Heard has proven all the elements of defamation? Answer: no. As against John C. Depp II, we, the jury, award compensatory damages in the amount of $2 million. As against John C. Depp II, we, the jury, award punitive damages in the amount of $0.
All right, let's break it down. Joining me this morning, criminal defense attorneys Karen Felicia Nance and Kesia Early. It's great to have you both here. Kesia, I will start with you. You know, we've had some time to reflect on the verdicts, to think about the verdicts. I am still shocked that the jury did not believe anything Amber Heard said. They did not believe one instance of abuse. And the reason I'm saying this, I'm actually producing a prime crime on this show, and I'm going through, I'm revisiting the testimony. Every time she talked about being attacked or sexually violated or verbally abused, they didn't believe it. And do you think it was A, they didn't believe it actually happened, or B, that it never rose to what they considered to be abuse?
I believe that they believe that it didn't actually happen, and that's because Amber Heard failed to present sufficient competent evidence. Amber Heard was the person who recorded several hours of conversations. She took pictures when she wanted to, when it was convenient. So why didn't you have any pictures whatsoever of these damages? And then her testimony didn't align with her alleged injuries. I mean, you're talking about Johnny Depp, a strong man, a healthy man who they noted wore several rings on his fingers. And if he's pounding you, you know, bang after bang, you have no injuries consistent with that, or your injuries were not as visible where you could just cover it up with makeup. It just didn't make any sense. I do not believe that she portrayed to the jury that she was credible. Therefore, they did not believe her testimony. Okay,
so I talked about some new updates here. And Karen, since the verdict came out, there's now an editor's note on Amber Heard's 2018 op-ed post in the online version in the Washington Post. And it now reads, quote, in 2019, Johnny Depp sued Amber Heard for defamation arising out of this 2018 op-ed. On June 1st, 2022, following a trial in Fairfax County, Virginia Circuit Court, a jury found Heard liable on 3 counts for the following statements, which Depp claimed were false and defamatory. 1, I spoke up against sexual violence and faced our culture's wrath. That has to change. 2, then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And 3, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Now, the jury separately found that Depp, through his lawyer Adam Waldman, defamed Heard in 1 of 3 counts in her countersuit. That is now the editor's note put in by the Washington Post. If you look at it online, is that the right decision there, Karen? What do you make of that?
Well, I mean, they're a news organization, right? And they have to report the most recent information, the true information, which came from the jury. So I think that.
But they didn't take it down. They could have taken the article down. They didn't.
That's true. But I mean, I think it increases their readership, right? Now everybody's curious about what was this article about anyway. So I think that it was a strategic point on their part. It was a great strategy to keep it up so that it just increases the conversation and increases their readership. So I think it was more from a business perspective to keep it up than to take it down.
Do you think there's any room to criticize the Washington Post here, or is the right thing, Kesia, to do? Because, you know, this is now an important article in defamation law, and also this case. I think people will go back, maybe read it in its entirety, and you shouldn't scrap it. So just because there were statements in there that went against the law, you know, that were illegal, you don't just scrap it, right? It's important to still have it up there.
Well, what the Washington Post is a very credible source, similar to the New York Times. They're known for doing their due diligence. In this case, it's very hard to investigate domestic violence because there's usually no witnesses, evidence, or surveillance. So I do believe that they did their due diligence when drafted this article. However, they had no way of knowing beyond taking the statements of Amber Heard. And we don't know whether or not they reached out to Johnny Depp's team or Johnny Depp to get a statement from him to confirm what they were drafted in this article. So again, this is not a salacious magazine where they'll just write an article without doing research or for entertainment purposes. So they took Amber Heard's word and whatever evidence that she presented to to the Washington Post. So I do believe that they did their due diligence, and as my colleague stated, keep it up there because it's already been printed, it's already out there, and I'm glad that they put that editor's note to show that a jury determined that those allegations were in fact defamatory.
We talked about the fallout from this verdict. We're seeing it already. There's so much more to discuss, including Anjanette Levy's interview with the courtroom stenographer, which has already gotten 1 million views on YouTube. A lot of people have thoughts and comments on this. Was she biased? Why was she hanging out with Johnny Depp after closing arguments? We'll talk about it. But when we come back, we're actually going to switch gears and focus a little bit more on the Ryan Duke case. Stay with us.
In the Superior Court of Irwin County, Georgia, in the indictment 2017 CR 027, the state of Georgia versus Ryan Alexander Duke, with a jury found the defendant count 1, malice murder, not guilty. Count 2, felony murder, not guilty. Count 3, felony murder, not guilty. Count 4, aggravated assault, not guilty. Count 5, burglary, not guilty. Count 6, concealing death of another, guilty.
All right, that's what we covered here on the network when Ryan Duke was found not guilty of the murder of Tara Grinstead, the 2005 murder of Tara Grinstead. This was out in Irwin County, but as we reported to you earlier, he's actually now being brought up on new charges in Ben Hill County where the actual burning of the body occurred. He's facing concealment charges, hindering charges, evidence concealment charges, tampering with evidence charges. And this is going to be now a big development because Bo Dukes, his co-defendant, is also charged in Ben Hill County as well. Before we even get into that, let's play a little bit more of Ryan Duke on the stand.
That on October 23rd of 2005, you were at the orchard in Ben Hill County, correct?
Yes, ma'am.
And we can agree that on October 23rd of 2005, Tara Grinstead's dead body was in that same orchard.
Yes, ma'am.
And we can agree that you saw her dead body, correct?
Yes, ma'am.
We can agree that you touched her dead body.
After I was told to pick her up.
Yes, you touched her dead
Yes,
body.
ma'am.
Okay. We can agree that you helped move her dead body.
Yes, ma'am.
We can agree that you helped Bo Dukes get the pecan wood to be able to burn her body.
Yes, ma'am.
We can agree that you were in the truck when you drove Tara Grinstead back to the place where she would be burned.
I don't know if that's where he continued to burn her or not. I was only there that one time.
You were only there that time. But you were there because you've already admitted you helped put her lifeless body on top of that fire pit.
Yes, ma'am, I did.
And you don't want to admit to having seen the match struck, but you know that she was set on fire.
Yes, ma'am.
And you knew that on October 23rd of 2005.
Yes, ma'am.
And you knew that on October 24th of 2005.
Yes, ma'am.
And you knew that on October 25th of 2005.
And every day after.
That's right. Every day after. And you never told a soul.
No, ma'am.
Okay, so Karen, it feels to me that now they're going after him. And, well, I think that we all knew that he was going to be brought up on charges in Ben Hill County, but even more so, the fact that he was acquitted of murder in Irwin County. He was convicted on one charge there, concealment charge. But the fact that now he's really being brought up on these additional charges in Ben Hill County, it's because the prosecution lost in Irwin, right?
Absolutely. And they basically, after hearing the testimony in the Ryan Duke case, we know that they should have charged, according to the jury, basically, right, that it was Bo Duke that was the one, the mastermind supposedly behind it, the smarter of the two high school classmates. And so I think that in order to get more time for each of these defendants, because they're not going to be able to move forward with the murder charges, they're making sure that the place where Tara lived and where she was residing in Irwin County, now they're going to Ben Hill County, which is where her body was found. So it's basically, I think, taking two bites of the apple, and it's going to raise double jeopardy issues as to whether or not they can go forward with these new charges in Ben Hill County.
And remember, during the course of the trial, the jury there actually had a question about venue. Take a look.
It says, can you please clarify this question for the jury regarding number 22, venue, in jury instructions? Please define the term venue as proper and explain how it applies to to count 6, concealing death of another. If you'll exhibit that to the attorneys, please.
Casey, when you hear that kind of question, what does that tell you?
It might be a possible attorney in the jury panel because they were really thinking about where this crime allegedly occurred and where he's being tried. So it appears that they had those questions, and obviously the prosecutors in Ben Hill County have the same question. And I believe that whatever charges he's convicted on and whatever judge is presiding over this case may possibly run these the time that he'll be served consecutively or concurrently. It depends on how long they really want him to spend the rest of his life behind bars. I know right now he's serving a 25-year prison sentence. So if he's convicted in Ben Hill County, that can be served consecutively right after he served the 25-year term.
Let's talk about Bo Dukes for a second, because the defense addressed him in their closing argument during trial. They put the blame on him and said he's the actual killer. Take a look.
Gentlemen, thank you so much for your service over the last 3 weeks. We know what an imposition this has been for you. It's been incredibly hard in your personal lives, I'm sure, and we appreciate your time and attention for taking such good notes. Bo Dukes should be sitting in that chair, not Ryan. Bo Dukes should be on trial for the murder of Tara Grinstead, not Ryan. Where was Bo Dukes in this trial? Why did the state not bring him? Why did we have to call Bo Dukes? Why did Bo Dukes not answer our questions? Be thinking about this as we talk about this case, because there's an important theme here. Ryan took the stand and sat in that chair and told you what he knew. He told you what happened. He didn't have to do that. He could have remained silent and sat over there this entire trial and not told you his story. And you saw him sit there and tell you that story from his own mouth, with his own words, with his own emotion, and you saw how it affected him when he talked. Don't forget that when the state gets up here and tries to tell you that he's a liar. You saw him. You can tell whether he's telling the truth from that chair or not. Keep that in mind as we go through the evidence in the case, because I think it's very important when we talk about his statement that he gave to the police, which you all have heard a lot about. There are a whole bunch of inconsistencies in that thing. And what did the witness yesterday, Mr. Posey, tell us? It was all over the place. Why was it all over the place? Because he wasn't there. He has no idea what the facts are surrounding her death because he was not there. He told you who was there. Bo Dukes woke him up and said, I killed Tara. Not, I killed Miss Grinstead. I killed Tara. Bo Dukes had her as, Bo Dukes was one of her students. Brian was not. Bo Dukes left that trailer that night with Ben McMahon in a black truck at around 10 o'clock at night. Ryan was passed out on the floor. You heard from Jerry, famous Jerry now, I assume, picked him up by the belt and dropped him on the floor to make sure he was alive. And he groaned, and that's the last time anybody saw Ryan that night, passed out on the bathroom floor.
So Karen, as it currently stands, no one is going to be found guilty of the murder of Tara Grinstead. It seems that ship has now passed, right? So the question becomes, do you think that Bo Dukes actually did the killing? And do you think that now these concealment or evidence tampering charges are the most that the family is going to get for justice?
I think so, and it's unfortunate because the prosecutor's office got thrown off, right, by the confession of Ryan Duke. So they just ran with that. And then we have the retraction of his confession because he says, no, I did confess, but I really wasn't the mastermind behind it. I didn't commit the murder. Bo committed the murder. So I think that really put the prosecutors in a bad situation because they're like, we have this confession, we're going to go forward with it. And now I agree with Cassie. I think that it's clearly up to a judge to determine whether or not both Bo and Ryan get consecutive time if convicted on these concealment and other charges. And I think that to give the family justice for Tara, I believe that a judge would give both of them consecutive time on these charges. The question is whether or not they're going to be able to go forward with the Ben Hill county charges, because how can you differentiate what happened in Irwin County? No one knows if she was killed there. No one knows if she was killed in the other county where her body was found. So I think that they face an uphill battle in that sense, but clearly they want to get as much time as possible from both of the defendants in this case. Yeah, that's a good question, Casey. How does the prosecutor in Ben Hill County address the murder of Tara Grinstead? You know, it would have been so easy to say, if he was convicted, this man murdered Tara Grinstead and then he helped to burn the body. They can't say that. So is this going to be kind of an interesting opening statement in case?
Very interesting, and it's going to be difficult for the prosecution. They couldn't even prove that either one of Dukes or Duke committed the murder. So how can you state or prove beyond a reasonable doubt where this murder took place and where the concealment took place? I think that particular charge will be difficult, but tampering with evidence, that I'm pretty sure that they can prove that. And again, once that's proven, to get sufficient justice, because you won't get it on the murder charge, to ensure that they're behind there and die in jail, the judge in this case will possibly go ahead and make those terms consecutive.
All right. Well, we're going to continue to follow the latest in the Tara Grinstead saga. It is a saga that we are always covering here on the network because it is really just so eerie and chilling, and it has these ups and turns and twists and turns, and we're never really sure which way it's going to go, but we will cover every second of it here on the Law&Crime Network. When we come back, we'll focus once again on the Johnny Depp Amber Heard trial. As I mentioned to you, we have an interview with the court stenographer who became quite a controversial figure in the aftermath of this case. We'll be back. everybody. We're still talking about the verdict in the Johnny Depp Amber Heard trial, but really not only so much the verdict, but the aftermath of the verdict, where Johnny Depp basically won his entire case and Amber Heard only won with respect to one of her counterclaims. The aftermath, not only the reactions, but what has we been seeing? We talked about earlier how the Washington Post added an editorial note to now the 2018 Washington Post op-ed piece from Amber Heard talking about the developments in this case. But we also saw this backlash against the court stenographer, Judy Bellinger. Now, the reason Ms. Bellinger has been getting this backlash is because there was this video that circulated what appears to be her partying with Johnny Depp after the verdict. That's what this looks like. But according to Judy, that was not the case at all. And the reason we know that is because our very own Anjanette Levy sat down with Judy, and you can watch this entire interview on our YouTube page. It currently has about 1 million views, but this is a quick sample of what actually happened here. Take a look.
So after closing arguments, I finally decided I wanted to get out of the courthouse and just take a breather. We were supposed to go until about 5:30, maybe 6 if the jury wanted to. And so I thought, I want to maybe try to go to Indiana this weekend. Let me run down the street and get my oil changed, and I'll come back and go back up. The courthouse closes at a certain time, and I didn't make it back in time. And Judge Ascarati just wanted to close the record. And I'm like, oh, yeah, well, I'm stuck outside. I'm getting my oil changed. And she goes, oh, it's okay. Well, she didn't say it. I was getting messages, and I said, okay, just don't worry. My recording's going. It's just closing the record. I'll, transcribe it when I get back. But then I needed my equipment. So Mr. Chu and it was Rebecca. I think they were the ones that were there, and they were kind enough to pack up my computer for me in my backpack, because that's all I needed. I leave my machine there because it's just quicker to come in and just set up my computer and not have to set everything up every day all over. So they were kind enough. They said, okay, if you tell us how to, disconnect everything, we'll bring it to you, because we have an office right around the corner from where we are now, and this is where they were staying. And I said, hey, I have an office on Greensboro. I can meet you there and get my equipment, and I can get the transcript out this weekend. So they're like, okay. And then I guess Johnny had told them he would really like to meet the court reporter, which was like shocking to me. I'm like, I'm just the court reporter. And so when they brought me my equipment, well, they were going to bring it, and there was no one at our Greensboro office, and you can't get in if there's no one there. So
and it's Memorial Day weekend.
Right. So
it's a holiday weekend.
Yes. So they just brought it back to the hotel, and they said, hey, do you mind if we just take it to the hotel and you can pick it up here? And actually, it took me a minute. I didn't know how to get up here. I didn't know you had to come in the downstairs door and then go to another floor and then get to another floor.
It's a little confusing.
It is very confusing. And so they had my computer and stuff with them, and they were in the hospitality room, and Johnny was in there. And so I had to go in there and get my equipment, and I saw him, and they're like, he really wants to meet you. And I was in there for probably less than 10 minutes. And he just hugged me and thanked me again. And I hugged a couple other people there, and I got my equipment, and I came out, and I left and went home.
That's really funny, because a lot of people are suggesting you're just out at the after party hanging out, with Johnny Depp, and that's not what happened.
Not at all. I still had from here, I had about a 50-minute drive home, so no, that did not happen.
He gave you a hug?
Yes.
You picked up your stuff and you left?
Yes. But it was a moment that I'll never forget.
And you've got video to support it. Have the grandkids seen that video?
No, not that I know of.
So, Karen, do you think she did anything wrong here?
Absolutely not. I mean, seems like a very pleasant person in court. I mean, that's a hard job to transcribe in real time in court. I admire all court reporters. They do an amazing job. So I think she was totally within her rights to do what she needed to do. She had to get her equipment over a 3-day weekend. So I don't think she did anything incorrectly at all.
But Casey, could Amber Heard's team say, well, listen, this shows that she's biased. I'm going to go back through the court record and see if she was accurate. Maybe she didn't take the proper notes. Maybe she took notes to benefit Johnny Depp. I know that's a conspiracy and a wild accusation, but the point is I imagine Amber Heard's team will now say, look, the whole court was biased, she was biased, we can't trust her work product now. Any grounds for that? Because we know Amber Heard's appealing.
That's far-fetched. I mean, bottom line, had she not gotten back to the courtroom late, she probably would have never encountered Johnny Depp. This was just an innocent encounter, and obviously she was thrilled and fascinated that Johnny Depp wanted to meet the court reporter, because they're usually the forgotten ones, right? They're in the background. I don't believe that there's grounds, unless they have the money to order all the transcripts and, verify that everything was transcribed properly. I doubt that. I mean, that is a conspiracy theory, and she's the innocent party in this case.
It just shows how everybody picks up something from that's happening afterwards. This interview with Judy, the stenographer, she also talked about how the jurors acted during the trial and how one reacted when they were found out that they were the alternate. She had a great front row seat to the jurors, so let's hear what she had to say.
I remember the jury was very intent. They were listening very intently. And unfortunately, when the jury was chosen, we knew that there were going to be some that would not see it all the way through. That there were alternates. We knew who the alternates were from the start because they just picked the names randomly. But I could not remember the numbers, and there was, unfortunately, the one alternate that was on there. She was probably the one that listened the most. I watched her facial expression. She was very deeply into every word that was being said, and I thought she would have made a great juror, and she did not get to see it to the end. She just took her hand and go, and I was like, oh man, she was going to be the best juror. I really thought she was the best juror.
Interesting, and it was because she was paying so
She was paying close attention. There were a few jurors that were dozing off.
Really?
She never dozed off.
Were the jurors who were dozing off, were they in the back row, front row, both?
Both. And it was tough because there was a lot of video deposition. And, they would just sit there and all of a sudden I'd see their head drop. But never her. Never her.
Yikes. Karen, when you hear that, what do you think?
It's scary, right? But I mean, we sat, we watched it, and there were times, especially with the videotaping, watching those depositions, it was hard to stay alert. And I can imagine sitting in the courtroom for hours. So you can empathize with them, right? And it's just unfortunate that the one that Judy felt was the best and most attentive was the one that ended up being an alternate and not being able to sit on the jury.
It's frustrating, I mean, look, from when I was in the courtroom, I never saw them dozing off, but then again, she had a much more front row seat and was there for every day. It's interesting when you hear that case, Sia, that the juror she thought was going to be probably the best juror didn't get selected. And I'm curious, if you are that juror, do you go out and do an interview and say, hey, listen, I would have maybe voted differently? And I'm curious what that would look like.
Yeah, but that's the purpose of deliberations, is that everyone's voice in the jury room is heard, and you consider each, scenario. So although she would have voted differently, we don't know that because someone else could have presented an alternative theory or analyzed the facts and evidence and testimony, and it probably would have swayed her decision. So trying hundreds of trials to verdict, I usually don't even speak to the alternate because bottom line, you're just one opinion. This is why we pick between 6 and 12 jurors so that everyone can analyze the evidence and come up with one unanimous decision.
Now, speaking of the jury here, Karen, Elaine Bredehoff did the media tour a little bit, although she has yet to come on Law&Crime. We would love to speak to her. But she does a little round of a media tour, and she says that, in her opinion, how could the jurors not have been swayed by all of the media attention and everything that surrounded this case? It is an assumption for her to say that, right? It is speculative to say that. To say that the jurors must have been biased and must have been influenced by everything that was happening outside the courthouse and on social media, is that fair?
Absolutely not. And we have to give the jury the benefit of the doubt, which the court gave them, right? She said that you were given certain instructions. They agreed at the outset that they were going to follow those instructions. And so we have to believe in the court system. We have to believe in the jury system. That's why we have it. So for her to go on these media blitzes and say these things, I think is really inappropriate. And she's an officer of the court, Ms. Brenda Hoff is. And so I think that it just flies in the face of our judicial system and us as lawyers. I mean, we have to believe in the system and to go out because you've lost, right? It's spilled milk, crying over spilled milk, and going out and saying these things about the jury is really inappropriate. And I think it does not keep the high standards which we're trying to do, right, as lawyers, and come off as authentic and supporting of the system. And she didn't do that, and she hasn't been doing that. And so that's very unfortunate.
But Casey, here's the thing. If the jurors come out and they do an interview and they say, yeah, we saw all this stuff online. It didn't sway us, but yeah, we saw all this stuff online. Or if someone even comes out and said, yeah, I read something about the case, or they looked at everybody outside and said, I saw the Johnny Depp supporters. At what point does it become a successful grounds for appeal for Amber Heard's team? They might, try to say anything, put anything in an appeal to try to make the point. But at what point does a court say, you know what, this was juror misconduct and we have to reverse the verdict?
Well, that's the avenue that an attorney should take. If they believe that the jury got it wrong, there's motions that you can file. There's usually a motion for judgment of acquittal after the verdict. There's a motion for a new trial that you can file based on the state a few days after the verdict. Rather than going to the media and saying that, this was a biased jury, that they did not deliberate properly on the facts and evidence. Well, you picked the jury. So you went through this vetting process, especially during the voir dire process. And now that the verdict was not returned in your favor, I don't believe voicing your opinion to the media is the avenue. Utilize the courts. That's the purpose of an appeals court. That's the purpose of the Supreme Court, is to say that, the trial court got it wrong. Here's some case law. Here's some facts. Draft your motion and let the court decide, rather than you showing that the jury was biased, because that is not respecting the jury's decision, respecting the judicial process, and respecting the rule of law.
All right. Well, we're going to talk more about the verdict, and we'll talk about fan reactions to the verdict right after this. still talking about the aftermath of the Johnny Depp Amber Heard verdict, where a jury found Amber Heard liable for each one of Johnny Depp's claims of defamation against her, and the jury only found Johnny Depp liable with respect to one of Amber Heard's counterclaims. He is being paid out $10.35 million from Amber Heard. She received $2 million in damages. Now, nothing has been paid out yet. That is a separate question. We'll actually get to that later on in the program. But that was the issue of damages and the verdict of damages in this case. But again, we're talking about the aftermath. We're talking about what's happening. Washington Post now came forward with an editorial note on the op-ed piece from Amber Heard. We heard from Judy Bellinger, the stenographer, the court reporter in this case, court stenographer in this case. And now I want to focus a little bit more on the fan reactions. You know, me personally being there in Fairfax County, Virginia, it was a swarm of Johnny Depp supporters and not that many Amber Heard supporters. But there were a few. And in fact, Stacey Delicat caught up with a Heard supporter after the verdict. Take a look.
Your reaction to the verdict?
Disappointed, confused, but not surprised, I guess, yeah.
Yeah, you're confused why?
I feel like it doesn't really make sense in terms of just the defamation part and how it's affected their work life. With Amber, I feel like she didn't really have much outside of Aquaman that is really like a big thing for her. And we've heard how much her part has been pared back. Compared with Depp, he had already kind of been on the downfall of his career because of his drinking and drugs. So I don't think that her op-ed specifically was what affected him, so.
Okay, let's first just talk about whether or not the verdict was consistent. That's a big factor here, Karen. So a lot of people have come forward and said, well, how do you find Amber Heard defamed Johnny Depp, that she lied about him in the Washington Post? These were all false statements. And yet at the same time say, well, the statement from Adam Waldman claiming that her and her friends staged a scene, tried to make it look like Johnny Depp did something, that they framed him. How do you say that's defamatory? And so do you view these verdicts as inconsistent?
I don't view them as inconsistent, Jesse, for two reasons. One, when we're talking about Johnny's case against Amber, we're talking about what she did to him specifically, right? And so the jury found, based on all of the evidence that they heard, that she did not prove that she was an abused person, abused by Johnny specifically. So that's why they awarded him the verdict in his favor. With regard to her case against Johnny, we have to add in the factor of his attorney, Adam Waldman, right? And so it was several statements, 3 statements that the jury had to focus on. And with regard to Waldman, the one that they did find that there was defamation was the one that he included the other, her friends in the statement. And so the jury could come to the conclusion that the person that was the primary and only one responsible, solely responsible, was Amber and not her friends. And also there's a disconnect from the jury's perspective that it wasn't Johnny specifically, it was his agent, his attorney acting on his behalf. And there was arguments, of course, that he was acting on Johnny's behalf, so therefore Johnny's liable. And the jury did find that to that extent. So I don't find that the decision of the jury with regard to Johnny's case against Amber as inconsistent with Amber's case against Johnny for those reasons.
Well, as Sydney Porter, the Amber Heard supporter, just explained, that she was a bit confused in terms of damages and the effect. That's the way I understood that question. And the idea here, Casey, is that what really damaged Johnny Depp's career? Was it his own actions, or was it the Washington Post op-ed? When the jury comes back with $10 million in compensatory damages, $5 million in punitive damages, but really that number was reduced to $350,000 by law, does that signal to you that they believe the article hurt him that much, or was it other things that hurt his career?
No, I believe that they believe that the article hurt him for about $10 million because Johnny Depp originally was suing for the $50 million. So they didn't give him everything that he requested. They gave him a lower percentage of what he requested. I do believe that the jury took into consideration his drug abuse, alcohol abuse, his mental instability, and that all of those factors also contributed to his own downfall. But they really took into consideration that this op-ed that was published had some contributing factor to Johnny Depp career declining, but not in its entirety.
Interesting. All right, so we're going to talk a little bit more about the reaction. So we heard from a Amber Heard supporter. Now here is a Johnny Depp supporter. Take a look.
Your reaction?
First, I'm going to say hi, Mom.
Of course.
I think it's good because it showed that the jury found that he did not do the things that she said. The money, he wasn't going for the money. So I'm all right with the money. It just found that she didn't have any clout in what she was trying to say.
Were you surprised that they found for him on every question?
Absolutely not.
Absolutely not.
Absolutely
Okay.
not.
Were you surprised that they found on the second Waldman statement?
Yes, because, I mean, if it was just Johnny, it would have been different, but it also was Waldman too, so.
As his agent?
Yes, yes. So there could be speculations, you know, that would be like me going around saying something about my friend over there and then, you know, falling back on her because of the things that I think it shows that men can speak up too, because it's usually women that do. So I think it is not a setback for either side. Just if you do it, come with the truth.
Okay, so Karen, when you hear this, now the question is, how does this case change defamation law, or does it at all? I've came into this case thinking it's so tough to prove defamation cases, particularly when you're a public figure, particularly when you have to show actual malice. And given that, you know, there was the argument from J. Benjamin Rottenborn, if you find one instance of abuse, jury, Johnny Depp loses. They didn't do that here. What do you think?
I think I don't think it deals directly with each and every defamation case. And I think that we have to look at the amount of money and resources that Johnny Depp and Amber Heard had in order to move forward with this case. I think that social media played a huge role in this case. We had people that basically came out of the woodwork. We had the person from the TMZ, clearly, and then we had from the trailer park that came forward, Morgan Black, I believe his name was. And so those people came forward, one, because the trial was televised, which Amber Heard did not want the trial televised. So I think that people that have resources and power, they're going to be handled differently than people that don't have those resources. And if it wasn't televised, I think we would have probably had a different result. And we can't overlook the fact, which I think is the most important part, is that Amber, there was tape of this. There was audio as well as videotape. So I think that that had a significant impact on not only the jury, but the public watching this trial. Had a huge impact.
Yeah, it really did. And the other question, of course, is, you know, we're going to focus a little bit more on it, is not only the impact on law, but also the impact on people coming forward with these allegations, you know, and is this case just a unique outlier? We can't judge it and use it as a blueprint moving forward, given the facts and circumstances and defendant in this case, or is this going to be problematic? And this is a big question that we've seen in the aftermath of this trial. It's an important question to have, and we are going to talk more about it. So when we come back, we'll focus a little bit more on Johnny Depp and Amber Heard. We're also going to focus a little bit more on the Ryan Duke case, and we are keeping a very careful careful eye on what's happening on our brand new trials here on the network. Stay with us. back to the morning docket here at Law&Crime, everybody. I'm Jesse Weber, and thanks for joining us. We're still breaking down the verdict in the Johnny Depp Amber Heard Defamation Trial. Johnny Depp winning across the board on each one of his claims of defamation against Amber Heard for the 3 statements that she made in a Washington Post op-ed piece in 2018. Amber Heard only winning with respect to one of her counterclaims against Johnny Depp for the statements of his attorney, Adam Waldman. And we're still talking about what's been happening. Earlier today, we focused in on how the Washington Post now had to put up an editorial note in regards to that op-ed piece. We talked about an interview that Anjanette Levy did with the court stenographer who's been taking a bit of heat after this video circulated of her celebrating and hugging Johnny Depp. She explained the context of that. We've been playing fan reactions to the verdict as well, outside of the Fairfax County, Virginia courthouse where we were stationed up for 6 weeks. But now let's hear from Kathleen Zellner, who at one point was a consultant on this trial. Let's take a listen.
I really approached the case more as a criminal attorney, and Johnny had reached out to me just, a few months ago. I told him I was getting ready for a murder case, and then the murder case got continued, so I was able to carry on conversations with him and sit through some of the depositions. But I really think it came down to credibility. I think her case failed. And looking at it as a criminal attorney, it failed on the forensic evidence. Those beatings and abuse that she described did not happen. I've been doing criminal cases for over 30 years, and the forensic evidence simply wasn't there. She just did not suffer the injuries. Forget about having witnesses. I can understand, that abuse victims don't have firsthand knowledge, witnesses present, but the evidence wasn't there. There just was not the forensic evidence to support what she was claiming. The second thing, because I've represented a lot of sexual abuse victims over the years, she wasn't afraid of him. And I think Camille Vasquez did a beautiful job of laying all that out, not only in the cross-examination, but in the closing. I mean, she wasn't afraid of him. She was, taunting him. She was very aggressive. And so her case just collapsed, and that falls at her feet. She just was not credible. That's why she lost.
All right, so join me once again, criminal defense attorneys Karen Felicia Nance and Kesia Early. Karen, you tell me, do you agree with Ms. Zellner's comments about why the jury came back the way they did? And 2, what do you see the effect of it being on other cases where, in general sense, where people accuse someone of sexual violence, domestic violence, and particularly those cases when they're going after and they're accusing someone who is very notable and is a celebrity? What impact do you think this case is going to have?
Well, with regard to Ms. Zellner, she's known in the field. As she indicated, that she's been in this area for 30 years as a practicing attorney. And so she's extremely credible. And she indicated in the full interview that Johnny actually reached out to her. She hadn't had she wasn't a friend of his. She was fully objective. And she also indicated, I believe, that she can tell if somebody's telling the truth. And by her interview or conversation with him initially, she understood and felt that he was being honest and truthful. So that's the first thing. The second thing is that we have a situation where people make judgments about this trial without having sat and listened to Amber's testimony and her demeanor on the stand, and also listening to the videotapes the audio tapes and a little bit of the video she was in. So I think that is directly goes to Amber's credibility as well as Johnny's, obviously. But we have a different presentation, right? From the very beginning, he acknowledged his drug use, he acknowledged his drinking, and Amber never, from my perspective, actively acknowledged her part in this and why she was taping him without his knowledge. And I think that had a significant impact on the jury's impression of her and her credibility, and those people that are making judgments without having seen the trial. And we had that opportunity, right, through Law&Crime to watch every single aspect of this trial. So the jury is out in terms of public opinion, but I think those who actually saw the trial would be in a better position to understand why the jury came to the decision that they did.
Kesia, do you think there were any legal mistakes that were made, any arguments that were made by Amber Heard's side that shouldn't have been made or that could have been made better? Or is it, we're just looking at it Monday morning quarterbacking and it's easy to pick on things? Were there things that were happening during the course of the trial when you said, I'm not really sure about that?
I didn't see anything. There was no allegations, and from my perspective, from ineffective assistance of counsel. I believe that the judge made the proper rulings when the objections were raised. This was a clear-cut trial. The only problem was that the evidence was not sufficient that Amber Heard was a victim of domestic violence based on her allegations. I mean, it just wasn't there. And you can't raise these allegations and not submit sufficient evidence. And I know that she testified during the trial that she turned over everything and it was up to her attorneys to submit everything into evidence. But if you're throwing your attorneys under the bus because they didn't submit sufficient evidence, then maybe your attorneys did not believe that that was sufficient based on your allegations. So I do not believe that the jury found her credible. They probably looked at her as an actress, and then being kind of sneaky and conniving because she's recording personal moments that should have been kept private as a married couple. And she did not take pictures of what was the most important thing, which was her abuse.
So and I want to talk about that for a second and what we can make of it. I will tell you that some of the most impactful testimony on her side was the testimony of Melanie Iglesias. This is Amber Heard's makeup artist, who not only said she observed these bruises after Amber Heard alleges Johnny Depp headbutted her in the face, but then had to cover them up for an appearance on the James Corden show. Take a look.
On December 16, 2015, did you return to Amber Heard's penthouse?
Yes.
And why did you come to Amber Heard's penthouse on December 16?
It was the James Corden show. She had an appearance, so I came back to work.
And when you arrived at the penthouse on December 16, please describe for me what you observed about Amber Heard's face and any injuries.
When I came to the penthouse on December 16 to do Amber's makeup, she had injuries. She had too light, I don't know how, I mean, I'm not a medical expert, I don't know how I would describe them, but it could have looked like somebody had headbutted her lightly, so she had a discoloration here, under both eyes, and on the bridge of the nose, and she had what I would call a split lip or something on the lip, like a gash or a split lip.
Ms. Iglesias, I'm going to ask you to look at what has been marked as exhibit number 11. Do you recognize this photo as being Amber Heard's head?
Yes.
Okay. And could you please describe for me what this photo is showing?
It's showing a chunk of missing hair.
And what, if anything, did you observe on December 16 about Amber Heard missing a chunk of hair?
I remember this because she showed it to us, and I looked at it.
Okay. And can you describe what is depicted right along her scalp there?
I don't know.
Do you recall that there was some bruising along the scalp and some pus, for lack of a better word?
I don't recall.
Could you please describe what you did by way of makeup to prepare Amber Heard for the James Corden show on December 16, 2015?
Yes, we covered, I just did makeup, but just a little heavier where needed. So we covered, the discoloration, the bruises with a little slightly heavier concealer, one that has a little more of a peach undertone, which I would normally don't use on Amber, but peach do cancel blue. So I did that under the eyes, and although Amber always, has a red lip, is one of her signature look, I remember clearly talking that we had no other option that night but then to use a red blood, like a really red lipstick to, make sure we could cover up the injuries on the lip.
And were you able to cover all of the injuries with the makeup that you applied and as you just described?
Yes.
Ms. Iglesias, if you could look at what has been marked as exhibit number 22, do you recognize Amber Heard in that picture?
Yes.
Okay. And is this the picture of her? Is this a picture of her that evening, December 16, 2015, on the James Corden show?
Yes.
What, if anything, did you observe on the difference in Amber Heard's demeanor before the show and then on the show?
That she had the ability to, turn it on. That she, the ability to do her job and perform how she was supposed to perform on the show.
And prior to Amber going on the show and while you were working with her on her makeup, how would you describe Amber's mood and demeanor?
Angry, sad, a little erratic.
Okay, Sia, when you hear that, the thing that strikes me is you put away Amber Heard's testimony aside. What is the jury saying about those photos? What is the jury saying about Melanie Iglesias' testimony? That these weren't real injuries, that they were manufactured, that she's not telling the truth? Walk me through what could be some possibilities here.
I don't necessarily think that the jury believed that these were not real injuries. The question is, how did Amber Heard sustain these injuries? The makeup artist wasn't present to see. All she was able to see, if you believe her testimony, is that she had some bruising. Specifically, she said under the eye, the nose bridge area. But when you're headbutted, unless I'm wrong, there would be maybe contusions or some type of swollen area in the forehead, but not necessarily under eye. Again, I'm not a medical doctor, but I'm just saying from practical common sense from the jury. So I don't believe that the jury does not believe that these weren't injuries, but there is a question as to how Amber Heard sustained these injuries. Now, if they don't believe Amber Heard, then obviously they cannot believe the makeup artist because the makeup artist did not have firsthand knowledge, and anything she says was hearsay testimony. So again, it goes down to how can you prove that you sustained these injuries from Johnny Depp?
And what do you think it was, Casey? I mean, Karen, the legal standard to find in favor of Johnny Depp for defamation is much lower than when we talk about beyond a reasonable doubt convicting somebody. And he wasn't on trial for a criminal case here, Karen. He wasn't on trial for a criminal charge. It was just whether or not Amber Heard was telling the truth about him in the Washington Post article. So the fact that the jury kind of had, even though, clear and convincing evidence of actual malice and greater weight of the evidence of whether or not the statements were false, two different standards here. The fact that the jury didn't even just say, you know what, there's too much here. I don't think she lied when she said she was a victim of domestic abuse. They didn't come back with that either. And so listening to that testimony and thinking about what the jury's verdict is, what's your response?
Well, I think that her presentation, meaning Amber's presentation on the witness stand, really was the litmus test, so to speak, for the jury. They were very close to her in proximity, and she would turn it on and turn it off. She was basically doing her best act. She's an actress. And I think with regard to Ms. Iglesias, she said in the clip we just saw, she knows how to turn it on, meaning Amber. She's an actress. And I think in this particular case, it worked against her because that's what was in the jury's mind. Johnny was pretty consistent, and even though he had some snide remarks for Mr. Rottenborn, he was pretty consistent in his his presentation in the courtroom, and she seemed more erratic. I mean, she was angry, then she was sad, and her tears on the witness stand were without water. I mean, she just seemed like a mess, and she came across. I believe the jury thought that she came across as not being credible and not being believable in her presentation. And so I think that that's what did her in, is her lack of credibility. And as she sat there, she was Dr. Jekyll, Mr. Hyde. On direct, she was very calm and somber. And then when being questioned by Camille Vasquez, she was a different person. And I think that really did her in.
You talked about Johnny Depp. We're going to talk more about Johnny Depp, but we'll hit a quick break. When we come back, we'll focus in on his testimony. Stay with us. All right, welcome back, everybody. We're still breaking down the Johnny Depp Amber Heard Defamation Trial. We're continuing our discussion of Kathleen Zellner, who was a trial consultant on this case at one point. She talked about some of the deficits in Amber Heard's case. Let's hear what she had to say about Johnny Depp.
Yes, you did see the real Johnny Depp. He's exactly the way he presented himself. His speech pattern is exactly that's the way he speaks. He's very thoughtful. He speaks very slowly. He thinks about everything that he says. None of that was acting. That is who he is. And he never varies from that. I found him to be just a very humble and sincere person, and probably one of the most unpretentious people I've ever met in my life. He's the real deal. That is the person that he is. That's not an act. I believe everything that he said on the stand was sincere. I do believe, what he stated is exactly how he felt, that he was very concerned about his legacy and rectifying this horrible lie that had been told about him. I think the great thing about his testimony is the trial team really brought out all of his thoughts about this. I thought they did a wonderful job of letting him, and I think that was Jessica Myers that did the direct. she did a wonderful job of just letting him explain himself. That's the way, if you were sitting with him today, that's exactly what he would tell you. He never varies. He doesn't contradict himself. He doesn't tell different stories. He's just a truth teller. So I'm so happy for him. He's been reborn.
All right, so clearly, Karen, there's a little bit of bias here, right? We understand there's a little bit of bias here, Karen. But the point is what did Johnny Depp do well?
He was himself, which is what Ms. Zellner said. He was the same as he sat there. He was talking to his attorney team, and he was engaging. And I believe, even though he admitted, and we saw that he sent these horrible text messages, and we have these pictures that Amber took of him apparently passed out. He was, I believe, believable. If you didn't, even if you liked him or you didn't like him, he was believable. He was consistent. And I think that that's what the jury saw, and that's what America saw, and that's why he is in the spotlight and remains in the spotlight, because he is who he is. He was consistent, if nothing else. And he was credible. And I think when he took the stand the very first time, he said, I'm here for my children. I'm here to reclaim my name. And he admitted what happened in his childhood. And I think that made him enduring. It made him human, right? He's this huge megastar, but at the same time, he has his flaws. And I think that was endearing to the public at large. The public opinion really bought into his story, good or bad. He was vulnerable. And I think that he admitted that. And we saw that. And that was different from how Amber presented herself.
Casey, when I was watching him, I was in the courtroom for the first day of his testimony, and he had these long, drawn-out answers that took some time. He struggled with the words. People thought it was performative. I didn't. I thought it seemed pretty genuine from the Johnny Depp, who, the way he acts on camera and spitting out lines minute by minute, it just didn't seem like this guy. And I'm curious what you thought of that aspect, because it did take a while for him to answer a question.
It did, but he had us on a string. You were sitting there waiting to hear what he had to say. This is a true story of redemption. And let's not confuse credibility with perfection. He was credible in that he owned his mistakes. He owned his past. He owned the fact that he abused drugs, alcohol, and may not have been the best husband, but he also provided an explanation. He told us about his childhood. He told us about his parents and the environment that he grew up in, and how he felt that he was being treated by Amber. So when you heard this explanation, when you heard his explanation, what he experienced as a husband, you started to be pulled into what he had to say. So yeah, he was slow at what he was saying, and I also think it was strategic that the the attorney for Amber Heard did not object, because then it would seem like she's cutting off a story and didn't want him to explain himself. But again, he allowed himself to be to tell his story, and it resonated with the jury as his truth. So he owned his truth.
Well, let's talk about that, because there wasn't always such smooth sailing. One of the most difficult things that he had to respond to was the infamous kitchen video that we played a little bit earlier. Amber Heard recording him smashing cabinets, kicking the refrigerator, pouring himself a mega pint of wine. And it was a tough video to watch, because it made you think, well, if this is what he's doing, A, could this be seen as abusive? Amber Heard's around this. And B, what was he doing behind closed doors if this is how violent he gets at one instance? So here's how let's see the video, and this is how he responded to it.
What happened? What happened? Nothing happened, Miss morning. You know that?
Were you in here?
No.
So then nothing happened to you this morning?
Yeah, you're right. I just woke up and you were so sweet and nice. We were not even fighting this morning. All I did was say sorry.
Did something happen to you this morning? I don't think so.
No, that's the thing.
You want to see crazy? I'll give you crazy. That's crazy. Oh, you're crazy. Oh, you're crazy.
Have you drunk this whole thing this morning?
Oh, you got this going. You got this going?
I just started it.
Oh, really?
Yes.
Really? See that?
No, didn't. You were smashing.
This is at your house in West Hollywood on Sweetser Avenue, correct?
That's correct, sir.
And that's you in the video, Mr. Depp, right?
That's correct, sir.
And you would agree that you were violent in that clip, correct?
Clearly I was having a bad time. I don't know what it was with regard to completely at this point, since I don't know the date, but being illegally recorded by your chosen other is, well, it's quite fitting with the rest of the photographs and tape recordings she made. So I thought what was most interesting is that she tried to hide it from me, and then that she laughed and smiled at the end. I thought that was the most interesting part myself. But so yes, I did assault a couple of cabinets, but I did not touch Miss Heard. And as you can see, I think, no.
And you may have been drunk in that video, correct?
There's a possibility of that, yes, sir.
You poured yourself a mega pint of red wine, correct?
A mega pint?
Yeah.
I poured myself a large glass of wine.
Right.
I thought it necessary.
Right. You seemed amused by the terminology. You were asked the question, you were drunk, I'm going to suggest. What do you say to that? Answer, I may have been.
Where are we, sir?
Line 5.
Thank you.
Question, you were drunk, I'm going to suggest. What do you say to that? Answer, I may have been, I do not recall. The chances are very good that I was if I was upset. Question, we saw you pour a sort of, answer, mega pint. Question, mega pint of red wine, which is not everybody's choice for breakfast, is it? Answer, no. Did I read that right?
You did.
And you were very, very upset in that video, correct?
I think that's pretty clear, yes.
And you would agree that your behavior in that clip could be intimidating to anyone present in that room, correct?
Objection calls for speculation. I'll sustain the objection.
Okay. You would agree that your behavior was intimidating, correct?
Objection calls for speculation. All right, I'll sustain the objection.
Okay. Now, you're a lot bigger than Amber, correct? Physically?
I wouldn't say that.
Okay. Would you agree with me that the standards of a Southern gentleman were not in your mind in this particular moment, were they?
I don't know about anyone else, but I have had experiences in my life where one does stray from complete control over their emotions at times, and that is a very normal, primal thing to do. I did not try to intimidate Ms. Heard. If she was intimidated, why was she filming? If she was scared to death, why didn't she leave?
Casey, how did he do at responding to that video? And in the end, do you think the video, well, I mean, I'm going to answer it. I don't think it had the impact that Amber Heard's side wanted it to have. Was it because of how he responded to the video?
It wasn't even how he responded. It was how she recorded it. you see someone in this state, and rather than help, rather than assist or try to calm him down, she just came off as sneaky. As I was watching the video, I just was turned off by her questions in the background. It was as if she was setting him up. And from that video, it definitely hurt. So anything he said after that, I kind of felt sorry for him on the stand, because clearly you were not scared. Clearly you were utilizing this audio. You were making sure that you were concealing the camera when he came close. And then what else did it show? That he was damaging property. So I did not like this video for Amber Heard, and it actually hurt her more than it helped her case in chief.
Well, that's the question I have, Karen. You know, she got criticized for recording him, and then she got criticized for not recording him or taking pictures of certain other events. It was like she was damned if she did, she was damned if she didn't. And I'm curious, you know, in cases where we talk about alleged sexual assault or alleged abuse, many times I say, well, there's no corroborating evidence, right? You know, you don't have photos, you don't have cell phone records. But here, she had this video, she had the photos of her what seemed to be bruised face, and in the end, it wasn't enough. So what is the lesson here moving forward with these kinds of cases?
Well, I think the first thing is, with regard to this video specifically, luckily for Johnny's team, Morgan Tremaine, from former employee of TMZ, came forward and said that this clip that we're seeing, or that was shown on TMZ, was edited, and she denies that she had anything to do with leaking this video to TMZ. And I think that just having Morgan Tremaine testify really put another dent in Amber's case, because it then corroborated the fact that she does manipulate, or did, at least in this particular case. She orchestrated this particular scene. She wasn't afraid, as Johnny responded on cross-examination. And so I think with regard to this specific video, I think that it just totally destroyed her character and her credibility. With regard to other victims of domestic violence, I think we need to look at the totality of the circumstances. In this particular case, there were things that Amber was doing that we don't have necessarily other victims of domestic violence doing. As Cassia indicated, if she was afraid, and Johnny on the witness stand also said, if she was afraid, why didn't she leave? And I do think that it does raise questions. It does put people in a precarious situation if they just hear the verdict in this case and say, wow, she was a domestic violence victim and this is what happened. She lost her case. You have to look at it in the totality and say, is this behavior by this particular person, speaking specifically of Amber, is this the type of behavior that they do exhibit? And I think when you look at the totality of it, the jury didn't believe it. And I think that when the jury, if the jurors do come forward, if they volunteer to do that at any point in time, we'll probably hear that that was a large part of their decision-making, is the lack of credibility. And does it damage people or make them less likely to come forward? Without hearing the whole case, probably, but I think that everybody has to stand in their own truth and get supported by the people that will support them. And I think it's very important that this is not the case. She is not the spokesperson for domestic violence victims.
You've always led me so well into the next segment, Karen, because that's what we're going to talk about when we come back, is kind of the things or times she was tripped up on the stand and how her testimony, her cross-examination was not like anything else. We'll be right back. Okay, as we break down the Johnny Depp Amber Heard defamation trial verdict, we have to be asking ourselves, how did the jury come to this decision? And without speaking to them, it's speculation, but at the very least, we have to imagine a big part of their consideration was the testimony of Amber Heard. I mean, she took the stand and explained, in her opinion, in her view, in her experience, all of these different multiple levels and multiple instances of verbal, physical, sexual, psychological, and emotional abuse, but yet the jury did not side with her. The jury found Johnny Depp proved the 3 claims of his defamation, the 3 statements in the Washington Post article. At the very least, they didn't even believe that there was any instance of domestic violence or it reached the level of domestic abuse. So the question becomes, what was it about Amber Heard's testimony? Well, we're going to play a portion of it, and this is when she's under cross-examination by Johnny Depp's attorney, Camille Vasquez.
Ms. Heard, at the beginning of your cross-examination last week, I showed you an audio where you told Mr. Depp to tell the jury, tell the judge, tell the world that he is a victim of domestic abuse. Do you remember that?
That's correct.
And you testified you found it hard to believe that Mr. Depp would tell the world that he's a victim of domestic abuse, didn't you?
I said I find it hard to believe that he would do that knowing that he himself had beat me up for 5 years.
But he has told the world that he's your victim of domestic abuse, hasn't he?
Well, he started to say that only recently. He didn't make that claim up until very recently. So when we signed our divorce agreement and we signed a statement saying that neither party had ever said false claims for financial gain, it was relevant and important to me because I was the only one making the accusations. I was the only one making those claims. He wasn't doing that at the time, and he signed his name to it.
You didn't expect as many people to show up and testify on his behalf that did you?
Incorrect.
When you told this jury under oath that you never assaulted, actually, strike that, sorry. When you told this jury under oath that you punched Mr. Depp because you thought of Mr. Depp pushing Kate Moss down the stairs, you didn't expect Ms. Moss to agree to testify that never happened, did you?
Incorrect. I know how many people will come out of the woodwork to be in support of Johnny.
So you think Ms. Moss needs to come out of the woodwork to testify for Mr. Depp?
Everybody who was around in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people. Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister. Of course I thought of that. I did not expect her to show up or not expect her to show up. It didn't matter. It doesn't change what I believed at the time when we were on the stairs and I thought he was going to kill my sister by pushing her down the stairs.
You told this jury under oath that Mr. Depp was aggressive and trashed a trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that was untrue, did you?
Incorrect. I've already been through trials with this man. I know how many people will come out in support of him.
When you told this jury under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016, you didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever for him. That's his power. That's why I wrote the op-ed. I was speaking to that phenomenon. How many people will come out in support of him and will fall to his power? He is a very powerful man, and people love currying favor with powerful men.
Currying
and I know
favor
that
and
firsthand.
risking jail time for committing perjury?
Excuse me? I didn't hear your question.
You didn't hear my question?
Ms. Vasquez, if you do mind, please just repeat the question. I didn't hear you.
Curry favor and commit perjury in this courtroom?
I have seen people do this.
For a powerful man?
I have seen people do this time and time again.
You didn't expect Ben King, the House manager in Australia, to show up from England. He flew from England to testify that Mr. Depp's fingertip was found exactly where he said it would be. Did you?
I have never heard Johnny testify to knowing where his finger was, or really, frankly, making a claim that he knew where it was when it was found. I've never heard Johnny claim that.
You didn't expect Keenan Wyatt.
Johnny has never actually said that.
Ms. Heard.
And
I think the jury can,
yes.
Ms. Heard, there's no question pending. You didn't expect Keenan Wyatt, Mr. Depp's longtime sound technician, to show up and testify that Mr. Depp is not being fed lines through his earpieces, but instead music, did you?
Not that it matters much, but of course I did. I know how his employees treat him.
So you probably,
I know how his team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to come and testify for Mr. Depp, right?
I'm not sure I thought about that.
Yeah. But you didn't expect Mr. Baruch to weep for Mr. Depp. after what you've put him through and so many others with your life?
I relate to Isaac because he and I are
There's
the
no
only
further
ones who
questions, Your
cried
Honor.
on this stand.
Nothing further.
All right.
Okay, so Casey, when you watch that back and forth, the big theme from Camille Vasquez, even in her closing argument, was if you believe Amber Heard, it's not just Amber Heard versus Johnny Depp, it's Amber Heard versus Johnny Depp versus every one of those witnesses that we've called that never saw any injuries and never saw him being abusive. And I think that was a really strong point. Was it that Amber Heard didn't handle it the best way she could have? Was she too combative or not? I mean, walk me through what you saw there.
Yeah, I saw attitude on cross-examination. And typically when you have, and this is from personal experience, I've tried a lot of domestic violence cases, and when I'm cross-examining the female in a domestic violence case, one thing you want to make sure is that you don't have an attitude with counsel, whether it's on cross-examination or anytime, because the moment you do that, that's a lack of respect to the court, and then you may turn off the jury. So in this case, I just saw it as a personal back and forth, but Camille Vasquez did an excellent job in controlling her, reminding her that you're not going to overtalk, you're not going to overspeak, there's no question pending. And it definitely turned off as I'm watching Amber Heard, because it appeared that she had an attitude and that she was desperate in her responses. And again, she could have had the evidence, but it just didn't appear that way during cross-examination.
So, Karen, I turn it over to you. You know, I always found it interesting watching Camille Vasquez because, and by the way, I just saw an article today that I think all these different law firms are reaching out to her to hire her, and Hollywood's she became a star in this, and it could have really flipped for her. When you cross-examine an alleged victim, an alleged survivor, an alleged domestic violence or sexual assault victim, it's a tricky conversation because you don't want to come off overly combative. You want to be sensitive, but also at the same time you need to make your points. She was combative, though. I mean, she really controlled Amber Heard from going off on tangents, and she did it in a way where, I mean, the majority of people I speak to say she came off fantastic. Now, there were some people who thought that she seemed a little bullish. She came off a little bit of a bully. How do you view it?
I agree with you, Jesse. I think that she did an excellent job. And I think what Camille did best was she read the person that she was on, that was on the witness stand, Amber. Because of Amber's temperament and how Amber came across, that Camille was able to negotiate her questions or navigate in such a way that it didn't come off as intimidating to Amber, to the jury and to the court of public opinion, because she met Amber where she was. Amber was very aggressive and very combative. And so I think that it was equal. It didn't come off as Camille being condescending or taking advantage of Amber. It was the energy that Amber put off so that it allowed for that. I think that that Camille is an awesome trial attorney, and she would adjust her demeanor depending on who was on the witness stand. And so she was a match with Amber. She didn't come off as condescending, so she was able to read Amber on the witness stand and adjust her tone and delivery accordingly. And she did an awesome job of that.
Yeah. All right. We're going to take a break. When we come back, we have words from Dan Abrams, the founder of Law&Crime, on the payout and the damages in this case. We'll be back. All right, welcome back, everybody. So much to break down in the verdict of Johnny Depp versus Amber Heard, a defamation trial that we covered for 6 weeks here on the network. It ended with Johnny Depp winning each one of his defamation claims against Amber Heard. Amber Heard only winning one of her counterclaims against Johnny Depp. Jury awarded him they originally awarded him $10 million in compensatory damages, $5 million in punitive damages. That number was actually reduced to $350,000 by law. So in total, $10.35 million for him, $2 million payout for Amber Heard. And we have a lot to break down. And really, one of the best people to talk about a potential appeal and damages is the Law&Crime the founder of Law&Crime, Dan Abrams. Now, I'm going to tell you, before we throw to a clip of him, a lot of people were concerned. Dan was not driving a car when he gave this interview. He was in the back seat of a car, so no worries, but take a look.
And remember, people have to remember that when you're appealing primarily the legal rulings, right? So she will appeal some of the testimony that was allowed to come in. She will appeal some of the aspects of the judge's rulings in this case, the pretrial rulings, the ruling itself. She's going to challenge the fact that there was a camera in the courtroom. There's going to be a whole panoply of challenges that she's going to make about how unfair the trial was. And she'll also seek to reduce damages, right? In any appeal, the first thing you want to do, in addition to try and get a new trial, get it thrown out, is to try to reduce the damages and say that the jury made mistakes in how it assessed damages. I think that's her most likely chance of success here. But, that's not going to be the win for her. I mean, this to me is just, it's basically an all-out win for Johnny Depp. And I do think that this gets him exactly what he wanted here, which is, I don't think he cares about the money, whether he ends up getting the money. She probably doesn't have that kind of money. This is vindication for Johnny Depp. A jury has said that he was defamed by these comments. And that means that these jurors believe that he was not a domestic abuser. And I think that allows him to get back his career in many ways. You could argue there were other reasons he'd lost much of his career. But this is a massive win for Johnny Depp, and I don't think it can be underestimated. But we'll see. Look, there's going to be a lot of appeals. We're a long way from the final judgment being issued in this case, and Johnny Depp pursuing the damages against her. Well, let's see what happens there before we say that Amber Heard is going to have to declare bankruptcy. Which is potentially something that could happen in the end if she owed this kind of money and simply can't pay it. She could also try and raise money through donations, etc., from other people based on the reaction to this trial. I'm not sure that would be particularly successful. But, I think we're a little ways away from knowing exactly how much she's going to have to pay and how she's going to get that money.
So, Kesia, do you think she's ultimately going to have to pay the full amount of $10.35 million, or do you see a scenario where it could be much less? And where is she going to get this money?
Well, it depends. I mean, she may ultimately have to file for bankruptcy if she's not getting any more acting deals and just really, truly cannot repay this amount. Or just like Mr. Abrams said, we may be far away because there may be appeals down the road. So we don't know, but ultimately, if she wants to put this to rest and move on with her life, she must pay that judgment if there is no appealable issue.
Let me ask you this, Karen. Is there a possibility that Johnny Depp could waive it and say, kind of like what Dan was saying, it's not so much about the money. He got his reputation back, his credibility, hopefully his career. That's what he's looking for. And at the end of the day, say, I'll waive this. I'm not going to seek the money, Amber, but you can't fight this anymore. Don't fight it.
I believe that would be a great PR move on his part, and I'm sure that his legal team is going to advise him what is the best way to proceed. But I think that in order to continue to rise in the court of public opinion, that would be a nice token to extend to her, because as he indicated and his counsel indicated during a cross-examination, during closing arguments, that it's not about the money. So as you indicated, and Kesia, and of course Danny Abrams indicated, he's won. And so to put himself in a position where he can possibly do Pirates or something along that level again, or that caliber, it would behoove him, I think, to extend this olive branch to Amber and her team.
Maybe that's what'll happen. We'll wait and see. There's more to this saga than we're going to see right now. Karen, Casey, appreciate it. Stay with us here on Law and Crime. We'll be right back. welcome back to the Morning Docket, everybody. I'm Jesse Weber, and thanks for joining us. So we have a lot that we're talking about here on the network. We're talking about two new brand new trials that we're going to be focusing on. They're going to be in jury selection. As soon as we have a live feed, we'll make sure to let you know. It might not happen today, it might happen tomorrow, but we are keeping a careful eye on both of them. I also do want to let you know that there was an update in the Ryan Duke trial that we've been following here on Law and Crime as well. Ryan Duke, in the trial that we covered here on Law and Crime, was found not guilty of the murder of Tara Grinstead in Irwin County, but has just been brought up on significant new charges in Ben Hill County regarding tampering with evidence and concealment charges. Bo Dukes, his co-defendant, has also been brought up charges in Ben Hill. This is where it's alleged that Ryan and Bo burned the body of Tara Grinstead. It'll be very interesting how they move forward with the prosecution of that case, given the fact that he was found not guilty of the murder of Tara Grinstead in Irwin County. And we are also, of course, talking about the verdict in the Johnny Depp Amber Heard defamation lawsuit. It was a monumental case, a monumental decision that we've been following for 6 weeks, where Johnny Depp sued his ex-wife for $50 million, claiming that she defamed him in a 2018 Washington Post op-ed piece, implying that he was a domestic abuser. She countersued him, saying that he defamed her through the statements of his attorney, Adam Waldman, calling her accusations a hoax and fake and staged. Well, we heard the verdict in real time. We all watched it. 3.5 million people watched it live on Law and Crime's YouTube page. Here was the verdict.
As against Amber Heard, we, the jury, award compensatory damages in the amount of $10 million. As against Amber Heard, we, the jury, award punitive damages in the amount of $5 million. 1. As to this statement, appearing in the April 8, 2020 online edition of the Daily Mail, quote, Amber Heard and her friends in the media use fake sexual violence allegations as both a sword and shield, depending on their needs. They have selected some of her sexual violence hoax facts as the sword, inflicting them on the public and Mr. Depp. Do you find that Ms. Heard has proven all the elements of defamation? Answer, no. 2. As to this statement appearing in the April 27, 2020 online edition of the Daily Mail, quote, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt did not do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911, end quote. Do you find that Ms. Heard has proven all the elements of defamation? Answer, yes. Has Ms. Heard proven by a greater weight of the evidence that, question, Mr. Waldman, while acting as an agent for Mr. Depp, made or published the statement? Answer, yes. Question, the statement was about Ms. Heard? Answer, yes. Question, the statement was seen by someone other than Ms. Heard? Answer, yes. Question, the statement was false? Answer, yes. Do you find that Ms. Heard has proven, by clear and convincing evidence, that the statement by Mr. Waldman was made with actual malice? Answer, yes. 3. As to this statement, appearing in the April 27, 2020 online edition of the Daily Mail, quote, we've reached the beginning of the end of Ms. Heard's abuse hoax against Johnny Depp, end quote. Do you find that Ms. Heard has proven all the elements of defamation? Answer, no. As against John C. Depp II, we, the jury, award compensatory damages in the amount of $2 million. As against John C. Depp II, we, the jury, award punitive damages in the amount of $0.
All right, so we're going to talk about this. Just want to give everybody a heads up. We are going to talk a little bit more celebrities later on in the hour. There is an update with Mariah Carey that might surprise you. But again, we'll focus on that a little bit later. Right now, I'm joined by my incredible guests, criminal appeals lawyer Matthew Barhoma and also former federal prosecutor Simon Gogish. It's great to have you both here. Matthew, I will start with you. I don't think we've had an opportunity to talk about the verdict. Your reaction?
Yeah, I was shocked. I mean, I was glued to the TV just like everyone was. I watched every day of trial and I was absolutely shocked. But what really stood out to me is how this jury actually came to this verdict. They found for Johnny on specific categories. They gave him punitives. They found for Amber on her counterclaim, and it almost felt like it was incidental, but people forget about it. I mean, we just televised it here, and people forget that she actually was awarded $2 million in her claim. Now it's offset by the $12 million that he's been awarded, but ultimately, all in all, I was really shook by this outcome, and I also, I think that they came to the right verdict because they deliberated and they came to a very specific kind of verdict.
Simon, the aftermath of this case we've been talking about all this morning. So since the verdict came out, an editor's note was put up by the Washington Post on the online version of the Washington Post article, and it says, quote, in 2019, Johnny Depp sued Amber Heard for defamation arising out of this 2018 op-ed. On June 1st, 2022, following a trial in Fairfax County, Virginia Circuit Court, a jury found Heard liable on three counts for the following statements, which Depp claimed were false and defamatory. 1, I spoke up against sexual violence and faced our culture's wrath. That has to change. 2, then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And 3, I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. The jury separately found that Depp, through his lawyer, Adam Wallman, defamed Heard in 1 of the 3 counts in her countersuit. So, Simon, the fact that the Washington Post did this, as opposed to, just taking the article down, because it has illegal material in there, defamatory material, but instead of just keeping it and now putting that note, what do you think about that?
I was really surprised. I found it to be a bit defiant. Ordinarily, when there is a defamatory statement which is published in a newspaper or other periodical, that article is taken down. Those comments are taken down. And one of the things that really struck me by the Washington Post comment is that they're still talking about Johnny Depp's claims. These are no longer claims. A jury has determined that what he has claimed is true. And to have respect for the jury's deliberation process and the outcome of the trial, I think they should have modified their commentary. It probably would have been a better decision for them to take the whole article down. Again, it seemed a little defiant to me.
Matthew, is there a possibility Johnny Depp could go after the Washington Post now?
That's a very good question, Jesse, and I think that the reason they didn't take it down and they put up that notice is that they're pretty content that it'd be very difficult to sue them. Could he bring a claim against them? Absolutely, he has that right. Is he likely to win? I don't know. Freedom of the press is a pretty broad item, and not only that, it's also very high for us to be able to sue an agency like that, as we've seen in the UK trial, even, right? They sued the Sun there and they failed. So I think he's going to go away with this. He's going to walk away with this win, and I think that this notice is probably very sufficient to put all readers on notice that, hey, don't fall for this defamation.
Well, you made a good point, Matthew, and I'm going to bring it up to Simon. How did a judge find him multiple instances of abuse in the UK trial against The Sun, or the publisher of The Sun, and how did a jury find that there was no instances of abuse? I mean, should have been easier for Amber Heard to win this.
Well, look, it is puzzling, and the two outcomes are definitely inconsistent with each other. The evidence that was presented in the United Kingdom before that court was a bit different than the evidence that was presented to the jury in Fairfax. Our systems are similar. They're both common law systems, but nevertheless, the process is a little bit different, and ultimately a jury made the decision here in the United States as opposed to a judge, there being the finder of fact.
And That's why it's so even more puzzling, when I listen, Matthew, to the statements of Elaine Brederhoff saying, or even, let me just rephrase, the statement of Amber Heard after the verdict that we won in the UK. You weren't a party to the suit. I thought that was a bit of an interesting comment. Elaine Brederhoff had said that she wished, and one of the grounds for appeal, it sounds like, is that they wanted evidence from the UK trial into this case, that there was suppression of evidence, that they at least wanted the jury to know that the judge had ruled the way that he did in the UK case. You think that would have changed anything here?
Possibly. I think that this jury had a decision and knew what it wanted. It also went through the facts. But I heard this follow-up comment, the statements after the verdict from Elaine, and I think that she's really laying out her tracks for an appeal. Right? She thinks that there's a lot of judicial, abuse of discretion from the judge over evidentiary issues. I've seen some of the text messages. Some of them indicate that he kicked her in the back. But that kind of testimony already came in. And so even though the text messages themselves weren't introduced, that testimony was still in front of the jury. Now, the fact that the jury knew or didn't know about the UK trial, I don't know if that would have changed the outcome of this case. So I think that the outcome would have been the same nonetheless.
Yeah, so that's a big talking point that we're seeing now because, again, we believe that could be something that is brought up in appeal by Amber Heard's side. We'll focus more on Johnny Depp, Amber Heard a little bit later on in the program. When we come back, let's focus again on the Ryan Duke case and the big developments there. Stay with us.
In the Superior Court of Irwin County, Georgia, In the indictment 2017 CR 027, the State of Georgia versus Ryan Alexander Duke, we the jury find the defendant count 1, malice murder, not guilty. Count 2, felony murder, not guilty. Count 3, felony murder, not guilty. Count 4, aggravated assault, not guilty. Count 5, burglary, not guilty. Count 6, concealing death of another, guilty.
All right, so we have a new development out in Ben Hill County, Georgia, where defendant Ryan Duke will now face another trial. In Irwin County, as we just showed you, Duke was acquitted back in May for the 2005 murder of Georgia beauty queen Tara Grinstead, but he was convicted of concealing her body and is now serving out the rest of his 10-year sentence with 5 years already served. But according to a new indictment released on Friday, Duke will now face another concealment charge, hindering apprehension or punishment of a criminal, 2 counts of concealment of facts, and 2 counts of tampering with evidence in Ben Hill County, all for this case. Now, I'm also going to add that co-defendant Bo Dukes, who was previously convicted of concealment in this case, will also face an additional concealment charge and hindering charge as well in Ben Hill County later this month. But before we chat all about this, I do want to take a look back at Ryan Duke on the stand, which played such a crucial and pivotal role in this trial. Take a look.
That on October 23rd of 2005, you were at the orchard in Ben Hill County, correct?
Yes, ma'am.
And we can agree that on October 23rd of 2005, Tara Grinstead's dead body was in that same orchard.
Yes, ma'am.
And we can agree that you saw her dead body, correct?
Yes, ma'am.
We can agree that you touched her dead body.
After I was told to pick her up.
Yes, you touched her dead
Yes,
body.
ma'am.
Okay. We can agree that you helped move her dead body.
Yes, ma'am.
We can agree that you helped Bo Dukes get the pecan wood to be able to burn her body.
Yes, ma'am.
We can agree that you were in the truck when you drove Tara Grinstead back to the place where she would be burned.
I don't know if that's where he continued to burn her or not. I was only there that one time.
You were only there that time. But you were there because you've already admitted you helped put her lifeless body on top of that fire pit.
Yes, ma'am, I did.
And you don't want to admit to having seen the match struck, but you know that she was set on fire.
Yes, ma'am.
And you knew that on October 23rd of 2005.
Yes, ma'am.
And you knew that on October 24th of 2005.
Yes, ma'am.
And you knew that on October 25th of 2005.
And every day after.
That's right. Every day after. And you never told a soul.
No, ma'am.
So as you're hearing about whether or not Ryan Duke played a role in this murder, the jury also had a question about this. They had a question about venue. Take a listen to this.
It says, can you please clarify this question for the jury regarding number 22, venue, in jury instructions? Please define the term venue as proper and explain how it applies to to count 6, concealing death of another. If you'll exhibit that to the attorneys, please.
All right, so Simon, when you see that, and you see the question that was raised by the jury, they ultimately found him not guilty of murder. They had a question about where this happened, right? And now it's becoming an even more important question because of what's happening in Ben Hill County. What do you make of that?
So this is really interesting. Everyone who is charged with a crime, whether it's state or federal, has a Sixth Amendment right to be charged in the proper venue. As you would expect, some crimes, they occur in multiple venues. So that then raises a question whether or not you have multiple crimes, which would be discrete offenses, or a continuing offense, which may have started in one county and went into another county or even into another state. I've compared the indictments, the first indictment for Ryan Duke and the second indictment, and there are some interesting issues with count 6 of the first indictment and count 1 of the second indictment. I think there's going to be a double jeopardy challenge.
Can you just follow up on that, Simon, what you mean by that? What are the issues?
Absolutely. So you have a Sixth Amendment right to be charged in the proper venue, which the government must prove by preponderance of the evidence and not beyond a reasonable doubt. It's one of the interesting facts of that element. But everyone has the right under the Fifth Amendment to the United States Constitution not to be charged with the same offense twice or punished for the same offense twice. And here, the question is going to be whether or not the elements of the offense in count 6 of the first indictment are identical to the elements of count 1 in the second indictment. That's what we call the Blockberger test. Not to get too law school on you, but under the Blockberger test, it's a Supreme Court case from about 90 years ago. Supreme Court determined that in deciding whether or not someone has been charged with the same offense, you look at the statutory elements of the crime and you compare those two. You don't look at the conduct. It's not just about whether or not he concealed the body, hindered the discovery of evidence of Ms. Grinstead's murder. It's about the elements of those two offenses. And I think this is going to pose an interesting challenge for the prosecution here because there seems to be overlap.
That's a good point. And remember, we're left in a position where nobody has been convicted for the murder of Tara Grinstead. You know, the Ryan Duke put all the fingers and all the emphasis, well, a big portion of it, on Bo Dukes. Well, they even addressed Bo Dukes in their closing argument. Take a look.
Gentlemen, thank you so much for your service over the last 3 weeks. We know what an imposition this has been for you. It's been incredibly hard in your personal lives, I'm sure, and we appreciate your time and attention for taking such good notes. Bo Dukes should be sitting in that chair, not Ryan. Bo Dukes should be on trial for the murder of Tara Grinstead, not Ryan. Where was Bo Dukes in this trial? Why did the state not bring him? Why did we have to call Bo Dukes? Why did Bo Dukes not answer our questions? Be thinking about this as we talk about this case, because there's an important theme here. Ryan took the stand and sat in that chair and told you what he knew. He told you what happened. He didn't have to do that. He could have remained silent and sat over there this entire trial and not told you his story. And you saw him sit there and tell you that story from his own mouth, with his own words, with his own emotion, and you saw how it affected him when he talked. Don't forget that when the state gets up here and tries to tell you that he's a liar. You saw him. You can tell whether he's telling the truth from that chair or not. Keep that in mind as we go through the evidence in the case, because I think it's very important when we talk about his statement that he gave to the police, which you all have heard a lot about. There are a whole bunch of inconsistencies in that thing. And what did the witness yesterday, Mr. Posey, tell us? It was all over the place. Why was it all over the place? Because he wasn't there. He has no idea what the facts are surrounding her death because he was not there. He told you who was there. Bo Dukes woke him up and said, I killed Tara. Not, I killed Miss Grinstead. I killed Tara. Bo Dukes had her as, Bo Dukes was one of her students. Brian was not. Bo Dukes left that trailer that night with Ben McMahon in a black truck at around 10 o'clock at night. Ryan was passed out on the floor. You heard from Jerry, famous Jerry now, I assume, picked him up by the belt and dropped him on the floor to make sure he was alive. And he groaned, and that's the last time anybody saw Ryan that night, passed out on the bathroom floor.
Matthew, we watched this trial. We saw Tara Grinstead's family in that courtroom. There is nobody who has been convicted of her murder now. And that's the reality where we're left with because of everything that happened, the legal wranglings of this case. So the most that the family is going to get, and the loved ones of Tara Grinstead, seems to be these concealment charges, the hindering charges, the tampering with evidence charges. Does that feel like justice to you?
Yeah, it feels unjust, that's for sure. But if anyone feels upset in some kind of way, that should be placed on the prosecution in this office, in this case. And the reason is they brought the wrong kind of charges against the wrong kind of people. They never brought a homicide charge against Bo Dukes, where they should have. Not only that, they were very certain in these claims. They brought these allegations. They had a confession, right? And I think that to some extent they really thought they were going to get a conviction. And it goes to show you that just because there's a confession doesn't mean that the outcome is going to be, a slam dunk. And so really, while it does feel a little unjust, each of these parties, one, they have a Fifth Amendment right. They don't have to say anything. But two, the burden is on the prosecution to prove beyond a reasonable doubt. And they are obligated. They're the master of the complaint. They have to bring the right kind of charges against the right individuals. And if you fail to do that, it will be unjust. There will be an unjust outcome, which is what I think is happening in this case.
Simon, I'll give you a chance to respond to that of any faults in the prosecution here, but also walk me through the upcoming trial in Ben Hill, if this actually goes through. These charges that he's facing, could you have a situation where if he's found guilty across the board, you might have a judge come back and say, you know what, I'm going to give him the max on everything, and that's my way of saying this is justice?
Let's start there. I think that's definitely the prosecution's plan here. I mean, these offenses carry substantial penalties, and it is generally within the discretion of the court whether or not to run those sentences concurrently or consecutively. And what I mean by consecutively is stacking them on top of each other, so that Ryan Duke, even though he was acquitted of murder, if he is convicted of, let's just say, counts 2 through 6 of the new indictment, he might spend the rest of his life in prison. So that's the first observation. The second is this trial shows it's a good demonstration of why we have obstruction offenses. When a person is murdered and their body is burned to ash or to dust, it is virtually impossible. In fact, it is probably impossible to determine how this person died, when this person died, where this person died. Those those facts need to be established generally to prove that someone committed homicide. But when someone moves a body, buries it, disposes of it, that prevents the prosecution from doing its job of proving the actual homicide. And that's why we have these obstruction statutes. So I think it's definitely appropriate to go after Mr. Duke for it, but there are definitely going to be challenges in this case, especially as I stated earlier, with respect to count 1.
Let me tell you a challenge that I'm concerned about here, Matthew, and that challenge is, how is this jury not going to know about what happened in Irwin County? I mean, is this jury going to be exposed to the fact that he was found not guilty of Tara Grinstead's murder? And if they're not, how does the prosecution address that in an opening statement, that Tara Grinstead got killed, but they were involved in it but not involved in it? I mean, it feels odd to me.
Yeah, absolutely. And we do our fair share of instructing the jury and letting them know, don't do your independent research and things of the sort. And I'm sure voir dire is going to be a very difficult process there. But honestly, if they do know, it might actually be good. Not in the sense that they're just going to come to a verdict, but in reality, they might be taking the totality of the circumstances a little bit differently. Now, they're not supposed to. They're not supposed to bring any independent knowledge to the deliberation room. If anything, it's kind of a closed universe, and that's why we have the evidence code. But ultimately, I think that it may play a factor in trying to get a conviction, and if so, probably getting maximum sentencing.
All right, well, we're going to talk more about the Duke case later on in the program today, but right now we're going to take a break. When we come back, we're going to switch gears. Anjanette Levy did an interview with the court stenographer in the Johnny Depp Amber Heard trial, and this is a person who's actually been receiving some backlash. The allegation being, was she biased to Johnny Depp, and was she partying with him after the verdict? We'll explain it on the other side. Okay, welcome back, everybody. We're talking about the Johnny Depp Amber Heard verdict, where the jury came back and found Amber Heard liable to Johnny Depp on each one of the statements, the 3 statements of issue in the Washington Post op-ed piece. Amber Heard only winning on one of her counterclaims. The jury awarding $10.5 million. Excuse me. Let me rephrase that. They originally awarded $10 million in compensatory damages, $5 million in punitive damages. That punitive damages award was reduced by law to $350,000. So basically, he's awarded $10.35 million. Amber Heard awarded $2 million. Whether or not that will actually be paid out is kind of a separate question. And we're still talking about the aftermath of this. We talked earlier about how the Washington Post now put an editorial note on the actual op-ed piece. We've been talking about the fan reactions, the attorney reactions, things like that. But then there was the court stenographer, Judy Bellinger, who I would say over the weekend, over the past week, has kind of entered into a little bit of controversial territory, because there was this video that was posted of her seemingly hugging Johnny Depp and kind of celebrating with Johnny Depp. People were wondering, was this after the verdict? Was she biased towards him? Well, our very own Anjanette Levy had an opportunity to sit down with Judy, and here's what she said.
So after closing arguments, I finally decided I wanted to get out of the courthouse and just take a breather. We were supposed to go until about 5:30, maybe 6 if the jury wanted to. And so I thought, I want to maybe try to go to Indiana this weekend. Let me run down the street and get my oil changed, and I'll come back and go back up. The courthouse closes at a certain time, and I didn't make it back in time. And Judge Ascarati just wanted to close the record. And I'm like, oh yeah, well, I'm stuck outside. I'm getting my oil changed. And she goes, oh, it's okay. Well, she didn't say it. I was getting messages. And I said, okay, just don't worry. My recording's going. It's just closing the record. I'll, transcribe it when I get back. But then I needed my equipment. So Mr. Chu and it was Rebecca. I think they were the ones that were there, and they were kind enough to pack up my computer for me in my backpack, because that's all I needed. I leave my machine there because it's just quicker to come in and just set up my computer and not have to set everything up every day all over. So they were kind enough. They said, okay, if you tell us how to, disconnect everything, we'll bring it to you, because we have an office right around the corner from where we are now, and this is where they were staying. And I said, hey, I have an office on Greensboro. I can meet you there and get my equipment, and I can get the transcript out this weekend. So they're like, okay. And then I guess Johnny had told them he would really like to meet the court reporter, which was like shocking to me. I'm like, I'm just the court reporter. And so when they brought me my equipment, well, they were going to bring it, and there was no one at our Greensboro office, and you can't get in if there's no one there. So
and it's Memorial Day weekend.
Right. So
it's a holiday weekend.
Yes. So they just brought it back to the hotel, and they said, hey, do you mind if we just take it to the hotel and you can pick it up here? And actually, it took me a minute. I didn't know how to get up here. I didn't know you had to come in the downstairs door and then go to another floor and then get to another floor.
It's a little confusing.
It is very confusing. And so they had my computer and stuff with them, and they were in the hospitality room, and Johnny was in there. And so I had to go in there and get my equipment, and I saw him, and they're like, he really wants to meet you. And I was in there for probably less than 10 minutes, and he just hugged me and thanked me again, and I hugged a couple other people there, and I got my equipment, and I came out, and I left and went home.
That's really funny, because a lot of people are suggesting you're just out at the after party hanging out, with Johnny Depp, and that's not what happened.
Not at all. I still had from here, I had about a 50-minute drive home, so no, that didn't happen.
He gave you a hug.
Yes.
You picked up your stuff and you left.
Yes. But it was a moment that I'll never forget.
And you've got video to support it. Have the grandkids seen that video?
No, not that I know of.
All right, Simon, did she do anything wrong? We should set the record straight right now.
Judy. This was not good judgment. Did she do anything wrong? No. Was it good judgment? No. Optics matter, and the optics here are not good. She's a freelance court reporter. I get that. He's technically not a part of the court staff, but you don't want to give anyone the impression that you're aligned with one side or the other. And showing up to this after party, this soiree, whatever you want to call it, was not a good idea. And frankly, the attorneys who took her equipment, no doubt, were trying to be helpful, but this is also the type of decision that gets made when someone is enjoying their triumph and they're on cloud nine and they're not really thinking clearly about how this might look. And so I think it was just bad decision making all around.
Well, Matt, now it becomes a question with Amber Heard. Does your side use this as a grounds for an appeal and say, listen, we now have to go through her entire record. We got to go through her entire transcript and see if she, I mean, it's a conspiracy theory, I'm just saying, but like, does this now taint anything in her performance during the course of the trial? I mean, could this be grounds and say, man, even somebody in the actual courtroom was biased towards Johnny Depp? Is this any way that it could be used by Amber Heard's side to benefit her appeal?
You know, it's possible. I would hope that they focus on other issues, especially evidentiary issues, which I know they feel strongly about. Now, with that being said, what are we really worried about? It's this ex parte communication. And not only that, but in a civil setting, the transcriber, it actually plays a very big role, okay, surprisingly or not. Their words are, we rely on them as fact. Actually, if there is a discrepancy,
let me just clarify something that I didn't mention before, is that her transcript isn't the official court record. It was only used for both sides to review transcripts at night, but still an important role nonetheless. Matthew, I'll give it back to you.
Even better, Jesse, even better. That's a very good point to make. And not only that, if both sides are relying on it and there's something in there that maybe could be a little favorable to Johnny, like skipping a line or passing over a word that maybe was, you know, not very favorable. Now, I don't think that's taken place, okay? I really do genuinely think this is incidental human behavior. This is them being good to each other. The only big problem I really see with it, I have with it, is that every single time throughout this trial, this transcriber was very favorable to Johnny. She'd look over at him, she'd smile. He'd crack jokes with her. He would, you know, engage in that, and that's what he's supposed to do as a litigant, right? He's plaintiff here. He should be nice to everyone. And so, you know, does it walk a line? Sure. Is it a problem? I really don't think so. I think this is all water under the bridge.
Okay, so aside from the role that she had, you know, inside and outside the courtroom, she also did provide really great perspective on what her view was of the jurors and watching the reactions, including of the juror who was excused because they were an alternate. Now, by the way, just to let you know, this video of Anjanette interviewing Judy is up on YouTube and has over 1 million views, I believe, the last time I checked. So please, you can watch the whole thing in your entirety if you want to check it up there. But let's just go back and we'll hear a little bit more from Judy.
I remember the jury was very intent. They were listening very intently. And unfortunately, when the jury was chosen, we knew that there were going to be some that would not see it all the way through, that there were alternates. We knew who the alternates were from the start because they just picked the names randomly. But I could not remember the numbers, and there was, unfortunately, the one alternate that was on there. She was probably the one that listened the most. I watched her facial expression. She was very deeply into every word that was being said, and I thought she would have made a great juror, and she did not get to see it. She just took her hand and go, and I was like, oh man, she was going to be the best juror. I really thought she was the best juror.
Interesting, and it was because she was paying so close.
She was paying close attention. You know, there were a few jurors that were dozing off.
Really?
She never dozed off.
Were the jurors who were dozing off, were they in the back row, front row, both?
Both. And it was tough because there was a lot of video deposition. And, you know, they would just sit there and all of a sudden I'd see their head drop. But never her.
Simon, if that is true, that is alarming. You know, I was in the courtroom, but, you know, I wasn't in there every day like Judy and didn't have as great a view as Judy, but I saw them pretty attentive. I never saw them falling asleep, but if they were, and in her opinion, the best juror was not selected, what do you think about that?
Well, first of all, I don't want to scare our viewers, but a dozing juror is pretty commonplace, especially when it comes.
What do you mean, Simon? You saying DNA testimony is not just enthralling? Oh my goodness.
I mean, think about it. You're sitting in a chair, looking in one direction. The courtroom sometimes is dimly lit because they're showing photographs and videos. I mean, people naturally start to doze when they're watching a PowerPoint being put on by their colleague. Same rule applies here with jurors. What you have to do is you have to give them plenty of breaks so that they can wake up. And I've had a number of trials where the judge was all but feeding the jurors caffeine just to make sure that they stayed awake. But these alternates, I have to say, I always felt terrible when they were released at the end of trial because many of them get really invested in the trial and in the evidence, especially when the trial lasts weeks on end. It's kind of like labor without the birth. And so for the alternates, I definitely feel bad for them, but you know what Judy was describing is not uncommon.
Well, focusing on the jurors for a second here, Matthew, there was a bigger issue at play here, and that is that Elaine Bredehoff, after the verdict, Amber Heard's attorney, did some of the media tour, and basically what she was saying is how could these jurors have not been affected by the media attention, by what was happening outside of court? That clearly is going to be a grounds for them to try to appeal. I just find that to be a bit speculative at this point, and a bit of an assumption that automatically the jury was tainted. That's the reason why they came back the way that they did. What do you think about that?
100%. I agree with you. And not only that, but you know, on an even bigger point, which is that bringing up appellate issues regarding jury issues is actually a pretty high bar. Okay, it's not easy at all. But you're right; it's very speculative, and we did everything we can. She even admitted it in that very statement, right? Which is that they were instructed not to look at the media. They were instructed not to discuss the case. They were instructed to maintain all the things that we need a jury to do. But we oftentimes talk about a jury like they're robotic. Like they're not human, like they're not curious, like they don't have family they're going to discuss this with. And that's going to happen incidentally. And any appellate court reviewing that, I mean, unless you have something very tangible, I mean, like a tweet, a text message from one of these juries clearly discussing, clearly doing something like that, they're not even going to review it. It's going to be harmless error. So all in all, I think that jury issues, from what I've seen and from what I've perceived, very speculative, very argumentative, very high bar to bring up to the appellate court.
Speaking of the appeal, and by the way, they could always do an interview and they could mistakenly say something like they were influenced or saw something that they hadn't seen. We've seen cases like that before. But Simon, outside of the jury issue, was there anything that stood out to you as possibly a successful grounds for an appeal? You know, Elaine Bredehoff also mentioned the fact that there were elements of the UK trial that weren't introduced in this case. She talked about the suppression of evidence. You know, you can talk about anything from improper rulings with the judge to maybe problems with the jury form, jury instructions. Was there anything that stood out to you?
There really wasn't. I mean, the court has an amazing amount of discretion in terms of what evidence she would allow in or she would exclude. Most evidentiary decisions are on abuse of discretion standard, which is a really high bar. And oftentimes, appellate courts don't like to overturn or second guess, rather, a trial judge's determination about what evidence should come in or shouldn't, because they're there. They're at ground zero where the evidence is being presented. They have the best perspective in that regard. There are times where decisions get made and they're bad ones. And oftentimes, in my experience, the appellate court finds a way to render that mistake harmless error. And that's, I think, like every appellate attorney's worst nightmare. They do all this work, they prove an error occurred, but it's only harmless. Finding reversible error can be a real challenge.
It's a challenge. Doesn't mean it can't be successful. It doesn't mean it won't be argued by Amber Heard's side. All right, gentlemen, stand by. When we come back, we're moving from one set of celebrities to another major celebrity. Mariah Carey now has a legal issue at stake. We'll be back. Welcome back, everybody. So the main celebrities at the forefront of the legal world have been Johnny Depp and Amber Heard. But a new celebrity has now landed in the hot seat. Pop singer Mariah Carey and her co-writer Walter Afanasieff and Sony Music Entertainment are being sued for at least $20 million in damages for the hit 90s holiday song that everyone loves, All I Want for Christmas Is You. No, I'm not singing it. That would just do a disservice to Mariah Carey and everybody else. But Andy Stone from the country pop band Vince Van and the Valiants is suing for copyright infringement, among other claims. He claims to have written the song with the same title 5 years earlier. Carey and Sony have yet to comment on the lawsuit, but that doesn't stop us from talking all about it. So, Simon, okay, now we have a situation here where I'm surprised. The first thing that stands out to me is this song came out, in 1994? He's coming out with this lawsuit now? How do you justify that?
I need to make a disclosure here. I own the Christmas album, and my wife loves All I Want for Christmas.
Who doesn't?
So there might be some bias there. But I have to tell you, I love this lawsuit. This is like Christmas in June. It is extremely entertaining. You ask a great question. I mean, Mr. Vance or Mr. Stone, he wrote this song in 1989. She wrote hers in 1994. And the interesting thing is that this is not about infringing the actual song. This is about the title of the song, which makes it pretty unusual. And for anyone who has Spotify or Apple Music, you can type in your favorite song and it might pop up 5 or 6 titles, but they're different songs. Now, I'm not saying that there's no claim here to infringing on someone else's title, but if you listen to both those songs, there's no similarity between them whatsoever. And I would actually highly recommend watching the video of Andy Stone's All I Want for Christmas. That in and of itself is a Christmas gift. It's the best of the 1980s, shoulder pads, sad haircut.
Well,
it's exceptional.
You know, we got Top Gun coming back, and it's great, and, you know, the 80s are in the forefront again. So, Matthew, you know, they're different lyrics, they're different melodies. He's suing for $20 million in damages. The likelihood that this gets past a judge, the likelihood that this moves forward, or will it end with a motion to dismiss?
Yeah, I would bring a motion to dismiss this case because it's time barred, okay? On most intentional conduct, there's a statute of limitations. It's pretty short. On negligent conduct, it could be a little bit longer, right? But here, I mean, it's been 30 years or so, right? Where's your claim been, Mr. Stone, for the last 30 years, right? That's a big question that a judge or any court is going to ask. You know, in this case, why haven't you brought it? When did you discover it? And why is it that you're only bringing it now? And ultimately, I think that for it to even get to a jury selection or possibly a bench trial, it's probably going to deal with a lot of discovery issues and a lot of various procedural issues that may never even get at that.
You know, one of the most fascinating aspects of these kinds of cases is also, you know, they'll say, how did Mariah Carey learn about you guys? You know, how did someone from her team learn about your song first? And you kind of learn a little bit who had access to what. So, I mean, these copyright cases or the trademark cases I always find to be fascinating, particularly when you're dealing with such a well-known song and a popular song that Simon loves and is probably going to listen to right after this. So we'll see which way it goes. Simon, Matthew, thank you both so much for coming on. Appreciate it. Michelle Yu is up next. Stay with us here on Law and Crime. We'll be right back.
will not be sequestered.
I'm Brian Buckmeyer, along with Terry Austin.
In the Weinstein case, fellow silence breakers, and any
Selection is moving along
When
here.
I'll read the verdict, says the Jesse Weber. Thanks for joining. We don't tend to see it as raw as this. Good evening and welcome.
Hi everyone, I'm Michelle Yu and welcome to For the Record. Thanks so much for being with us. Before we jump into recaps, I want to fill you in on two new trials that are starting up this week, starting with Florida versus Danielle Redlick. Redlick is charged with second-degree murder and tampering with evidence in the death of her husband. We plan on taking this live on the network as soon as the jury is selected. Then we will have more for you out of Florida once jury selection concludes for Alan Wade and Michael Jackson. The duo is facing a new sentencing for the robbery, kidnapping, and murder of James and Carol Sumner back in 2005. Previously sentenced to death, their sentences were later thrown out after new state legislature passed in 2017 requiring a unanimous decision for the death penalty in Florida. We also have a new development out in Ben Hill County, Georgia, where defendant Ryan Duke will now face another trial. Last month in Irwin County, Duke was acquitted for the 2005 murder of Georgia beauty queen Tara Grinstead and convicted on concealment charges. According to a new indictment released on Friday, Duke will face another concealment charge hindering apprehension or punishment of a criminal, 2 counts of concealment of facts, and 2 counts of tampering with evidence in Ben Hill County for the same case. Bo Dukes, who was also convicted of concealment charges in this case, will also face an additional concealment charge and hindering apprehension or punishment of a criminal in Ben Hill County later this month. We'll get to that later on in the show, but right now I want to talk about some new developments in the Johnny Depp Amber Heard saga. Last Wednesday, Depp won his defamation lawsuit against his ex-wife Amber Heard, who wrote a 2018 op-ed in the Washington Post, dubbing herself a domestic abuse survivor. Heard also walked away with a monetary award after the jury found one of her countersuit claims against Depp to be defamatory. To see just how much money each side will walk away with, let's go to the award portion of this verdict.
As against Amber Heard, we, the jury, award compensatory damages in the amount of $10 million. As against Amber Heard, we, the jury, award punitive damages in the amount of $5 million. 3. As to this statement appearing in the April 27, 2020 online edition of the Daily Mail, quote, "We've reached the beginning of the end of Miss Heard's abuse hoax against Johnny Depp," end quote. Do you find that Ms. Heard has proven all the elements of defamation? Answer, no. As against John C. Depp II, we, the jury, award compensatory damages in the amount of $2 million. As against John C. Depp II, we, the jury, award punitive damages in the amount of $0.
All right, joining me now to discuss all our trial topics is attorney Sharina Anki-Krall with me this afternoon. Thank you for joining me. Sharina, the Washington Post put a disclaimer at the bottom of Amber Heard's 2018 op-ed recently. Was this the right move?
The disclaimer really didn't do much because I feel like the people that read the story knew exactly who she was referring to. And it certainly didn't help her during the trial because I'm sure everyone watching now has also watched at least portions of the trial. So did we know that the article was talking about Johnny Depp, or did we actually think that it was about some unknown party? That was a big question throughout the trial. So in my opinion, as long as we were that clear on who the op-ed was about, the disclaimer didn't really do much.
Do you think a retraction is in order?
At this point, after the jury has already given its verdict, I don't know what a retraction would potentially do, or if it would even mend some of the injury, the mental and emotional injury that was involved in this case, if it would even mend any of that. So even if they do have a retraction, I mean, really, what is that going to accomplish at this point? The jury has already given its verdict. Maybe if it was done before the lawsuit, it could have done some good, but I don't see how it's going to make a difference right now.
How do you think the jury decided on the monetary awards? Do you think it was a fair amount?
Sure. It was very interesting to see the amounts that the jury came up with. It was almost as if, I'm sorry. I'm sorry. There's a little, so as I was saying, the jury, came up with a very interesting amount, and I still don't know how they exactly came up with the amount, but it was almost as if the jury was telling Amber Heard that they understood that there was some form of something going on from Johnny Depp's side. However, they ultimately decided that Johnny Depp was the victim in this case of domestic abuse. That's really what I can take away from the verdict itself.
Now, the last thing the jury heard from the attorneys in this case before making their decision were the closing arguments. So let's listen to some of them now to see what they had to consider during their deliberations, starting with Johnny Depp's argument by Benjamin Chew and then Amber Heard's closing arguments by Benjamin Rottenborn. Take a look and we'll talk about it after.
While Mr. Depp's name will be forever tarnished by these horrendous and false allegations, this case is about telling you his story and the truth about what really happened, which you've now heard. It is about restoring his lost reputation. It's about showing Mr. Depp's children, Lily Rose and Jack, that the truth is worth fighting for. It is. And it's about restoring Mr. Depp's name and standing in the community to the fullest extent that you can. And you can do something. And only you, ladies and gentlemen, can do that for him. You heard from Mr. Depp yesterday that he has been carrying these outlandish, outrageous stories on his back, pretty stoically, and living with them for 6 years. And waiting to be able to bring his truth out. And he has told you the truth, the unvarnished truth, even truth that pretty embarrassing. He knew that was going to happen when he brought this case. You've seen the evidence in this case over 6 long weeks, which we again thank you for. That evidence shows overwhelmingly that Ms. Heard's attempt to paint herself as a heroic survivor, an innocent survivor, and Mr. Depp as a terrifying abuser are utterly false. We ask you to please return your verdict for Mr. Depp. We ask you, we implore you to give him his name, his reputation, and his career back. Thank you very much, ladies and gentlemen.
In trying to convince you that Mr. Depp has carried his burden of proof in proving that he was never abusive to Amber on even one occasion, think about the message that Mr. Depp and his attorneys are sending to Amber, and by extension to every victim of domestic abuse everywhere. If you didn't take pictures, it didn't happen. If you did take pictures, they're fake. If you didn't tell your friends, you're lying. And if you did tell your friends, they're part of the hoax. If you didn't seek medical treatment, you weren't injured. If you did seek medical treatment, you're crazy. If you do everything that you can to help your spouse, the person that you love, rid himself of the crushing drug and alcohol abuse that spins him into an abusive, rage-filled monster, you're a nag. And if you finally decide that enough is enough, you've had enough of the fear, enough of the pain, and you have to leave to save yourself, you're a gold digger. That is the message that Mr. Depp is asking you to send. But he doesn't stop there, because in Mr. Depp's world, you don't leave Mr. Depp. And if you do, he will start a campaign of global humiliation against you, a smear campaign that lasts to this very day. He will do everything he can to destroy your life, to destroy your career. That is what they're saying, ladies and gentlemen.
And with that, we also have Marie Pereira, criminal defense attorney, former prosecutor, joining us as well. Marie, Johnny Depp's angle was to let the truth prevail. Do you think this is what led him to victory in the end?
Absolutely. He humanized himself. He put out all the dirt on himself. He admitted he was an addict, an alcoholic, and he was the most dangerous person to his own physical safety. And for that, they believed him. That's what happens when you tell the truth, as opposed to Amber, who tried to make herself look like a saint, and it blew up all over her.
And Sharina, on the flip side, why do you think that Amber Heard's angle of calling Johnny Depp a liar did not work out for her?
I think the story has to be left up to the jury to decide, right? The ultimate storyline that people are going to decide what should be left up to them. Each of their individual goals should have been to just present the facts as they thought would benefit them, and not necessarily to make themselves out to look like saints or devil, but just to really put the facts out there and let the jury just determine what it is that they really truly believe in. In Amber's case, she was so into just proving her innocence that I think she lost a lot of trust and credibility in the eyes of the jury.
And Johnny Depp's attorney, by the way, other attorney Camille Vasquez, is coming out to be the true star in this trial. She's becoming quite famous. In fact, over the weekend, we've heard she's already getting a lot of offers from a lot of different law firms. Some want to make her a partner now. Marie, are you surprised at how her stardom has just skyrocketed and become so high?
I'm not surprised at all. She fit the look. She's a beautiful woman. She's intelligent, and she's just really presenting herself very well. I'm not surprised that this is basically the most consequential case in her career, and it's her pop-out role. Camille is going places. She may even get a judge show.
A judge show, that's certainly something that would be really interesting. A lot of people I know would watch her for that. All right, thank you so much, ladies, for that great analysis. We have so much more to come. We're going to take a quick break here on Law and Crime, but stay tuned for more Johnny Depp, Amber Heard coverage on the other side. Stay with us. Welcome to For the Record. I'm Michelle Yu. You're watching the Law and Crime Trial Network. We're continuing our review of the Johnny Depp Amber Heard defamation case today, where a verdict came on Wednesday afternoon. As a refresher, Johnny Depp sued his ex-wife for $50 million over her 2018 op-ed in the Washington Post, dubbing herself a domestic abuse survivor. Depp claimed he was the real victim of domestic abuse, and her defamatory article cost him his reputation and several acting roles. Amber Heard countered-sued Depp for $100 million, arguing Depp and his attorney coordinated a smear campaign following the op-ed. The jury had to consider 3 statements made by Amber Heard in her op-ed and 3 statements made by Adam Waldman, Depp's attorney, after its publication. The jury out of Virginia found each of Amber Heard's 3 statements in question defamatory towards Depp and awarded him a total of $10 million. As for the 3 Adam Waldman statements, the jury found one of them to be defamatory towards Heard and awarded her a total of $2 million. Let's take a look back at how Johnny Depp did on the stand. Here's a clip of him describing an altercation he had with Amber Heard.
What happened at the end of that situation?
Because of the grabbing of the arms and holding them to her side so that I didn't receive any more blows, and she was still fighting, I believe there was some kind of contact with our heads, our foreheads, as would happen if you're trying to calm someone like that. And then that was when she accused me of headbutting her, of giving her a headbutt and breaking her nose. But there was no blood. There was no, I didn't hit her nose. If there was anything at all, it was a bump of, well, I'm trying to restrain her. She's trying to get out of it. There's going to be some contact here and there, accidental contact, but not a headbutt.
How did you escape this altercation?
After she'd made the remark about the fact that I headbutted her, which was just impossible, she huffed off. I let her go. She huffed away, and she was gone for about 7 or 8 minutes. And then when she came back, I was in the bedroom of Penthouse 3, our bedroom, and she came back about 7 or 8 minutes later, and she had a Kleenex or a tissue to her nose, and then she pulled it away from her nose and she showed it to me, and there was red. There was indeed like red color on the tissue. But me, I know that there was no connection to her nose. No part of my body made connection to her nose or eyes or anything like. So she said, she took it away and she showed it to me. She said, "Way to go, Johnny, you broke my nose."
So it was obvious that the jury found Johnny Depp to be a more credible witness. Do you agree with them, Sharina?
Absolutely. I watched the entire trial, and everything that Johnny Depp said had some conviction power to it. I don't know if it's just his demeanor. He was calm and collected the entire time. But what really struck me about his testimony in court is the similarity between his tone in court and also in the recordings that Amber Heard presented. in trial, right? So in those recordings, even during their so-called heated moments, he had a very calm voice. It's almost, he was saying things like, I just want to go away, I just want to walk out. And that sort of carried through into the courtroom. So that subconsciously even, I think, helped people to trust him more, to understand what he was saying. Whereas Amber's testimony, on the recordings, it was mostly just combative. She was yelling, arguing most of the time. And in court, she tried to present herself in a completely different light. She tried. I'm not saying that she succeeded. And in court, she was, crying. She was trying to stay calm, but that didn't quite work out. It just, when you compare the two of them, people wanted to see consistency. I believe I did, I think, personally. And Johnny Depp delivered, and everything that he said was believable.
But Marie, how much of Johnny Depp's victory you think had to do with his fame?
It had a lot to do with his fame, but on the stand, he was very credible. Like the clip we just played where he explained that he had to grab her arms to prevent her basically from hurting him. This wasn't an assault case. This wasn't an assault case, but it had a lot to do with assault. And basically, he had to prove she was the aggressor. And any injuries she might have sustained, the bruising, was because he was trying to stop her from hurting him. Now, he proved it because that trumps her accusations of him being an abuser. Truthfulness is the defense, and she didn't quite make it because you can't say that someone attacked you when you're the one attacking them.
Now, here's how Amber Heard remembers the so-called headbutt incident.
I remember at some point trying to flee upstairs, and we had, he got a hold of me and I got free, and I managed to get all the way up the stairs almost. I was on the last flight, and we'd had some interaction where I think I said something to him on the stairs. It might have been broken up, and I think I said something on the stairs, and I just remember how quickly he shot back up those stairs and grabbed me by the back of my hair, my head, and slammed his hand on my head. And I went down on the stairs, and he overtook me. I remember him so well. I remember his boots and the sound they made. I remember him grabbing my hair, my head, and kind of dragging me up the stairs the rest of the way. He dragged me into the room that those stairs open into. It's like a salon foyer area. And we had this argument that kind of, was a shoving match that I was losing. By the second or third shove, he sent me toppling over this chaise lounge, like a little low-lying sofa seat, and I hit my head on the brick wall. There was an exposed brick wall. I remember I stood up, and I remember Johnny asking me if I wanted to go. And he did that thing where he's like challenging me. He said it in that way, challenging me to stand up, get back up. And when I did, he said, "Oh, you really want to go now, tough guy?" Shoved me back down. "Oh, you really want to go, huh? Oh, you're so tough." I stood back up again. This time he hits me in the face. I stand back up and look him right in the eyes. And it was just a really still moment. I'll never forget it. Really still. I stood up and he said, "You want to go again, tough guy?" And I just looked right at him, just looked right at his face. And he balled up his fists, leaned back, and headbutted me square in the nose. Just right as I stood in front of him. I was a foot from him. Just slammed me right in the nose. Instantly, searing pain. It's one of the few memories I have in this long relationship that I actually remember the physical pain in that moment, just searing.
Now, these two accounts are obviously very different from one another, and after almost 13 hours of deliberations, how do you think the jury worked through these stories, Marie?
I think they worked through it by looking at what evidence was presented. Because let's be clear, Johnny Depp made some omissions and embellishments as well. However, hers, like the testimony she just read, says, he hit my head against an exposed brick wall. There was searing pain and he squarely headbutted me. There would have been blood all over the place. She would have been wearing a gown. Where are the pictures of the gown? And I say this because she takes pictures of everything. The jury will be looking for independent, corroborated, unbiased evidence for every accusation. And that's what Amber didn't produce, and that's why they didn't believe her.
And Sharina, do you think that Amber Heard's theatrical answers took away from her credibility, the way she looked at the jury every time she said something?
Absolutely. When I was watching her testimony, it was kind of creepy, for lack of a better word, because she kept staring at the jury so many times. And at one point, it became her just staring at them directly, not even looking away. But here's my take on the testimony you just played. For those of you who have kids, more than one child will understand. It almost sounds like one child trying to place blame on the other, and they can't get their story straight. If you're trying to visualize what she's saying from point A to point B, things just don't line up. It's her walking up the stairs, then there's an exposed brick wall. Then he's balling up his fist, but he's headbutting her. I mean, none of it makes any sense. And this is the type of storytelling that really worked to her disadvantage with the jury, as with so many viewers who have been watching the trial from the beginning.
Yeah, and there was a report that came out a couple of days after the verdict saying that one of the alleged jurors, we don't know if it's true or not, he went on TikTok and he said he was one of the jurors of this trial, and what he found was weird was Amber Heard looking at the jury all the time, and he said that came off weird, and that was one of the reasons they did not believe Amber Heard. So take it for, what you want to take it for, but that's what one of the alleged jurors said. All right, we're going to have to take a quick break here on Law and Crime once again. When we come back, so much more trial coverage to get to. Stay with us. We'll be right back. Welcome back to For the Record. I'm Michelle Yu. We have a new development out in Ben Hill County, Georgia, where defendant Ryan Duke will now face another trial. Last month, Duke was acquitted in Irwin County for the 2005 murder of Georgia beauty queen Tara Grinstead. He was, however, convicted on concealment charges and is currently serving the rest of his 10-year sentence with 5 years already served. According to a new indictment released on Friday, Duke will face another concealment charge hindering apprehension or punishment of a criminal, 2 counts of concealment of facts, and 2 counts of tampering with evidence in Ben Hill County for the same case. Bo Dukes, who was also convicted of concealment charges in this case, will also face an additional concealment charge and hindering apprehension or punishment of a criminal in Ben Hill County later this month. Ryan Duke actually took the stand in the Irwin County trial last month. Let's hear what he had to say about his involvement in the case.
Mr. Duke, did you murder Tara Grinstead?
I did not.
Did you break into her home on October 22nd or 23rd, 2005?
No, sir, I did not.
Have you ever been inside her home at any point in your life?
No, sir, I haven't.
Did you ever have a sexual relationship with Miss Grinstead?
I did not.
Did you ever strike Miss Grinstead?
No, sir, I did not.
Did you ever choke Miss Grinstead?
No, sir, I've never choked anyone.
Have you ever been inside Miss Grinstead's car?
No, sir, I have not.
Did you ever take a pair of gloves or a glove to Miss Grinstead's home?
No, sir, I did not.
Did you see Miss Grinstead's body after she died?
I did.
Where did you see it?
In the pecan orchard.
Did somebody take you to the body?
They did.
Who took you to the body?
Bo Dukes.
Did Bo Dukes tell you that he killed Tara Grinstead?
He did.
Do you know how Miss Grinstead died?
I do not.
Were you asked to help dispose of her body?
I was.
Who asked you to do that?
Bo Dukes.
Did you help Bo Dukes move Miss Grinstead's body in the orchard?
I did.
Were you afraid that he'd hurt you or your family if you told anyone about it?
I was.
Is that why you didn't come forward prior to February of 2017?
Yes, sir.
And before we talk about this, let's hear more about what Ryan Duke had to tell the jury about the incident.
He was upset, shaking almost, just, till something was wrong.
What was he wearing when he woke you up?
Blue jeans, a t-shirt, maybe a sweater.
What did he say to you when he woke you up?
Objection. Your son.
And, Your Honor, this next statement is a statement against interest. And it is, I guess, if you want to go through the analysis. So the declarant's unavailable. Bo is unavailable to testify. We know that he's going to take his Fifth Amendment against the this particular statement.
Having a speaking objection now, which is what defense counsel asked us not to do, so I ask that we discuss that in a minute.
I'm going to sustain that objection at this time.
Thank you.
Bo woke you up, and what happened next?
He woke me up. It's hard to explain without saying what he said, but he said something that freaked me out, and then he went to the living room.
So, Marie, let's bring you in to talk about this. I mean, here we go again. Do you expect the outcome of this trial to be similar to last month's?
It may be. I was shocked that he was acquitted. With the details, the videotape confession, the precise location, the way he described the cremation, which was basically the manual burning of this poor girl's body. Only 4 tiny bones were left. And for the DA to fail to get him on murder charges and only get him on concealment charges was shocking to me. And it hurt me for the family because they dealt with her loss for so long only to go through this and have no closure, so nobody's going to really be blamed for this murder. What? What is this?
Great points there, Marie. Sharina, will Ryan Duke, though, take the stand again in this trial, you think?
I have no idea. There is the question of double jeopardy, right? Because this is the second trial now. I don't really know what's going to happen. This entire case has taken me for a shock. I don't even know how this all came to be and how he was not found guilty in this instance. So I honestly, I wish I had a better answer other than saying I don't know what's going to happen, because all of this has been not the norm, to say the least.
Yeah, closing arguments are the jurors' last chance now to hear from the attorneys before making their decision. Let's listen to what they heard from Ryan Duke's attorney to help guide their decision towards the acquittal he received.
I've written out in my terrible handwriting some questions that I challenge the state to get up here and answer for you, because you deserve to have an answer to these questions. How does the glove corroborate how Ms. Grinstead died? Cause of death, something they have to prove beyond a reasonable doubt. How does the glove corroborate that Ryan caused her death? I asked Agent Chabelle these questions, and he said it doesn't. He said there's no evidence of this. How does the glove corroborate that she died in Irwin County? A glove that did not appear until Monday morning. How does the call corroborate this 411 call? How does it corroborate the cause of death? Remember, the law says his statement has to be corroborated. So they want you to believe that that one statement is the statement that is the Holy Grail, and they have to corroborate it. How does that call corroborate that Ryan is the one that killed Ms. Grinstead? How does it corroborate that she actually even died in Irwin County? What proof beyond a reasonable doubt has the state brought you to prove Ryan's statement to Agent Chabelle was accurate? Because everything you heard from the witness stand was that it was not, that it was a mess. It was all over the place. What evidence has the state brought you to disprove Ryan's sworn testimony in front of you beyond a reasonable doubt? They have to do all this. They have to answer all these questions. And again, I don't get to get back up here. So I leave these questions and challenge the state to try and answer these questions, because everybody deserves, they're asking you to convict a man of murder, and they can't answer these questions. And the law requires that. Some other questions that I couldn't fit on my board. Has one single person come in here to testify that they saw that glove on Sunday? No. 3 said they didn't. So I challenge the state to tell you what evidence they have that that glove was there on Sunday, other than they just want you to believe it. How is it possible, another question that I'd love the state to be able to answer, how is it possible that you heard from 5 witnesses that did not see Ms. Grinstead's car on Sunday morning, but not one single witness to come and say they saw Ryan carrying out a body in a quilt? Not one. In broad daylight, when everybody is headed to Sunday school. Not one. How is it possible that Ryan broke into Miss Grinstead's house with a credit card when she had a hotel-style loan? And I challenge the state. Why did they not bring you this photo? Why did they ask witnesses about this photo that doesn't show this part? To create the illusion, to create smoke and mirrors, so that you believed that, oh, it might be broken. Have you never been in a public bathroom where it's broken? Those were the questions that were asked. Well, that's disingenuous. It's not broken. And you heard testimony that she installed that lock specifically because Anthony Vickers had tried to break into her house. That lock was there specifically to avoid people breaking in. She used that lock.
So Ryan Duke's attorney took on this case pro bono because they believed in their client's innocence. Do you think this shone through in their closing arguments, Sharina?
She seems very aggressive. She almost seems rude. I don't know if that's just a tactic. I feel like she's doing too much to prove something that didn't necessarily happen. I don't think he's innocent. So that's probably why I'm interpreting her message and her actions the way I have. But she doesn't seem to have very strong evidence. So she's latching on to the little bits that she has to make her client look innocent as much as she can.
Marie, do you think Ryan Duke should have gotten off with such a short sentence?
Absolutely not. He already was in jail waiting for trial for 5 years. And so he's only really going to do maybe another 5, and he'll probably be released before that. That's why they're trying to get him on more charges, because I feel the DA must feel terrible about what happened here. I'm shocked that this man got off. I couldn't believe the sentence. So now they are trying to piece together little things like tampering with evidence, concealment of body, and interfering with investigation to see if they can maybe get a 5, 5, and 10 to make him have a longer sentence. Because really, he needs to be in jail for at least as long as Bo Dukes is, which is 25 years.
Well, speaking of Bo Dukes there, Marie, there will be another trial for Bo Dukes as well. Here's the question we all have. Who killed Tara Grinstead? Marie, I'm going to start with you.
We don't know, and it's heartbreaking. It's heart-wrenching for the family because they will never get the closure. For one thing, we do know it was one of them. Although, they tried to assail her name and her character, when I say they, the defense team, to try to say that she was dating 2 men at one time. Then it came out that she had a side boo who was married. They hurt her reputation, and I felt that was even more terrible for her family, who still has no closure to who killed this wonderful person.
Sharina, what do you think?
Her character has really nothing to do in this case. She's been murdered. I think we should focus on that, right? So for us to even be discussing her character from either of these defendants is really pointing at something that's not even an issue. I don't care who she was, what she did, how many boyfriends, man friends, whatever she had. She didn't deserve to die, and someone needs to come forward and pay for it. And we need to find out who.
All right, we have to take another quick break here on Law and Crime, but when we return, we will discuss a lawsuit against Mariah Carey. You're not going to want to miss this one. Stay tuned. Welcome back to For the Record. I'm Michelle Yu. We have a bit of celebrity law news that I want to chat about this segment. Pop singer Mariah Carey, her co-writer, and Sony Music Entertainment are being sued for at least $20 million in damages for the hit 90s Christmas song, All I Want for Christmas Is You. I think a lot of people are aware of that song. Now, Stone from the country pop band Vince Van and the Valiants is suing for copyright infringement, among other claims. He claims to have written a song with the same title 5 years earlier. Carey and Sony have yet to comment on this lawsuit. So let's discuss about this. And Sharina, I'm going to start with you because you specialize in things dealing with copyright infringement. Why do you think it took so long for Stone to come out with their lawsuit?
Has been my major question about this lawsuit as soon as I heard about it. It's not like it's a not famous song. I mean, every Christmas, this is the one song we hear over and over and over in any radio station that you can imagine. In fact, it's also so popular on social media that everyone has pretty much made some sort of a post about the song. So they can't possibly claim that they didn't know that this song existed until just now. So that's my big question: is what took you so long? What are you claiming right now? Are you claiming that you just discovered this song by Mariah Carey that plays religiously every Christmas and that has almost become a part of Christmas itself? I don't know. That's what I'm looking to find out.
Marie, what do you think? Why do you think it took so long?
I still don't understand. I mean, I'm no expert in copyright law like my esteemed co-panelists, but why did it take so long? And isn't there some sort of statute of limitation for when you found out about the alleged crime, basically? And why are you now just coming forward, claiming damages, that they, copied your style? There has to be some sort of limit.
Well, Sharina, can you help us answer that question? Is there a statute of limitations on this type of lawsuit?
Absolutely. The statute of limitations in the U.S. for such a lawsuit would be 3 years from the time that you have discovered the infringement. So are they telling us that they just found out about this song 3 years ago or just now? I'm not really sure. And on top of it, another thing we need to consider is the fact that you cannot protect a title with copyright law. So you cannot register just a title. It would have to be the entire song. Now, I don't know if you guys have listened to both songs side by side. There is not that much of a similarity. And when it comes to copyright infringement, the main question that we're looking at is substantial similarity. So in order for there to be copyright infringement, what we have to look at is substantial similarity. Are the two songs in question substantially similar? In my opinion, no, it's absolutely not. It just shares a title. And again, titles cannot be protected by copyright law. So I don't know what they're going to claim, but it looks like someone wants some money.
Well, Marie, do you think there's a chance of this getting a trial?
I think there may be. They could make a motion for summary judgment and try to shut it down before it begins, but I think there may be. I haven't heard both songs side by side, but I think I will definitely trust the opinion of our expert and go along with, there's no case, somebody wants some money, but it may not happen.
Well, Sharina, what I do find interesting is that Mariah Carey has not commented on this yet. If this was something that was just no question, why am I even bothering with this? Why isn't the big Hollywood singer not talking about this? Why hasn't she said anything and just put the kibosh on?
Well, hey, we don't know if she's been consulting with a copyright attorney this very moment, right? When it comes to situations like this and when it involves such huge stars, right? They don't want to open their mouths until and unless they have had a good consultation with an attorney who knows what they're talking about. And in this case, she would have to consult with a copyright expert, a copyright attorney, to know exactly what she's going up against. And again, if they're following the analysis that I've just given you guys, I don't think there is any case for the plaintiffs to come after her for anything. But we shall see what happens, because this song is a huge moneymaker for her every year. So every December, she is making royalties out of just having the song play in various stations.
Well, it's interesting you say that, because I believe that this is the most played and most popular Christmas song of all time. At least that's what I saw on Spotify last Christmas when I was playing it on my phone. So this is very interesting that Mariah Carey has not commented. What is your theory, Marie? Why do you think she hasn't said anything in this case?
I think she's waiting for her counsel to step in and make a statement, and I think it's wise for her not to even get involved. And I think that at the end, maybe they will just settle out of court just for nuisance value, to just avoid the negative press, so that this doesn't blow up out of proportion and hurt the reputation of my favorite song, Santa Baby. I mean, my favorite song is Santa Baby. We'll see what happens.
I love it. We're talking about Christmas songs here in June. Who would have ever thought that would happen? Anything happens here on the Law and Crime Network, by the way. And Sharina, before we let you go, is there a case? I mean, does it sound egregious that they would settle for something like this?
You know, it's not outrageous, and it doesn't even shock me, because anyone can sue for anything. Whether or not it has any merit is a completely different question. But like I said, you know, they are looking for some money. I don't know if they're not getting new deals or what the case is. Obviously, I also don't know all the details, but looking at the case on its face, I don't see how it's going to go anywhere. And you know, if they do come into a settlement agreement, it's because they want to avoid the negative publicity, like my esteemed panelist has just mentioned. So a lot of times settlements just take place just to kind of shut everybody up and move on with their lives. So we have yet to see what happens, but if you ask me, there is absolutely no reason for this lawsuit to go anywhere.
Quickly, 20 seconds, Marie, what kind of jury would they look for in this trial?
People who know about music and pop culture, young people, and maybe even older people who want to preserve the integrity of this iconic song and not stain it at all.
All right, well, thank you so much. That's always a great discussion, us talking about our favorite Christmas songs. All right, Sharina, thank you so much for joining us and your great analysis as always. Maria Pereira is going to stay with me, so should you. We'll be right back with so much more trial coverage on the Law and Crime Network. We'll be right back. Stay with us. to the second hour of For the Record here. I'm Michelle Yu, and you're watching the Law&Crime Trial Network. We're continuing our review of the Johnny Depp Amber Heard defamation case today, where a verdict came in Wednesday afternoon. As a refresher, Johnny Depp sued his ex-wife for $50 million over her 2018 op-ed in the Washington Post, dubbing herself a domestic abuse survivor. Depp claimed he was the real victim of domestic abuse, and her defamatory article cost him his reputation and several acting roles. Amber Heard countersued Depp for $100 million, arguing Depp and his attorney coordinated a smear campaign following the op-ed. The jury had to consider 3 statements made by Amber Heard in her op-ed and 3 statements made by Adam Waldman, Depp's attorney, after its publication. The jury out of Virginia found each of Amber Heard's 3 statements in question defamatory towards Depp and awarded him a total of $10 million. As for the 3 Adam Waldman statements, the jury found one of them to be defamatory towards Heard and awarded her a total of $2 million. Let's take a look back now at some of the most important moments in the trial. When an ACLU member testified via deposition for this trial, we were able to get an inside look at how Amber Heard went about writing her op-ed and what it was actually about. Let's start with some questioning by Johnny Depp's attorney.
And isn't it true that Ms. Heard's advisors initially revised the draft to remove any reference to Ms. Heard's marriage or divorce?
I recall a number of email communications back and forth among ACLU personnel and Ms. Heard's attorneys where they were suggesting edits to the op-ed relating to matters covered in the NDA.
And then isn't it also true that there were some at the ACLU who expressed their belief that excising those references to her marriage and divorce from Johnny Depp made the op-ed less impactful, correct?
It is correct. That is correct.
But ultimately, based on those voices, Ms. Heard pushed to get that excised material back into the op-ed so it could be more impactful, true?
That's not my understanding. My understanding is that the language that wound up in the final op-ed piece was very different from the original language that Robin included in the op-ed after having spoken with Amber about her personal experiences.
And how was it different?
It did not refer directly to Ms. Heard's relationship with Johnny Depp.
And Amber's referencing her own direct personal experience and her marriage to Johnny Depp makes it a stronger product, correct?
I think that the Amber's contributions to the portion of the op-ed that talks about personal experiences is part of what informed the view that this was a strong op-ed and the importance of the women's rights issues referred to in the op-ed, in that some of them were very timely women's rights issues before Congress.
All right, joining me new this hour is criminal defense attorney Josh Ritter, and still here with me is Marie Pereira, criminal defense attorney and former prosecutor. Thank you so much for joining us this second hour here on For the Record. Josh, I'm going to start with you. How did this testimony help drive Johnny Depp's case forward?
You know, it's funny. I thought this issue was going to be a bigger issue going into the trial. Like, how are you going to prove this is about Johnny Depp when his name is not mentioned anywhere in the piece? And I thought they would focus more on that. But that part of their case, I'm talking about Heard's case, really seemed to fall apart throughout the trial. This was one of those witnesses that kind of highlighted that. His name was in and out of it. It was bandied about. They all knew the elephant in the room that they were all talking about. It was just whether or not they used his name or not. And then that all kind of completely fell apart when she took the stand towards the end of the trial and basically admitted that it was about him. So that part of their defense really seemed to kind of fall apart throughout the case.
And Marie, this was just the first step to proving that Johnny Depp was indeed defamed by this article, right?
It was the first step, but it was a very important step because he had to show defamation by implication. And you know what? That statement, that testimony by the ACLU attorney really makes Amber look disingenuous along with her entire team. Because how are you saying that, oh, this wasn't even about him, because that was one of her arguments. It was about my life after I left him. It was never about Johnny. And as Josh said, and at the end, admit, that's why I wrote this op-ed. Jurors don't like to be lied to. They can't jump up and call you a liar while you're on the stand, but they can deal with you in the deliberation room, and that's exactly what happened to Amber. And she lost that case because she looked like a liar.
Now, another witness, Richard Marks, a prominent entertainment lawyer, was called to the stand by Johnny Depp. He testified about the damage that the op-ed had on his career. Here's what he had to say.
You wouldn't want to hire an actor who has negativity following them. You wouldn't want to pay to actually bring your brand down, your movie. And so that's very important, and especially in the last 5 years with the Me Too movement, you wouldn't want negativity hiring an actor who, quote unquote, had been canceled.
Is there anything in particular that might prevent an actor from getting hired by a brand or a studio?
Well, I mean, we're talking about illegal activity, a criminal record, but right now, the pinnacle of negativity in Hollywood is being accused of domestic abuse, sexual abuse, violence, and what we've seen is almost immediately terminations and cancellations for the investors, to the people who create that product, to move away from that negativity.
I think you mentioned the Me Too movement. What's your understanding of what the Me Too movement is?
My understanding of the Me Too movement is that finally society is listening to the victim, giving the victim of domestic abuse, sexual abuse, the benefit of the doubt. And there has been a shift in our society from not doing that to now the victim gets the benefit of the doubt until there's too much doubt. And to me, that's the Me Too movement. One person can come forward and accuse Harvey Weinstein, and another person can come forward, and another. That's the Me Too part of it. But they get the benefit of the doubt, whereas in the past, the victim didn't have that benefit.
So after hearing that type of testimony there, how much do you think Amber Heard had to do with Johnny Depp's fall from fame, Josh?
I think she had a tremendous impact on his. I hope it's not a fall completely. I hope it's a speed bump in his career after this trial. But I think she had a huge impact. I mean, it wasn't. That attorney pointed out something important. This wasn't just accusations made at any point in history. This is accusations made in the backdrop of Me Too. I mean, that was huge. And he's right. It was this this time where if a victim said something and came out with allegations, even without proof or otherwise, it was assumed to be true. And he kind of got swept up in all of that. He got swept up with a lot of bad actors, a lot of people who needed that kind of reckoning. But now, you know, at least we see an opportunity for people accused to come forward, have a trial, and say, listen, I need to clear my name, which I think he absolutely did.
And Marie, how much do you think it had to do with his own substance abuse and irresponsibility? I mean, keep in mind that one of his former agents came out to say, oh, well, he wasn't getting roles because he was late and he was delaying the crew and things like that.
They might have tried to make dents in his damages by trying to blame his own character and lack of professionalism on the lack of luster that his career was having. But I think Richard Marks, that expert witness who deemed himself a deal maker, knew so much about the industry, and his testimony was so compelling and unbiased because, you see, he didn't make a living being a hired gun. He rarely testified, and he wasn't like the experts that Amber's team brought on, who we and the world of expert hiring attorneys call whores because they have testified so many times, it's like they're hired guns. His credibility was just unimpeachable, and he did a good job with the damage portion, at least proving that it had nothing to do with Johnny's behavior, because Hollywood is used to, well-liked actors being like that, and they deal with them because they sell tickets.
Now, this took place, though, before the Me Too movement. How do you think Amber Heard's accusations impacted Hollywood, Josh? I guess then and now.
Well, yeah, I mean, then, we're talking about an actor who is at the top of his career, right? I mean, we're talking about somebody who's every single movie he seems to touch becomes a blockbuster. And it was such a scandal. I remember that day that she walked into court and she was seen with a bruise on her face coming out of court. I mean, it's hard to feel that is not hugely damaging to him. But now we're on the other side of things, right? The full arc of this entire story, and we're on the other side of it. And I really think this is kind of a cultural moment as well. It's a moment where we realize that, listen, sometimes people are motivated by things other than the truth, right? Sometimes they're motivated by either money or to get leverage out of divorce, or maybe just flat out fame and to bring attention to themselves. And it's been a remarkable moment to see how Amber Heard's her moment fell apart.
And certainly now, when we talk about the Me Too movement, we are also talking about Amber Heard and how that may be evolving and how the Me Too movement is evolving because of that verdict. All right, we have to take a quick break here on Law and Crime, but stay tuned because we have more Johnny Depp Amber Heard coverage on the other side, including an update about a statement made by Amber Heard's sister about the verdict. You don't want to miss it. Stay with us. Michelle Yu, and welcome back to For the Record. Thank you so much for joining us. We are continuing our review of the Johnny Depp Amber Heard defamation case today, where a verdict came in Wednesday afternoon. As a refresher, Johnny Depp sued his ex-wife for $50 million over her 2018 op-ed in the Washington Post, dubbing herself a domestic abuse survivor. Now, Depp claimed he was the real victim of domestic abuse, and her defamatory article cost him his reputation and several acting roles. Amber Heard countersued Depp for $100 million, arguing Depp and his attorney coordinated a smear campaign following the op-ed. The jury had to consider 3 statements made by Amber Heard in her op-ed and 3 statements made by Adam Waldman, Depp's attorney, after its publication. The jury out of Virginia found each of Amber Heard's 3 statements in question defamatory towards Depp and awarded him a total of $10 million. As for the 3 Adam Waldman statements, well, the jury found one of them to be defamatory towards Heard and awarded her a total of $2 million. Whitney Henriquez, Amber Heard's sister, spoke out about the verdict recently and said that she was proud of Amber regardless of the outcome. Before we get into more details about that, let's watch some of Whitney's testimony from this trial.
What, if any, behavior changes did you observe when Mr. Depp had been drinking alcohol or using drugs?
Like I said, it was, a completely different version. He was almost unrecognizable when he was drinking and using to an excess. If it was alcohol and Coke, he would slur. He would go on these paranoid, delusional rants about things that didn't make any sense. His speech would be slurred. I almost never knew him to use cocaine without drinking. Those were generally combined. When he would smoke weed, he was much more relaxed. He was kind of what you would expect, happy on a couch, laughing. But when he was drinking, he would just get very angry, and he would just say really nasty, unkind things, and it almost didn't, usually about Amber, sometimes about me, but it almost didn't matter if she was in the room or not. He would just say really horrible, horrible, horrible things about her or to her.
Can you give the jury a few examples that you can recall?
Pardon my language. He called her a used up trash bag, slimy whore, saggy whore, was thrown out a bunch, just horrible things like that.
Now, Whitney Henriquez posted on her Instagram with a supportive message toward her sister recently, and it reads this. Quote, "I will stand with you, sissy. Yesterday, today, and tomorrow, I will always be proud of you for standing up for yourself, for testifying both here in Virginia and in the UK, and for being the voice of so many who can't speak to the things that happen behind closed doors. We knew that this was going to be an uphill battle and that the cards were stacked up against us, but you stood up and spoke out regardless. I am so honored to testify for you, and I would do it 1,000,000 times over because I know what I saw and because the truth is forever on your side. I'm so sorry that it wasn't reflected in the decision made by this jury, but I will never give up on you, and neither will anyone who stands with you. Forever by your side, hashtag I stand with Amber Heard." All right, I want to get my guest's take on this. Now, Marie, let's keep in mind that when Whitney was on the stand, she also at one point said that, she got along with Johnny Depp and that sometimes she and Amber Heard were not the best siblings. What do you take from all of this?
I think her testimony was genuine and it seemed credible, but it did no more than verify that Johnny Depp was mean when he drank. We had text and voicemails that verified that, and we had Johnny Depp's own testimony that verified that. What it did not do is verify the claims that her sister made that he assaulted her brutally as per her descriptions on the stand. She was there during, for instance, the trailer park incident, where Amber said he grabbed the hand of a woman who was coming on to Amber and said, "You talking to my girl, I'm going to break your arm." She never testified on the stand that she saw that. So she was truthful about what she saw, and she never saw Johnny beating up Amber. So her testimony didn't really tip the scale in her sister's favor, but she did look like she was telling the truth for the most part.
Josh, what do you think? Do you think she's being genuine here, supporting her sister, or she's trying to get maybe 2 minutes of people paying attention to her?
I think it's the PR machine in full effect, right? I mean, this is funny if we think about it, right? She's writing a statement as if she's speaking to her sister, but of course she's releasing it on Instagram for the world to see. Then they've got this hashtag I stand with Amber thing. This is an orchestrated PR attempt to try to rewrite the narrative, and they're still going with the victim narrative here, right? It's still you were brave, you stood up, you talked about things that happened behind closed doors. You're a champion for victims and victims' rights. I think that they've actually done a lot of damage to that movement, and I would implore them to kind of step aside, allow this moment to pass, because there are true victims of domestic violence who do go through awful things and do have to testify and come forward, and we should be supporting all of that. And I think this has left a kind of a black mark on all of that.
Now, one important event that Whitney gave us insight on was the so-called staircase incident. Let's listen to what she had to say about her involvement in that.
So I go to PH5 where Johnny, Debbie, and Travis were all standing in the kitchen of PH5. I went down there to talk to him, and again, I can tell he's clearly drunk, and he has a bottle of alcohol of some sort in front of him as well. And again, he's talking to me about how Amber found these text messages between him and a woman called Rochelle, and then he starts saying that this woman was meaningless. It wasn't anything special. She's nothing special. But then he immediately shifted to, well, Amber pushed me. Amber made me do it. And, of course, I'm cheating on her. Whatever. And it suddenly became about Amber making him do it. At some point, then Amber is on the mezzanine level of PH5. So she is. It's kind of hard to explain. So the kitchen's down here and the mezzanine's up here. So she's there. It's her little office nook, and she starts shouting at him, saying,
Objection, Your Honor, hearsay. It's not offered to prove the truth of the matter asserted, Your Honor. She's screaming expletives at him. I mean, that's not offered to prove the truth. Overruled. Thank you. Please continue.
They're saying horrible things to one another. You know, he's calling her a whore, used up trash bag, whatever. They were saying horrible things to one another. She was calling him old and fat. It was a fight. They were saying really nasty things to one another. I leave them in the kitchen to go up the stairs. I was trying to calm Amber down, hopefully get her back into my apartment. And Debbie had come up with me.
And Debbie, who's Debbie?
Debbie was his nurse at the time.
Debbie Lloyd?
Yes, I believe that was her name.
Okay.
So we're with Amber on the mezzanine level.
I'm sorry, just so we know who we're is it you and Debbie that are with Amber, or is it...
Yes, Debbie, Amber, and I are all in the little mezzanine area. And as I mentioned, the mezzanine overlooks the kitchen and the living room. So Johnny then hurls a Red Bull can, and it hits Debbie in the back. She didn't even react. She didn't really seem to notice. But I'm standing up there talking, I'm at the top of the stairs with my back to the stairs. And that's when Johnny runs up the stairs. And again, I'm facing Amber. He comes up behind me, strikes me in the back, kind of just somewhere over here. He strikes me in the back. I hear Amber shout, "Don't hit my f***ing sister." She smacks him, lands one. And then he grabs, at that point, that's when Travis runs up the stairs after Amber landed one. But by that time, Johnny had already grabbed Amber by the hair with one hand and was whacking her repeatedly in the face with the other as I was standing there. Travis pulls them apart. I get Amber into mine. I close the doors behind me and lock them. I then hear Johnny's voice shouting.
Never mind, withdraw here, sorry.
I hear Johnny's voice shouting, "You f***ing hate you. I hate you both. You f***ing whores." And I hear crashing. I hear crashing and banging and smashing, and he starts screaming like an animal. And I then just moved Amber into the next room, and I just kept her there all night.
Marie, Whitney was clearly a key witness in Amber Heard's case, especially when it came to that incident. But When we look back, when we hear that, how genuine was that testimony?
Again, it seemed as if it was genuine, but I think she embellished when she said things like he repeatedly whacked her. Because even with that, the next day, that was the last fight they had, by the way, I believe, and she went after that to get the TRO. And to me, it didn't show all that whacking that Whitney is describing on the stand. Even Amber Heard with the bruise coming out of that family court or the criminal court where she got the TRO, it didn't really match up with the description of the violence her sister was describing on the stand, and I think it might have hurt her at the end because, again, jurors want to see photographs that match allegations of witnesses on the stand.
By the way, the Daily Mail reported that Amber Heard stayed in a house that costs, get this, $22,000 a month in Fairfax, Virginia for this trial. Josh, how did she save the funds for this and not to repay the lawsuit?
That's a great question. People are going to be digging through her finances real quick here. It's funny. All of this is really starting to look like a mess for her. And just from a PR perspective, like how is she going to, I mean, the fact that we know how much she paid for her house and that that's being reported shows you a lot about how the media has really turned the tide, and they've really turned against Amber on this whole thing. If I could go back to what Marie said a little bit about Whitney, because I totally agree with what Marie was saying. I found Whitney to be such an interesting character because she was supposed to be a really pivotal witness. This is supposed to be the one person that Amber can present that actually witnessed violence. And I felt she was credible the way that she testified. But obviously the jury didn't believe a word that she said because all they had to do was prove one instance, right? One instance of violence would have been truth and enough to make a defense against defamation. And the jury listened to her. She seemed credible. She was very subdued. She was very straightforward. But they obviously did not believe a word coming out of her mouth, as indicated by their verdict.
Okay, I'm sorry. I'm still fixated on the $22,000 a month here that Amber Heard paid while she was in Virginia for renting a house. Marie, you're always sassy with your comments. I want to hear your thoughts on this one.
Listen, she still has the money from the divorce settlement that she sat on for a very long time and couldn't get off it to give to the ACLU. Now, she's really going to have to try to repair her image and give up some of that money. So why not try to spend it and create an expense account through that $22,000 house to say, well, I needed a place to stay while I was being sued because, you know, I was just holding on to the money because he sued me. So that was just all part of the suit. And then, you know, that'll be less money she has to cough up to the ACLU.
That checkbook is certainly not adding up for Amber Heard. I'll say that. And I'm no mathematician. All right, we're going to have to take another quick break here on Law and Crime. When we come back, so much more trial coverage, including more recap of Johnny Depp versus Amber Heard. Stay with us. to For the Record. I'm Michelle Yu, and you're watching the Law and Crime Trial Network. We're continuing our review of the Johnny Depp Amber Heard defamation case today, where a verdict came in Wednesday afternoon. As a refresher, Johnny Depp sued his ex-wife for $50 million over her 2018 op-ed in the Washington Post, dubbing herself a domestic abuse survivor. Now, Depp claimed he was the real victim of domestic abuse, and her defamatory article cost him his reputation and several acting roles. Amber Heard countersued Depp for $100 million, arguing Depp and his attorney coordinated a smear campaign following the op-ed. The jury had to consider 3 statements made by Amber Heard in her op-ed and 3 statements made by Adam Waldman, Depp's attorney, after its publication. The jury out of Virginia found each of Amber Heard's 3 statements in question defamatory towards Depp and awarded him a total of $10 million. As for the 3 Adam Waldman statements, the jury found one of them to be defamatory towards Heard and awarded her a total of $2 million. Last week, our very own Anjanette Levy interviewed the freelance court stenographer, Judy Bellinger. Bellinger was getting all sorts of attention for supposedly hanging out with the Depp team after court one day. Now, it turns out this was a big misunderstanding, and here's what she had to say about it.
So after closing arguments, I finally decided I wanted to get out of the courthouse and just take a breather. We were supposed to go until about 5:30, maybe 6 if the jury wanted to. And so I thought, I want to maybe try to go to Indiana this weekend. Let me run down the street and get my oil changed, and I'll come back and go back up. Well, the courthouse closes at a certain time, and I didn't make it back in time. And Judge Ascarati just wanted to close the record. And I'm like, oh yeah, well, I'm stuck outside. I'm getting my oil changed. And she goes, oh, it's okay. Well, she didn't say it. I was getting messages. And I said, okay, just don't worry. My recording's going. It's just closing the record. I'll, transcribe it when I get back. But then I needed my equipment. So Mr. Chu and it was Rebecca. I think they were the ones that were there, and they were kind enough to pack up my computer for me in my backpack, because that's all I needed. I leave my machine there because it's just quicker to come in and just set up my computer and not have to set everything up every day all over. So they were kind enough. They said, okay, if you tell us how to, disconnect everything, we'll bring it to you, because we have an office right around the corner from where we are now, and this is where they were staying. And I said, hey, I have an office on Greensboro. I can meet you there and get my equipment, and I can get the transcript out this weekend. So they're like, okay. And then I guess Johnny had told them he would really like to meet the court reporter, which was like shocking to me. I'm like, I'm just the court reporter. And so when they brought me my equipment, well, they were going to bring it, and there was no one at our Greensboro office, and you can't get in if there's no one there. So
and it's Memorial Day weekend.
Right. So
it's a holiday weekend.
Yes. So they just brought it back to the hotel, and they said, hey, do you mind if we just take it to the hotel? You can pick it up here. And actually, it took me a minute. I didn't know how to get up here. I didn't know you had to come in the downstairs door and then go to another floor and then get to another floor.
It's a little confusing.
It is very confusing. And so they had my computer and stuff with them, and they were in the hospitality room, and Johnny was in there. And so I had to go in there and get my equipment, and I saw him, and they're like, he really wants to meet you. And I was in there for probably less than 10 minutes, and he just hugged me and thanked me again, and I hugged a couple other people there, and I got my equipment, and I came out, and I left and went home.
That's really funny, because a lot of people are suggesting you're just out at the after party hanging out, with Johnny Depp, and that's not what happened.
Not at all. I still had from here, I had about a 50-minute drive home, so no, that did not happen.
So that is the real story of Judy Bellinger and her interaction with Johnny Depp's team. Now, before I get to discussion here, I want to emphasize that Bellinger's transcript is not the official court record. The actual court reporter's word will be in the court file. Bellinger was hired by both sides so that they could get a transcript at the end of the trial each day. So now that I've gotten that out of the way, let me get my great guest's opinion. Marie, do you think she acted at all unethical by doing this?
I don't think so. And I think that she was just a wrong victim of cancel culture. She left her things in there, and Benjamin Shue tried to help her and capture the stuff, you know, so she wouldn't have to be without it. And then all of a sudden they're accusing her of choosing sides. You know, she could have lost her job for this, you know. The negative press alone, even though it was unwarranted and unsubstantiated, could have really gotten her in a lot of trouble. And poor Judy, you know, but she did get to meet Johnny, which was, you know, really fly.
Well, that's the thing, Josh. I mean, when you hear her talk about her encounter with Johnny Depp, I mean, she seems like a very lovely woman, a little giddy that she got to meet Johnny Depp. Does that come off the wrong way?
I don't think so. I mean, she's starstruck, you know, I mean, it's understandable. You know, the thing to understand, too, is that when these trials go on as long as they did, I've done a couple of trials that have gone on for weeks. You get to know these people, the courtroom staff, the stenographer, the bailiff. These become like your coworkers. You're there for 8 hours a day, if not more, dealing with these people, you know, and during breaks, you're chit-chatting. How are your kids? Oh, my God, did you watch the ball game last night? And so it's understandable that there would kind of be this friendly rapport amongst everyone. And I think it's just showing you another effect of the media circus and microscope that everybody was under, that even the poor court stenographer is getting attacked for just a really commonplace kind of interaction.
I feel people can't be happy for people anymore when they just, are at an accidental place at an accidental time meeting Johnny Depp. They always have to spin it somehow. All right, thank you so much for that take. We're going to take another short break here on Law and Crime. When we come back, we're going to talk about the Ryan Duke trial. There's an update on that, so stay with us. We'll be right back.
That sentence is 10 years to serve in the state penitentiary. You're right. The parole board may pardon him out today. Maybe that's the case. But that's the sentence of the court. You have 4 years from the date of the filing of the sentence to seek any state habeas corpus relief. 30 days from the date of the filing to file any notice of appeal or motion for new trial. Anything further?
What you just saw was the sentence of the Georgia versus Ryan Duke trial that finished up last month with an acquittal in Irwin County. Welcome back to For the Record. I'm Michelle Yu. Well, in the latest development, there will be a new trial in Ben Hill County for similar charges. Duke was found not guilty in the murder of Georgia beauty queen Tara Grinstead last month, but guilty of concealment charges. He is currently serving the rest of his 10-year sentence with 5 years already served. And according to a new indictment released on Friday, Duke will face another concealment charge, hindering apprehension or punishment of a criminal, 2 counts of concealment of facts, and 2 counts of tampering with evidence in Ben Hill County for the same case. Bo Dukes, who was also convicted of concealment charges in this case, will also face an additional concealment charge and hindering apprehension or punishment of a criminal in Ben Hill County later this month. We will have Ryan Duke's attorney on tomorrow. She took on Duke's case pro bono because she believed in her client's innocence. She really showcased her faith in Ryan Duke through her opening statement. Let's take a look at that.
What are you not going to hear? What else are you not going to hear? You're not going to hear any evidence that Ryan had his blood, semen, saliva, skin cells, prints, anything in that house. Not one piece of evidence that Ryan was in that house. Not one piece of evidence that Ryan was in that car. They took fingerprints off the door, off this door that they're going to ask you to believe he broke into with a credit card. They took fingerprints. Not one single one matched Ryan's. The state's theory, we believe, is based on a statement that was taken from Ryan and that was not the truth. Does the state know the truth? We'll have to see at the end of this case if the state has presented any evidence that they actually know what happened in this case. But what we do know is that Ryan did not harm Ms. Grinstead. And at the end of this trial, you will agree with us that Ryan did not harm Ms. Grinstead, that he was not in her home, and that he did not assault her, he did not burglarize her. He's charged with burglarizing, he's charged with assault, but he did not do any of those things. Like I said at the beginning, this case, it's about power and it's about influence. What's great about jury service is that at this point, you all hold the power. You have the influence. And at the end of this case, we're going to come back up here and we're going to ask you to render a verdict. We're going to ask you to render a verdict that speaks the truth and that speaks justice for everybody involved in this case. And that verdict is going to be not guilty because Ryan Duke did not commit the crimes that he is charged with committing in Irwin County. He did not murder Ms. Grinstead. He did not assault Ms. Grinstead. He did not burglarize Ms. Grinstead. He did not conceal her death in Irwin County. He did none of the things that he's indicted for. And you all will agree with us at the end of this trial. Thank you.
Marie, how much do you think Ryan Duke's attorneys and how much they believed in him played a role in this verdict? I mean, she was pretty convincing.
She believed in him 100%, where she took nothing and made some reasonable doubt out of it. I was shocked when I heard the verdict. This woman is the picture for compelling advocacy and criminal law, because honestly, he should have been convicted.
Yes, no doubt. I completely agree with you. Josh, what do you think? What do you expect the outcome of the next trial to be after seeing what happened here?
You know, I'm really confused by what they're doing in Georgia. And I think they might be getting exactly what they asked for, in that they're going to get convictions that might be contradictory, that might be piling on. Wait till this gets in front of an appellate court. I mean, this is problematic. You know, they've secured convictions now. Why try to double down on all of this stuff and possibly get yourself into trouble that some of these convictions start getting thrown out because you're abusing double jeopardy laws? I don't understand it. They put on their case. They had a strong case. I agree with Marie. I was surprised by this verdict as well. You had a confession here. You put forward the best case that you could, and you didn't get it. It's time to kind of cut your losses and move on. I just don't understand this kind of double charging. And, well, we're not charging them with murder. Now it's charging them with concealment. And it's just going to get so messy on appeal.
Ryan Duke even took the stand. The jury ultimately believed him, even after his shaky cross-examination. Let's take a listen to that.
That on October 23rd of 2005, you were at the orchard in Ben Hill County, correct?
Yes, ma'am.
And we can agree that on October 23rd of 2005, Tara Grinstead's dead body was in that same orchard.
Yes, ma'am.
And we can agree that you saw her dead body, correct?
Yes, ma'am.
We can agree that you touched her dead body.
After I was told to pick
The
her
answer is
up.
yes, you touched her dead
Yes,
body.
ma'am.
Okay. We can agree that you helped move her dead body.
Yes, ma'am.
We can agree that you helped Bo Dukes get the pecan wood to be able to burn her body.
Yes, ma'am.
We can agree that you were in the truck when you drove Tara Grinstead back to the place where she would be burned.
I don't know if that's where he continued to burn her or not. I was only there that one time.
You were only there at the time. But you were there because you've already admitted you helped put her lifeless body on top of that fire pit.
Yes, ma'am, I did.
And you don't want to admit to having seen the match struck, but you know that she was set on fire.
Yes, ma'am.
And you knew that on October 23rd of 2005.
Yes, ma'am.
And you knew that on October 24th of 2005.
Yes, ma'am.
And you knew that on October 25th of 2005.
And every day after.
That's right. Every day after. And you never told a soul.
No, ma'am.
So, Josh, I can't help but think what you said before. You said you were confused about what was going down in Georgia. I'm confused after watching that testimony. How do you think he did on the cross-examination for these people to make the decision that they made?
Well, obviously, my opinion, regardless of what it was, you convinced 12 people in Georgia, right? But what I thought was really interesting about that short segment that we watched right there is he admitted a lot, right? I mean, this is where you build credibility with the jury, is if you're willing to admit some pretty awful stuff. I mean, he's saying, yes, I helped with the body. Yes, I know it was burned. Yes, I know that poor woman is buried in a pecan orchard. But I'm admitting to all of that. Please believe me on all of that. And please believe me when I say I did not take a part in her actual murder. And they must have believed it. So it shows you how the building of credibility by maybe admitting to some awful things can sometimes build you enough credibility that they'll believe you when you deny the worst thing of all, which is what we're on trial for here, the murder of Tara.
Marie, you've seen a lot of this in your years of practice. How do you think he did?
I think he did a great job, and I want to agree with Josh on his assessment and flip it back to Johnny Depp, because he said, you know what, he admitted a lot that he did. And as a result, the jurors believed him. Kind of like Johnny. He admitted, I'm trash, I drink, I hurt people, I say disgusting things, but I didn't do that. And it helped. And I think it was the same premise that helped this guy get away with murder, which I think is what happened here. He sat there when they said 10 years and he looked all sad, but he really wanted to just jump up like Fred Astaire because he got away with murder. 10 years for murder.
Well, Josh, do you think he scored a lot of sympathy points with the jury there?
I guess he did. I mean, he sounds sympathetic, right? He's not being combative. He's not kind of talking over. He's not trying to argue with the attorney. He's just answering the questions. He seems to be very kind of, sorry for his involvement and what happened and what he did. And I think the jurors, the part that really kills me, though, is he confessed to this. And they were able to get over his confession and believe his testimony on the stand it's pretty remarkable what the attorneys or whoever you want to give credit to here, his testimony or his attorneys, it was a pretty remarkable verdict.
Well, it's very interesting that you bring that up. And I think after all the evidence, you know, everyone was so surprised and stunned by this decision. And Marie, we talked about this earlier in the first hour of For the Record. I mean, why do you think there is now a new trial? What do you think they're trying to do now?
Because I think the DA, they did a great job. I still don't understand it. But let's get past that. They feel bad about what happened. That this guy is getting another 5 years in jail for what happened. So now they're trying to put together all of these little minimal charges, tampering with evidence, hiding the body, 2 counts of this, to try to see if they can add up at least 25 years in jail for this guy, because Bo Dukes is in jail for 25 years. They're just trying to add up the years so that it makes sense for the murder, even though he wasn't charged with the murder.
And Josh, what do you expect to see in the Bo Dukes trial, speaking of that?
I would give you an honest guess had we not seen the verdict that we just saw, right? I mean, who knows what's going to happen in these trials? Again, I agree with Marie. This is not the way the justice system should work. You shouldn't be saying, well, I want this result, so then I'm going to figure out whatever pieces I need to put together and whatever kind of convictions I need to get to that result. The system is about, listen, you've charged somebody with a crime, you put them on trial, you put forward your best evidence in the best case you can, and then you let the jury speak, and that should be the final word. And that, I don't think, is what's happening here.
Yeah, it's going to be interesting to see what happens in this new trial. All right, we're going to have to take a quick break here on Law and Crime. But before we do, I would like to thank and sign off criminal defense attorney Josh Ritter. Thank you so much for joining me. Until next time, as always. And for everyone else, please stick around for more of our coverage after the break. Marie Pereira is sticking with us. We have so much more to recap with Johnny Depp, Amber Heard, and more trial coverage. Stay with us. We'll be right back. and welcome to the third hour of For the Record. I'm Michelle Yu. We have more celebrity news for you all. Pop singer Mariah Carey, her co-writer, and Sony Music Entertainment are being sued for at least $20 million in damages for the hit 90s Christmas song, All I Want for Christmas Is You. The hit Christmas song has topped the Billboard Hot 100 chart every year since 2019. Now, Stone from the country pop band Vince Vaughn and the Valiants is suing for copyright infringement, among other claims. He claims to have written a song with the same title 5 years earlier. It's not clear from the complaint when Stone first learned about Mariah Carey's song. Now, Carey and Sony have yet to comment on this lawsuit. And with that, let's bring in my guest to discuss this. Marie Pereira, criminal defense attorney, former prosecutor, has stuck with us for this hour, but we have Nafis Syed, Law&Crime legal analyst, can't speak today, joining us as well for the rest of the show. Nafis, what are your thoughts on this lawsuit? Why now?
I agree with your, the surprise in your question. It's very surprising that he's doing this over 20 years after this hit song, which has made Billboard charts over and over and over again, a record-breaking number of times, in fact. And he alleges that he wrote the song 5 years earlier. So it's very strange that he is raising this now. And I also think he has a really uphill battle, because the only similarity between his song and Mariah Carey's song that I can see from the complaint is that the titles are the same. And in copyright infringement, it's very difficult to prove that that actually occurred just based on the title.
Now, Marie, the complaint outlines how the parties were unable to come to an agreement in April of 2021. What are the next steps in this lawsuit, you think?
Probably an effort to settle this nuisance and get it out of court on the part of Mariah Carey's team, because they don't want the negative press. They don't want it to seem like this megastar is unjustly enriching herself off the strength of somebody else's song. So they may try to engage in settlement negotiations because they don't want the negative press.
Of course, we'll be glued to that news here on Law and Crime, so we'll have updates as they come along. Switching gears now to another celebrity-related lawsuit. After 12 hours and 45 minutes, the 7-panel jury came back with their verdict in the Johnny Depp Amber Heard Defamation Trial. The jury had to consider 3 statements made by Amber Heard in her op-ed and 3 statements made by Adam Waldman, Depp's attorney, after its publication. Now, the jury unanimously found that Amber Heard could not substantiate her allegations against Depp and that she acted with malice, writing the op-ed. This means the jury agreed that all 3 statements in question were in fact defamatory towards Depp. The jury awarded him $10 million in compensatory damages and $5 million in punitive damages. As for the 3 Adam Waldman statements, the jury found one of them to be defamatory towards Heard and awarded her a total of $2 million. Now, following the verdict, the Washington Post added an editor's note to the top of Amber Heard's op-ed. Quote, in 2019, Johnny Depp sued Amber Heard for defamation arising out of this 2018 op-ed. On June 1st, 2022, following a trial in Fairfax County, Virginia Circuit Court, a jury found Heard liable on 3 counts for the following statements, which Depp claimed were false and defamatory. I spoke up against sexual violence and faced our culture's wrath. That has to change. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. Now, the jury separately found that Depp, through his lawyer, Adam Waldman, defamed Heard in one of 3 counts in her countersuit, end quote. So let's chat about this one. What do you think of the Washington Post's decision to add this editor's note, Marie?
I think that the negative press that this verdict sheds on the Washington Post hurts their credibility as a source of credible information. Because here she is, she came in with her story, they had to do some fact-checking, and they deemed it enough so that they went to print. And now the jurors are saying it didn't happen. Because for Johnny Depp to win that case, Amber had to be deemed a liar, because truthfulness is a defense to defamation. So clearly, if she lost, they don't believe what she said. So if what she said wasn't true, why didn't the Washington Post vet her information with more accuracy? And why did they print it? And why did they even let it get that far? Because lawyers talked to her, looked at it before they went to print, and they got it all wrong according to the jurors. So it really makes Washington Post look kind of dumb right now for letting this go to print.
Well, Nafis, what does this verdict mean for domestic abuse victims in the future?
Unlike what Amber Heard and her attorney have said, that have claimed that this is going to have a chilling effect on domestic violence, well, we have to look at two things. One is, this was a trial in the court of law, and justice was served. As Johnny Depp said in his statement, I think his statement was more on point because he alluded to the truth, and that's what we're trying to find out through a trial. We're not making a claim on all domestic violence claims. And I actually think this won't have a chilling effect. I think it might have the opposite of a chilling effect, because I think men will come forward, because we have to remember that men can also be victims of domestic violence. And I also think that because of this verdict and because justice was served, people will understand that they have to look at the facts on a case-by-case basis and not go with one side or the other just based off of emotions or claims, because that's not justice. That's just going off of your emotions.
By the way, since the verdict came out, the court stenographer Judy Bellinger has been facing backlash for a video that surfaced from a small get-together at the Ritz-Carlton Hotel following closing arguments in the Depp Heard Defamation Trial. And our own Anjanette Levy had the opportunity to sit down with her, so let's hear the story from Judy herself.
So after closing arguments, I finally decided I wanted to get out of the courthouse and just take a breather. We were supposed to go until about 5:30, maybe 6 if the jury wanted to. And so I thought, I want to maybe try to go to Indiana this weekend. Let me run down the street and get my oil changed, and I'll come back and go back up. Well, the courthouse closes at a certain time, and I didn't make it back in time. And Judge Ascarati just wanted to close the record. And I'm like, oh yeah, well, I'm stuck outside. I'm getting my oil changed. And she goes, oh, it's okay. Well, she didn't say it. I was getting messages. And I said, okay, just don't worry. My recording's going. It's just closing the record. I'll, transcribe it when I get back. But then I needed my equipment. So Mr. Chu and it was Rebecca. I think they were the ones that were there, and they were kind enough to pack up my computer for me in my backpack, because that's all I needed. I leave my machine there because it's just quicker to come in and just set up my computer and not have to set everything up every day all over. So they were kind enough. They said, okay, if you tell us how to, disconnect everything, we'll bring it to you, because we have an office right around the corner from where we are now, and this is where they were staying. And I said, hey, I have an office on Greensboro. I can meet you there and get my equipment, and I can get the transcript out this weekend. So they're like, okay. And then I guess Johnny had told them he would really like to meet the court reporter, which was like shocking to me. I'm like, I'm just the court reporter. And so when they brought me my equipment, well, they were going to bring it, and there was no one at our Greensboro office, and you can't get in if there's no one there. So
and it's Memorial Day weekend.
Right. So
it's a holiday weekend.
Yes. So they just brought it back to the hotel, and they said, hey, do you mind if we just take it to the hotel and you can pick it up here? And actually, it took me a minute. I didn't know how to get up here. I didn't know you had to come in the downstairs door and then go to another floor and then get to another floor.
It's a little confusing.
It is very confusing. And so they had my computer and stuff with them, and they were in the hospitality room, and Johnny was in there. And so I had to go in there and get my equipment, and I saw him, and they're like, he really wants to meet you. And I was in there for probably less than 10 minutes. And he just hugged me and thanked me again. And I hugged a couple other people there, and I got my equipment, and I came out, and I left and went home.
That's really funny. Because a lot of people are suggesting you're just out at the after party hanging out, with Johnny Depp, and that's not what happened.
Not at all. I still had from here, I had about a 50-minute drive home. So, no, that did not happen.
And before we come out to chat about this, I want to remind everyone that Judy's transcript is not the official court record. The court had their own reporter. Both parties in the case agreed to hire Judy to provide transcripts so that they can review each testimony each night. So with that being said, did she do anything wrong? I want your opinions both on this. Nafis, I'm going to start with you.
I don't think she did anything wrong. I think this would have raised more questions if she were the judge or an actual trier of the fact or a member of the jury. Then, yes, indeed, that would raise questions. But I mean, this is a court stenographer who has been sitting through a 6-week-long trial. And we saw that, even the police officers who were security for this case were saying hi to Johnny Depp. He was very friendly with the staff. And I think this is just another example of that. I think this was really blown out of proportion. And I feel quite sorry for the stenographer that, here she was in the background, just really trying to transcribe what's happening. And she's being, seen as somebody who is doing something almost criminal.
Marie, was this a wrong place at the wrong time type of situation?
I think it was, and I think I want to piggyback on what Nafis said. It would have been weird if she was the judge, but she was the court reporter, and like you said, she wasn't the official court reporter. She was a freelance court reporter they added on so that they can get their transcripts every day that the official court reporter wouldn't do. So I don't see why they blew this out of proportion, and I'm really glad that Anjanette made this about her and gave her an opportunity to come and explain the situation, because they could have canceled her, period. She works for a company. That company could have said, you know what, this negative press, we don't want to use you anymore. She's an independent practitioner, and it could have really hurt her business. And I'm glad that Anjanette, let her come on and tell her side of the story and avoid this cancel culture of this poor woman.
Yes, there's always two sides to a story. Thanks for that. All right, we have to take a short break here on Law&Crime, but when we return, we will discuss new details regarding Amber Heard's sister, Whitney, and what she is saying. Stay with us. back to For the Record. I'm Michelle Yu, and thanks so much for watching the Law and Crime Trial Network. We are continuing our review of the Johnny Depp Amber Heard defamation case today, where a verdict came in Wednesday afternoon. As a refresher, Johnny Depp sued his ex-wife for $50 million over her 2018 op-ed in the Washington Post, dubbing herself a domestic abuse survivor. Depp claimed that he was the real victim of domestic abuse, and her defamatory article cost him his reputation and several acting roles. Amber Heard countersued Depp for $100 million, arguing Depp and his attorney coordinated a smear campaign following the op-ed. Yesterday, Whitney Heard posted on Instagram a statement related to the case. It reads as follows, quote, "I still stand with you, sissy. Yesterday, today, and tomorrow, I will always be proud of you for standing up for yourself, for testifying both here in Virginia and in the UK, and for being the voice of so many who can't speak to the things that happen behind closed doors. We knew that this was going to be an uphill battle and that the cards were staked against us, but you stood up and spoke out regardless. I am so honored to testify for you, and I would do it 1,000,000 times over because I know what I saw and because the truth is forever on your side. I'm so sorry that it wasn't reflected in the decision made by this jury, but I will never give up on you, and neither will anyone who stands with you. Forever by your side. Hashtag I stand with Amber Heard." And with that, I want to get your immediate reaction on Whitney's post there. Marie, what do you think?
Like she said, I know what I saw, but she never saw Johnny put a hand on Amber, and the jurors heard that on the stand. That's her sister. Her sister's trying to secure the bag, the shopping trips, and all of that. So how is she ever going to come on and say, okay, I saw, Johnny beat up Amber? It never happened. She did what she could on the stand. She was honest. I have to give her that. But that Instagram is just her still securing the shopping trips to Rodeo.
Well, I also think that with that Instagram post, it's just showing that Amber Heard that whole party is not giving up. They're still continuing. They want to appeal. And with that, Nafis, what would the appeal process look like?
Well, I want to note, first of all, that I think it's very problematic that she has a witness from the trial actually posting that she thinks that the verdict was wrong. And I think all of this, from a legal standpoint and from a PR standpoint, is really bad for Amber Heard because it's making her look like a sore loser. The fact that her attorney is attacking the jury and that she has her sister who is a witness attacking the verdict is all really bad news for her. And that is not grounds for an appeal. In order to appeal this verdict, she has to prove that a decision that the judge made perhaps was, or that the jury made was incorrect as a matter of law. She has to show that something unfair happened during the proceedings, that either the jury or the judge or Depp's counsel did was somehow unfair to her and biased to such a level that it actually affected the verdict. Essentially, she has a very, very high bar to meet, and I don't think this is going to look good for her.
Whitney was no doubt one of the key witnesses for Amber Heard in this case. Let's remember some of Whitney's testimony from this trial. Take a look.
What, if any, observations did you make about how the statements, we're talking about the 3 statements that we're quoting Adam Waldman, impacted Amber? And I'm asking for your observations. Just tell the jury what your observations were of how these statements impacted Amber.
Objection, Your Honor. Compound, lack of foundation, speculation.
Overruled, that's fine. Thank you.
Amber has worked so hard to overcome everything that she went through in the duration of their relationship. She has really, really tried her best to move past it. And anybody that knows Amber at all knows that some of the most important things to her are honesty, integrity. Her reputation is all she has. She doesn't have piles of money and private islands or...
Objection, Your Honor. It's non-responsive.
I'll sustain the objection.
She was devastated by these. To say that they're not true, it devastated her. And also, we had just buried our mother. So Amber, she started having panic attacks randomly. She was not sleeping.
Objection, Your Honor. Hearsay.
These are your observations. Thank you. Please continue.
These statements devastated her. They devastated her because they weren't true, and they were just very, very, very much affecting her.
And you talked about panic attacks. What else did you observe that she would do as a result of these? Physical.
She would just periodically just break into tears. She I don't know how else to describe it. She was so unwell. She stopped sleeping again. She was super anxious. She couldn't relax. She couldn't sit still. It was very similar to the Amber that I had seen back in 2016 as she was trying to get out of this relationship. It launched her back into this space where she was just so physically unwell, and she cried a lot.
Keep in mind, though, during cross-examination, Camille Vasquez tried to discredit her credibility on the stand, and it must have impacted the jury. Let's watch that.
You talked a little bit about the incident in March 2013, right?
Which one?
That was the one before you went to the Keith Richards documentary set? And you were present with Mr. Depp at Orange that day?
I was.
Didn't you do cocaine with Mr. Depp that afternoon?
Yes.
And you said Mr. Depp's already intoxicated?
He was by the time I got there.
And he was fighting with your sister?
He wasn't doing much of anything. He was sat at the table. He was telling me about the fight that they had.
So he'd been fighting with your sister that day when you arrived?
That was my understanding.
And you said she had a puffy face?
Yes.
And despite all of that, you decided it was a good idea to do cocaine with Mr. Depp at that juncture?
I hadn't yet connected the dots. I hadn't yet understood what that meant or what that would do.
That was a yes? Yes, you took cocaine with Mr. Depp after all that?
I did. Yes, I already said that.
You testified that you had suspicions that Mr. Depp was allegedly hitting your sister by some point in 2013, right?
Suspicions.
And notwithstanding that, in June 2013, you were actually joking with Mr. Depp about hitting your sister, right?
Regrettably, over a text message, yes.
You were encouraging him to hit her?
I was not literally encouraging him to hit her.
But you were joking about it?
Regrettably, yes. Again, I did not have an understanding fully of what that was. I never would have said that now, knowing what I know.
But that was around the time that you allegedly became aware that he was... I don't know injuries on your sister that caused you to have suspicions?
I don't know if it was around the same time.
By the way, it was not Camille Vasquez, it was Stephanie Kalnin who did the cross-examination. So with that being said, do you think that Stephanie's cross was effective in discrediting her testimony, Nafis?
I think so, because let's look at what Amber Heard's sister was doing and what she was not doing. What she was doing was trying to say her sister was a sympathetic character, that her sister was very credible. She actually explicitly used the word credible, and that she was very close to her sister and that she believes in what her sister is saying now. During cross-examination, we saw what she was not doing, which is she could not actually point to eyewitness testimony that she saw, that she witnessed any domestic abuse, that she witnessed any acts of violence by Johnny Depp, even though she appears to have been very close to both him and her sister. And she also admits during cross-examination that she wasn't even aware of the domestic violence at the time that she was texting Depp. She says, if I knew what I knew now, I wouldn't have made a joke like that, which indicates to the jury and really to anybody watching this testimony that even though she was very close to her sister and very close to both of them during their marriage, she apparently didn't know about domestic violence then. and appears to have found out later, perhaps when Amber Heard started making the claims in around 2016.
Do juries tend to hold a lot of weight to family members' testimony, Marie, you think?
They don't hold a lot of weight because these are clearly biased witnesses. That's why when allegations are made and supported by witnesses who are employees, family members, jurors are smart enough to use their common sense to look for outside evidence that could corroborate what everybody's saying. Because then it becomes a big he say, she say, and jurors are smart enough, like I said, to sit down, look at the evidence and see, okay, how can we prove who's telling the truth based on independent verification, photographs, videotapes, things that don't lie. And in this case, it didn't help Amber at all because she was saying things that she was out of congruence with. I love him, but let me take an off-guard, humiliating picture of him and send it to my friend Rocky. I'm scared of him, but let me buy him a dagger as a gift and let him have it. It just doesn't make sense. He's a bad guy, but wait, let me do some coke with him and hang out.
Yeah,
jurors pay attention to that.
There were so many vast differences in her testimony that they just did not believe her at the end. Her credibility was just shot with that. All right, we have to take a quick break, but when we return, we have new updated information in the Georgia slain beauty queen Tara Grinstead case. We'll be right back. Stay with us. Welcome back to For the Record. We have a new development out in Ben Hill County, Georgia, where defendant Ryan Duke will now face another trial. If you may recall, last month, Duke was acquitted in Irwin County back for the 2005 murder of Georgia beauty queen Tara Grinstead. He was, however, convicted of concealment charges and is currently serving the rest of his 10-year sentence with 5 years already served. According to a new indictment released on Friday, Duke will face another concealment charge, hindering apprehension or punishment of a criminal, 2 counts of concealment of facts, and 2 counts of tampering with evidence in Ben Hill County for the same case. Bo Dukes, who was also convicted of concealment charges in this case, will also face an additional concealment charge and hindering apprehension or punishment of a criminal in Ben Hill County later this month. And I want to bring in my guests, Marie Pereira, criminal defense attorney, former prosecutor, and Nafis Syed, Law&Crime legal analyst, to discuss these new developments. Nafis, I'm going to start with you. Both Ryan Duke and Bo Dukes are being indicted for another concealment charge, but in a different county. Could you explain how this is not double jeopardy?
Well, actually, this does raise major flags for me on double jeopardy, which is that you can't be convicted of the same crime twice. And this is true. There's a difference between state law and federal law. So you can be convicted of the same crime in federal law and in state law, but both of these involve state law. So that's why it's slightly problematic. I think the way that the county can differentiate this from the previous convictions and acquittals is if the new charge is based upon a different set of facts or based upon a different circumstance that doesn't actually intersect with what was already tried successfully in Irwin County.
Now, Marie, the jury has to overlook the fact that both defendants have already been found guilty on similar counts related to this 2005 murder of Tara Grinstead at trial. What do you suspect being the defense's strategy here?
I think that they're going to have a problem with the fact that these charges were already filed and they were indicted for almost the same charges. And I agree with Nafis that this really raises concerns of double jeopardy. I'm not quite sure how the state is going to overcome that challenge, but I know that defense is going to be arguing, we've been there, we've done that, and these charges are unsubstantiated legally. You shouldn't be doing this.
Now, keep in mind, Grinstead's disappearance in 2005 launched a massive search. And despite the extensive investigation, there are no arrests made in this case until 2017. However, it took Ryan Duke just 90 seconds to confess to killing Tara Grinstead and burning her body. And according to the GBI inspector who took the stand during this trial, Duke's attorneys said it was a false confession and he was coerced into making it. Let's listen to this ourselves.
Just to break into people's houses, just to steal money. I was a drug addict. I've been drinking. I was high. I don't remember everything clearly. Okay. But I was stealing from a purse, and she snuck up on me, and I hit her. I didn't mean to. Purely reactionary, and I ran. I didn't know what else to do, you know, and that's the only reason I didn't come forward before. I can't lie, I can't live with myself. I'm so sick of this stuff. I think there's other people that feel the same way you do. No, sir. I'm tired, and my family's good people. I didn't want to do this to them. You know. That's temporary. You want something to drink? No, sir, I'm fine. Okay. I've thought about this. It seems like my world's been loose by a thread, and I've been holding on to that thread for so long. I'm fucking wrapped up in it. You know, you're not about that. No, sir, I'm not. Right now you are. If I'd been a man, I'd have done something. It doesn't matter when. Yes, sir, it does. Fear is fear.
But you're doing the right thing now.
You don't feel like it.
Well, I'm telling you.
You don't.
Having done this for a long time, this is very, I can see it on your face. I could tell yesterday that this was bothering you.
Now, when he got on the stand, he said something entirely different. Let's listen and discuss on the other side.
Mr. Duke, did you murder Tara Grinstead?
I did not.
Did you break into her home on October 22nd or 23rd, 2005?
No, sir, I did not.
Have you ever been inside her home at any point in your life?
No, sir, I haven't.
Did you ever have a sexual relationship with Miss Grinstead?
I did not.
Did you ever strike Miss Grinstead?
No, sir, I did not.
Did you ever choke Miss Grinstead?
No, sir, I've never choked anyone.
Have you ever been inside Miss Grinstead's car?
No, sir, I have not.
Did you ever take a pair of gloves or a glove to Miss Grinstead's home?
No, sir, I did not.
Did you see Miss Grinstead's body after she died?
I did.
Where did you see it?
In the pecan orchard.
Did somebody take you to the body?
They did.
Who took you to the body?
Bo Dukes.
Did Bo Dukes tell you that he killed Tara Grinstead?
He did.
Do you know how Miss Grinstead died?
I do not.
Were you asked to help dispose of her body?
I was.
Who asked you to do that?
Bo Dukes.
Did you help Bo Dukes move Miss Grinstead's body in the orchard?
I did.
Were you afraid that he'd hurt you or your family if you told anyone about it?
I was.
Is that why you didn't come forward prior to February of 2017?
Yes, sir.
Based on those two clips, which story sounds more credible to you, Nafis?
That's a really difficult question, Michelle, because I do think the two clips that you showed perfectly summarizes why the jury did not believe he was the actual killer. One is because his defense successfully put enough doubt in the jury that that confession that you just played was under the influence of drugs and alcohol. And by comparison, you see him on the stand and he's very lucid. He's like a different person from the actual clip. And the second reason why the jury had enough doubt that they didn't convict him of killing the beauty queen is because the defense successfully raised enough doubt in the jury that Dukes was actually the killer. And that's why Ryan Duke decided to go on the stand and point that finger at Dukes. And that's the reason why both of them are likely going to be are going to be put on trial again. I think the state is really trying to have a second try at this because from a prosecutor's perspective, when you see him on the stand and you see his testimony, he doesn't look entirely credible. And so if the state does a better job of taking away these doubts from the jury's mind, then he could be convicted of killing her.
Well, how do you prep a defendant like Ryan Dukes for trial? How do you think he did on the stand, Marie?
I think he did well because clearly the jurors bought it lock, stock, and barrel. I still, even after it happened and he was acquitted, and I look at the clips, I cannot believe that this man was acquitted because it's not like he says, you know, I was under the influence, and then you see an interrogation tape where he looks like, you know, someone beat him up and he's slurred. They took him to the scene. And I'm an RN, and I know people who are under the influence, what they look like. And he looked pretty lucid to me when he was giving his account. So I don't match up his demeanor during that field trip to the gravesite as what he's saying on the stand. I was under the influence of drugs. It just doesn't add up. And I would love to poll the jurors, get them in a room and say, what were you thinking, kind of thing.
Now, we did hear from Bo Dukes, the co-defendant, pretty briefly during Ryan Duke's trial. Let's hear what he had to say when he was called to the stand by the defense.
On the advice of counsel, I'll be invoking my Fifth Amendment right not to provide testimony.
How'd you get here today?
On the advice of counsel, I'll be invoking my Fifth Amendment right not to provide testimony today.
Judge, may I introduce Defendant's Exhibit 4? I've already shown it to the state. It's a certified copy of his conviction in the United States District Court, the federal court for conspiracy.
Yes. Are you
only under our prior objection, Your Honor.
All right. Sure, that'll be fine.
Judge, may I approach the witness?
Sure.
Thank you. Showing you what I've marked as Defendant's Exhibit 4. If you could take a look at that. Do you recognize that document?
On the advice of counsel, I will be invoking my Fifth Amendment right not to provide testimony today.
Mr. Duke, do you intend to invoke your Fifth Amendment right to every question?
I do, Your Honor.
Any reason to continue this?
No, Judge.
You be excused.
I mean, Marie, what was the point of calling Bo Dukes to the stand if he was going to just plead the Fifth?
I guess maybe to just show, to the jurors, because jurors expect to see certain witnesses. And when you don't bring them, they can use it against you if you had access to that person. So I guess they just wanted to show, hey, it's not our fault. I know we're not making sense right now, but we would have brought him in, but he just, he invoked his rights. So, I know that's the missing piece, but he didn't want to do it. It's not that we didn't think he was necessary, so forgive us. And it didn't work.
Well, Nafis, what do you anticipate happening at the next trials for Bo and Ryan? Is this justice for Tara Grinstead and her family? Because to this day, we still don't have a killer.
Yeah, it's a very sad situation because the death of this beauty queen and teacher who touched the lives of so many is still a mystery after so many decades. And right now we have two big legal issues coming up with the upcoming trials of Duke and Dukes. One is that it really does seem like double jeopardy is going to be a major part of the defense's argument, and they might easily win on that because both of these individuals have already been tried on many of the similar charges, and the prosecution has an uphill battle to show that they're going to try this case on a different set of facts. And not that they're just doing a second try because they failed the first time. On the other hand, as Marie pointed out, the actual evidence of the confession being coerced is very, very weak. We have seen case after case after case of actual coercion by the police, and those are very clear-cut cases where the individual was being bullied, was taken advantage of after a very vulnerable situation, perhaps after seeing a dead body, where the individual had a mental illness. Here, he's just alleging that he was drunk and on drugs at the time. But based on the tape, the police officer was actually pretty respectful to him. So it's unclear why, even under the influence of drugs or alcohol, you would come up with these details that actually match the forensic evidence of the case. So I think this could go either way. And I think what really hurts the state is the defense of double jeopardy. But if they do a better job this time and actually show that this isn't double jeopardy, I think they can win.
Great analysis. Very good. Thank you so much. And we're going to take a quick break here on the network, but stay with us because when we return, we will discuss the two new trials we're covering live this week. You don't want to miss it. Stay with us. This week, Law&Crime is starting 2 new trials, both out of Florida. Before our show ends here, I want to preview the next cases. Out of Jacksonville, Florida, today also marks day 1 of jury selection for defendants Alan Wade and Michael Jackson, not to be mistaken with the pop singer. Both defendants were previously convicted of the first-degree murder, kidnapping, and robbery of retired Florida couple James and Carol Sumner back in 2005, and they were subsequently sentenced to death. However, both of their sentences were thrown out after state legislature was passed in 2017, requiring a unanimous jury to recommend the death penalty. And with 2 juries in the works, the defendants will now have to face a second round of sentencing, so we will keep everyone updated on how that progresses. Now, our other trial, Florida versus Danielle Redlick. That began jury selection today in Orange County. Redlick is charged with second-degree murder with a weapon and tampering with physical evidence in the 2019 death of her husband, Michael Redlick. The 48-year-old defendant called 911 and told dispatchers that her husband had a heart attack. But when dispatchers arrived, she told them he stabbed himself after they had an altercation. Police say that the stab wounds weren't consistent with being self-inflicted and with a possible affair in the mix. We'll have to see how everything comes together. So once we get a word on a jury being selected, we will take you right into that courtroom for opening statements. But for now, let's get some details about this case from the defendant herself in 911 calls she made 11 hours after the fatal stabbing of her husband.
So did you find him this morning? Because I know you said that you believed it happened last night. Did you see him last night? Was he okay, or was...
He was not okay last night. We had altercation, and he stabbed himself, and I ran into the bathroom, and then when I came out, I tried to help him, and I saw he was lying in blood. And then I tried to help him, and I couldn't. Correct, yes. And then I tried to help him, and I woke up sitting up next to him, and I've been trying to figure out what to do.
Right. I got you. I'm going to get you some help, hon. So you all had an altercation last night, correct?
Yeah.
All right. What's your name?
Danielle.
Are there any weapons on scene now?
A knife.
A knife?
Mm-hmm.
And you said he was 64, right?
65.
I'm sorry?
65.
65. So, okay. Go ahead and give me your first name again, because I don't want to call your name.
Danielle.
Danielle. Okay, so Danielle, let me ask you this. So, did he stab himself last night and he passed last night, and you just didn't know what to do?
Correct, I believe so, yes.
Okay. Were you all drinking?
He was.
He was?
Yes, he was. And altercation was the night before, too, but I left the house and took my children with me because he was drinking then, too.
Mm-hmm. Were your kids there last night during this altercation?
No, they were not. They were not here, and they're not here now.
I know you first said that you thought he had a heart attack. So do you think it was a heart attack, or do you think it was due to the stabbing that he passed away?
Probably the stabbing triggered it, I guess. I don't know. It's a shoulder wound.
You say it's a shoulder wound?
Right.
So there you have it. Those are the 911 calls that you just heard. Now, Danielle Redlick's attorney, they are claiming self-defense here. Does she have a good case, Marie, you think?
I'm going to reserve my opinion until the entire case is presented, but I'm still stuck on the fact that she married her whole stepdad. I'm thinking, how young was she when he was married to her mother? Was there abuse? Could the abuse might have, been responsible for this alleged murder? It's not making sense to me, so I'm going to reserve my opinion. But the marrying my stepdad, I'm still shocked about that.
You're still fixated on that one, Marie. How about you, Nafis? Does she have a good case here, you think?
I don't think so, just based off of what we've heard. But again, I would need to see the forensic evidence and the stab wounds and so on, and whether those actually match up with what she's saying. As we discussed about the Depp Heard trial, forensic evidence is really key, and whether that matches up with the witness testimony. Right now, just based off of the 911 call, it's a little bit, her case seems pretty shaky if she's going to rely just on that, because she seems to be contradicting herself as she goes on, and as the 911 dispatcher asked her more and more questions. So we'll have to see how the evidence actually plays off, but she shouldn't rely on just this if she expects to win.
All right. Well, thank you so much, Nafisa Marie, for joining us. Bob Bianchi is up next with the afternoon session. Stay with us. So much more trial coverage here on Law&Crime.
jury will not be sequestered.
I'm Brian Buckmeyer along with Terry Austin.
In the Weinstein case, fellow silence breakers and any
Jury selection is moving along
Well,
here.
I'll read the verdict, says in Jesse Weber, and thanks for joining us. We don't tend to see it as raw as this. Good evening and welcome.
Welcome to the afternoon session. My name is Bob Bianchi. I'll be taking until 5 o'clock. We have a few topics we'll be talking about on the show. Of course, we continue to recap the Johnny Depp versus Amber Heard Defamation Trial. Obviously, a very fascinating case that's still captivating a nation. In other celebrity news, Mariah Carey is being sued for her hit All I Want for Christmas Is You. Can you believe it? It's an old song, but she is now in legal trouble, at least jeopardy with regard to that. Also, there's a new development in the Ryan Duke case, the case that just keeps on going. We covered gavel to gavel on the Law&Crime network. He was acquitted for the murder in Georgia of beauty queen Tara Grinstead, but now he is facing additional charges, concealment charges, in particular in the county where he said he helped Bo Dukes burn Grinstead's body. We will bring you 2 new trials this week as well, so hang on to your seat. Jury selections underway in Orange County, Florida, in the trial of Danielle Redlick. She is accused, charged with second-degree murder with a weapon and tampering with physical evidence in the 2019 death of her husband, Michael Redlick. Redlick called 911 and said that her husband had a heart attack, but when EMS responded to the scene, she indicated that he stabbed himself. The coroner is saying after an altercation, the coroner is saying that these are not self-inflicted stab wounds. So that's going to be an interesting case to see whether or not she will be able to prove that these were self-inflicted, or if the government could prove rather that they are not. And in Jacksonville, Florida, jury selection is also underway in the penalty phase retrial of Alan Wade and Michael Jackson. You may remember this case. Both defendants were previously convicted of first-degree murder, kidnapping, and robbery of James and Carol Sumner. They have to be retrialed because of this trial. They were buried alive back in 2005. They were both sentenced to death for that horrible and horrific crime. However, it was thrown out after the state legislature changed a law in 2017 that requires a unanimous jury verdict before you can impose the death penalty. So that will be a sentencing phase only. So anyway, let's get back to Johnny Depp, because that obviously is the defamation trial of the century and has a lot of blowback going on from so many different sectors after this verdict came back last week. Here is what each side was awarded. Heard was awarded for damages on Adam Waldman's second long statement when he claimed incidents of the May 2016 penthouse incident were staged. And so let's get back to that with respect to this trial, and the verdict that came in, obviously very compelling. So let's take a look at the verdict.
As against Amber Heard, we, the jury, award compensatory damages in the amount of $10 million. As against Amber Heard, we, the jury, award punitive damages in the amount of $5 million. 3. As to this statement, appearing in the April 27, 2020 online edition of the Daily Mail, quote, "We've reached the beginning of the end of Miss Heard's abuse hoax against Johnny Depp," end quote. Do you find that Ms. Heard has proven all the elements of defamation? Answer, no. As against John C. Depp II, we, the jury, award compensatory damages in the amount of $2 million. As against John C. Depp II, we, the jury, award punitive damages in the amount of $0.
Obviously, the community debating whether or not this verdict is something that's positive or not with respect to domestic violence cases. I find this kind of commentary very interesting. We'll certainly get into that with our great guest that we're going to have here. Interestingly enough, the Washington Post added an editor's note to the top of the Amber Heard's op-ed that reads as follows. In January 2019, Depp sued Amber Heard for defamation arising out of a 2018 op-ed. On June 1st, 2022, following a trial in Fairfax County, Virginia, Circuit Court a jury found Heard liable on 3 counts, the following statements which Depp claimed were false and defamatory. I spoke up against the sexual violence and faced our culture's wrath. That has to change. Then 2 years ago, I was a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. The jury separately found that Depp, through his lawyer, Adam Waldman, defamed Heard in one of her 3 counts in the counter lawsuit. So that's pretty much what we got right now. Let me introduce our guest that we have. Mitra Ahorian is an entertainment attorney. Mitra, welcome back to the show. I think this is, a lot of people are saying that this case is only about the celebrity of it. Of course, there's that element to it, but there's also messaging that's going on from both camps. Interestingly enough, Amber Heard's camp is doubling down on these statements, which I find, at least from a legal point of view, perhaps very dangerous, especially given the fact that a jury came back with a verdict that clearly established they did not believe Amber Heard, because even a single instance of domestic abuse, even a single one that they believed, would have made her statements true with regard to the defamation case. And if there was a single instance of sexual assault, it would have made it true. But they came out right out giving all damages on all 3 counts of Johnny Depp, which by definition means they did not believe Amber Heard's story. So one, as an entertainment specialist, do you find it odd that they're doubling down on these statements, potentially creating more of a slander suit? And where are you falling on this thing where people are saying this was a setback for the Me Too movement and women in particular in domestic violence? Could it be argued that perhaps it's a setback when people come into court and don't tell the truth and accuse somebody of something they didn't do?
Yeah, I'll take that second one first. I disagree that it's a setback. I actually think that it opened up a conversation that needed to be had, and that is the weaponizing of the threat of sexual abuse or the threat of physical abuse, which tends to happen. And I think that that's something that with the Me Too movement, we sort of shut a blind eye to in order to make up for the fact that we weren't always believing women. So maybe the pendulum is now swinging back to have a more honest and real conversation about how these things actually happen. And they're quite complicated. They're not always, a Harvey Weinstein situation. Sometimes they come up in the context of a relationship. And that's when things get really complicated with the psychology of how 2 people find one another. So I think that I don't think it's a setback. I think anything that opens up honest discourse is always a good thing. And you'll have to remind me of that second question.
Yeah, well, let me drill down on that one. I mean, Mitra, this is look, as a prosecutor that prosecuted domestic violence cases, domestic violence homicides that ultimately turned into murder cases, I mean, we all know in the business, there are times that people make false complaints, whether or not it's because they're trying to get a tactical advantage in a divorce or a custody battle, or they're agitated for whatever reason, maybe even some of them believing it, but the objective evidence that comes out during the case just does not support it. And we've had many people who have recanted their domestic violence allegation after we as prosecutors developed information, initially pursuing them as a victim, saying, wait, this doesn't make any sense, it's contradictory to the information you gave us. And then they say, well, I made it up because, I was mad, I was angry. The thing that bothers me as a trial lawyer is that, look, we cover this gavel-to-gavel here on this network, and not that the court of public opinion means anything in terms of, these devices here and what people are saying, but many of the legal analysts and many of the hosts of the show saw that Amber Heard's credibility was significantly impaired, and we were not in that jury box watching the demeanor of the witnesses and the manner in which they were. So I kind of find it offensive when people say it's an insult to domestic violence abuse victims. We don't want that, of course, but the fact is the jury didn't believe it. And where are we getting in a society when we no longer accept that people can have a contrary view than yours with regard to what the facts are? Don't facts matter anymore?
I'll say this. One of the things that I was wondering the entire time that we were watching this trial, sort of on the outside, quote unquote, even though we had the cameras in the courtroom, there's something different to being in that physical space. And of course, we don't see all of the reactions, and we did not see the jury to see how they were reacting. And, one of the questions that's coming up on this appeal is, how much did we experience that is different from what the jury may have experienced? And that was a question I had all along. And so it's really interesting to see that, perhaps human beings have this sort of instinctual or innate ability to pick up on when someone is lying, regardless of what is being presented to them, and perhaps the influence of being in that environment, which is different from what we're seeing on the screen, because we're, of course, a lot of people are seeing bits and pieces of it. They're not seeing the entire thing. And there's also this tidal wave of people who are overwhelmingly calling Amber Heard a liar, that presumably we have to assume the jury did not see these things. So at the end of the day, like you said, it comes down to her credibility. It was not a hard task for her defense to show that there was one instance of abuse. I think anyone watching could probably argue that perhaps there was one instance there. We could probably find something, maybe not in the stories that were told, but in some form. Johnny Depp acknowledged that it could be a psychological, emotional, other types of abuse. So not a hard task. So at the end of the day, like you said, it was a rejection of her entire statement. And if you can't believe someone, how do you know what parts to believe and what parts you can't believe?
Yeah, I just think in a country, I don't know, we become so politicized with our legal debates. We're in the courtroom, and we know darn well when we have high-profile cases that are reported on that despite even how much the reporter wants to do the right thing, the feel in the courtroom is much different than what actually gets out into the public. Even when you have a camera inside that courtroom, I've had it occur myself. But nevertheless, the bottom line is facts should matter. I don't think it sets Me Too back at all. We should certainly aggressively handle those cases. But when the facts don't support it, there should be findings such as this, and then we let juries decide that. That's what happens everywhere. It's almost like saying, well, if you're a criminal defendant and you're found not guilty, the whole system's falling apart. Everyone should be found guilty that's been charged with a crime. Anyway, I won't go on my soapbox much longer about that. Let's look a little bit at the Johnny Depp closing arguments and see where they fit in terms of what ultimately the jury did.
Mr. Depp wasn't canceled by Hollywood because he was sometimes late to set. He was canceled because Ms. Heard falsely accused him of domestic violence and sexual violence on the pages of the Washington Post on December 18, 2018, repeating the prior lies of May 17, 2016. And as you saw at trial, Ms. Heard published the op-ed on December 18, 2018, 2 years after her public allegations of domestic abuse. Ms. Heard's publication of the op-ed coincided with the release of her major movie Aquaman that December. And it coincided as well with her announcement on Twitter that she was becoming an ACLU ambassador for women's rights. And in that op-ed, Ms. Heard repeated her false allegations against Mr. Depp. Now, she didn't mention his name. She didn't have to. Everyone knew exactly who and what Ms. Heard was talking about. Ms. Heard got on the stand and tried to tell you that the op-ed was not about Mr. Depp. She then said, well, it wasn't just about Mr. Depp. But she couldn't deny, and this was yesterday, that this was at least partly about Mr. Depp. The op-ed obviously is about Mr. Depp, and the testimony at trial proves that. You will recall testimony from the ACLU's representative, an attorney, stating that Mr. Depp's name was included in drafts of the op-ed, and that they and others understood that the op-ed was about Mr. Depp. Specifically, the ACLU representative testified, among other things, quote, based on my review of prior drafts of the op-ed, I knew that she was referring to Johnny Depp and the marriage, unquote. Ms. Heard's claim that the op-ed is not about Mr. Depp is just another one of her many, many lies. In fact, what you have seen time and time again through the course of this trial is that Ms. Heard lies. She lies all the time about things that are important and the things that aren't important. She just can't seem to stop. And as Ms. Vasquez said, what she routinely does is she doesn't take ownership or responsibility for anything, and she has an excuse for everything. But in this courtroom, confronted with the evidence, she can't run away from her own words. As my colleague said, words matter, and Ms. Heard is condemned by her own words.
Okay, part of the closing argument. I also have Adam Conta with me, criminal defense lawyer. Adam, talk to our audience about the importance of your credibility as a lawyer when you are making arguments and opening statements, and do you think that the credibility not only of Amber Heard but her legal team, because it's 1 in 1A when you're in that courtroom, was impaired or damaged when there was the argument that, well, they can't even prove it was about Johnny Depp, and yet all this avalanche of evidence came through, including out of the mouth of Amber Heard on the witness stand, that it was about Johnny Depp. How does that have an effect on a jury's decision?
Yeah, of course it does. Credibility is king, right? And so, for instance, like I don't do opening statements a lot. If I can get out what I need to get out in front of a voir dire, in front of jury selection, then I might choose not to do an opening statement at all, because it's not my burden to prove anything. It's the prosecutors. And in a situation like this, point being is that you're promising to a jury when you give an opening statement. So you need to deliver on those promises. Now, if you're going to make as part of your promise, hey, she's the victim here, but she never said that it was him specifically, you can't prove it was him, then you're losing credibility by omission. You're telling something that the jury knows already is patently true, and you're trying to kind of play both sides. You can't do that. Even if you technically can, you're going to blow your credibility in the process. So your opening statement is so important because you're building that relationship with the jury, what you've already tried to build on while selecting the jury. So this is the first time you really have to really give a full-throated speech to the jury and really lay out everything you want to do and everything you intend to prove and anything you intend not to have proven. And so it was a big hit, I think, when you start out by such a critical element and you're kind of being cagey about it, because that's how it comes off. It comes off as cagey, and that's not a word you want associated with yourself as a lawyer.
Yeah, no question about it, Adam. Okay, guys, appreciate the commentary. We're going to take a quick break because we got a lot to cover here at the Law&Crime Network. Stay with us. We'll be right back. Welcome back to the afternoon session. Just about 2 weeks ago, Ryan Duke was found not guilty on all counts in the murder of Georgia beauty queen Tara Grinstead, except the 6th count, concealing her death. He was sentenced to the maximum 10 years in jail for that final count, and he's eligible for parole due to 5 years already being served in prison. Now, he's been indicted in Ben Hill County, where the pecan orchard where they said they had helped to burn Grinstead's remains is located. He is facing similar concealment charges that Bo Dukes faced that landed him 25 years in prison. So this is really an amazing case. And, you know, Ryan Duke actually took the witness stand in his trial where he was acquitted. So it's a bold move. And keep in mind, with Ryan Duke, he had given a confession to police. So the defense attorneys had to kind of work around saying that that was a false confession. Let's take a little listen to Ryan Duke on the witness stand.
Mr. Duke, did you murder Tara Grinstead?
I did not.
Did you break into her home on October 22nd or 23rd, 2005?
No, sir, I did not.
Have you ever been inside her home at any point in your life?
No, sir, I haven't.
Did you ever have a sexual relationship with Miss Grinstead?
I did not.
Did you ever strike Miss Grinstead?
No, sir, I did not.
Did you ever choke Miss Grinstead?
No, sir, I've never choked anyone.
Have you ever been inside Miss Grinstead's car?
No, sir, I have not.
Did you ever take a pair of gloves or a glove to Miss Grinstead's home?
No, sir, I did not.
Did you see Miss Grinstead's body after she died?
I did.
Where did you see it?
In the pecan orchard.
Did somebody take you to the body?
They did.
Who took you to the body?
Bo Dukes.
Did Bo Dukes tell you that he killed Tara Grinstead?
He did.
Do you know how Miss Grinstead died?
I do not.
Were you asked to help dispose of her body?
I was.
Who asked you to do that?
Bo Dukes.
Did you help Bo Dukes move Miss Grinstead's body in the orchard?
I did.
Were you afraid that he'd hurt you or your family if you told anyone about it?
I was.
Is that why you didn't come forward prior to February of 2017?
Yes, sir.
Okay, so acquitted of the murder, that's the big charge. Family very upset, and they're happy that there's been another indictment, hoping that there can be convictions for some of these other offenses that they can tack on to the sentence that he's currently serving. He's currently facing the following new charges: concealing the death of another, hindering the apprehension or punishment of a criminal, concealment of facts, 2 counts, tampering with evidence, 2 counts. Bo Dukes, who's obviously also involved in all this, each pointing the finger at the other. Bo Dukes' second trial for similar charges, he's already serving time in jail for that. So let's take a look back at Ashley, but he's got an open indictment as well. Let's take a look back at Ashley Merchant's closing argument that gave Ryan Duke the actual acquittal, if you will, in terms of some of the questions that she was asking in his first trial, asking, has the state been able to answer these questions for you? May have been a powerful moment. Lawyers like to be able to sum up based upon the failure of the prosecution to fill in blanks. Let's take a listen.
I've written out in my terrible handwriting some questions that I challenge the state to get up here and answer for you, because you deserve to have an answer to these questions. How does the glove corroborate how Miss Grinstead died? Cause of death. Something they have to prove beyond a reasonable doubt. How does the glove corroborate that Ryan caused her death? I asked Agent Chanel these questions, and he said it doesn't. He said there's no evidence of this. How does the glove corroborate that she died in Irwin County? A glove that did not appear until Monday morning. How does the call corroborate, this 411 call? How does it corroborate the cause of death? Remember, the law says his statement has to be corroborated. So they want you to believe that that one statement is the statement that is the Holy Grail, and they have to corroborate it. How does that call corroborate that Ryan is the one that killed Miss Grinstead? How does it corroborate that she actually even died in Irwin County? What proof beyond a reasonable doubt has the state brought you to prove Ryan's statement to Agent Chanel was accurate. Because everything you heard from the witness stand was that it was not. That it was a mess. It was all over the place. What evidence has the state brought you to disprove Ryan's sworn testimony in front of you beyond a reasonable doubt? They have to do all this. They have to answer all these questions. And again, I don't get to get back up here. So I leave these questions and challenge the state to try and answer these questions, because everybody deserves, they're asking you to convict a man of murder, and they can't answer these questions. And the law requires that.
Well, Mitra, we know the end analysis here. He was acquitted of that murder. Some people are in complete shock based on the evidence that came out in the case. And of course, like I indicated before, he gave a statement, the police arguing and the prosecutors arguing. He gave information confessing to things that weren't out in the public, things that only the murderer could know. But nevertheless, he was acquitted. What did you think of the defense attorney's closing argument, and any insights you have into why the jury may have acquitted him on that charge?
Yeah, that was very interesting to me. You know, with respect to the defense, I think that, you know, highlighting the fact that there wasn't corroboration and also highlighting the fact that the burden was on the prosecutor, I think those were strong. But whether the entire closing was strong enough, I mean, clearly, no. As far as this particular, as far as the not being convicted of murder on the initial case that was in Irwin County, I mean, I think that was one that, like you said, the family was very disappointed of, and I'm glad that they're having a second chance at this to potentially add more years to that sentence.
Adam, something else that she had mentioned in her closing arguments that I thought was interesting, and as a homicide prosecutor used to kind of unnerve me when I had these cases, is that there really wasn't an establishment of the cause and manner of death beyond a reasonable doubt. The lawyer argued that, but she also argued an interesting jurisdictional question. Did they prove to you it happened within this county, and you must find that beyond the reasonable doubt? And I've had a couple of trials where there was some confusion as to whether the murder may have been in our county or in another county. Do you think that it could be something technically like that, where they were like, we're just not convinced where it occurred, but we believe he did it? Is that possible?
It's possible, but, you know, I think we should give more credit to the job done here. There were holes that were significantly punched, and at the end of the trial, those holes remained. This isn't, you know, our system is not prove every possible, you know, if you think he did it, then he's guilty. It's proved beyond a reasonable doubt. So yeah, there was a confession. There was evidence that wasn't known to the public. Could he have learned that from someone else? Maybe. But there were big holes that remained at the end. And so if you highlight those big holes, even if you've gotten 75% of the way there, if you've got 25% that's just up in the air, that's reasonable doubt, right? So the jury did what it's supposed to do. You know, I disagree that there's now this new bite at the apple and that they could add more time, and that's a good thing. I mean, this to me smacks of double jeopardy, and I have still yet to see why there's new laws and new evidence that would require that they go back to trial in a different county. This is sour grapes to me. You're going to get 10 years out of a concealment of a body. That's a pretty hefty sentence for what he's accused of. If you think he did more than that, then get in a courtroom and prove it. And you couldn't do that. You thought you had everything you needed. You went in there with the confession and thought that was it. You weren't prepared to adjust and really prosecute the case to the point where you're beyond a reasonable doubt. And now you want more time added on. To me, I don't like the way this smells. I don't like the way it looks, and I haven't seen any evidence as of yet that would tell me why this is such new and important evidence that it would yield a new trial.
Yeah, I really appreciate that. I was thinking the very first thing that hit me about that double jeopardy argument. I think a lot of people don't really understand what that is. So hopefully we'll get an opportunity to talk about what it means, not just in concept, but how it actually plays out in practice. And last point I'd like to bring out, the defense lawyer is saying that it's just a confession that wasn't corroborated. In most states, a mere confession alone is not enough to convict. There has to be an additional evidence, just however slight, and that's why the lawyer was saying it was just a confession without any other evidence. Great commentary, guys. Appreciate it. But we don't go anywhere. We're going to take a break, but we're going to be back to Johnny Depp for some more of the more fascinating aspects of this case and actually some new developments that have occurred since the trial. Stay with us. welcome back to the afternoon session. My name is Bob Bianchi. If you take it to 5 o'clock, so we're going to be peppering in the Johnny Depp Amber Heard case. One of the things trial tactically that's very, very difficult for lawyers to make a decision, you know, you got to kind of go on feel of a case, is the rebuttal cases. And in this particular instance, the jury got to listen to each Ms. Heard and Mr. Depp a second time, and some of the most emotional testimony that came out during those rebuttals, interestingly. Let's take a listen to a little bit of Johnny Depp on rebuttal.
Mr. Depp, what has it been like for you to listen to Ms. Heard's testimony at this trial?
I'm sorry?
What has it been like for you to listen to Ms. Heard's testimony at this trial?
Objection to relevance, Your Honor.
Oh, overruled.
Insane. It's insane to hear heinous accusations of violence, sexual violence, that she's attributed to me, that she's accused me of. I don't think anyone enjoys having to split themselves open and tell the truth. But there are times when one just simply has to, because it's gotten out of control. Horrible. Ridiculous, humiliating, ludicrous, painful, savage, unimaginably brutal, cruel, and all false. No human being is perfect, certainly not. None of us. But I have never in my life committed sexual battery, physical abuse, all these outlandish, outrageous stories of me committing these things and living with it for 6 years and waiting to be able to bring the truth out. So this is not easy for any of us. I know that. But no matter what happens, I did get here, and I did tell the truth, and I have spoken up for what I've been carrying on my back reluctantly for 6 years.
Adam, I want to go to you on this question about criminal law. She accused him of some pretty violent sexual offenses that, if a prosecutor were to believe it, could land him, I'd imagine, in jail for a considerable period of time, because all state laws, certainly in Jersey and New York, and I'm sure everywhere else. So whenever you have a client who faces potentially within the statute of limitations a possible charge by prosecutors, most defense lawyers try to stay away from civil courts, where you, especially if you bring the case, then you have interrogatories you have to answer, depositions that you have to answer, courtroom testimony that you have to answer to, and a slip of the tongue or a slip of the lip could cause you to wind up in some serious criminal law jeopardy. Talk to me about what you think that conversation looked like amongst his attorneys, and does that in your mind weigh into that he really believed in his cause and brought this forward for that, partially for that reason?
Oh boy, does it weigh into my thinking that he, I don't know. Because here's the thing, let's keep in mind, this is not the first trial, right? Mm-hmm. This is his second bite at the apple. He lost in the UK, where the UK said essentially, no, we think you beat her up 12 times. And so to come now into this arena, I think the once you put something into motion that's this big, it's hard to undo it, right? So I guarantee you, to your question, that somebody along the way, he had a team of people along the way that said, hey, if you go down this path, if there's any real substantial proof of the sexual violence, let alone just the domestic violence, this could create a legal mess for you criminally. But you look at these people, you hear the testimony, and I know this isn't what you asked, but I mean, would you take these people on as a prosecutor? You're a former prosecutor. You got people, what I took away from this trial, these are two people that I wouldn't want any of my kids being in a relationship with. These are people who treated each other very poorly and put themselves in really bad positions. I think both of them were not telling the truth. So if you don't think they're telling the truth, you don't want to prosecute that case, right? Yeah, of course. But we only found out about that after the trial had occurred and we listened to the testimony. I'd be more worried about Johnny Depp making a statement or saying something that may, dot an I or cross a T for prosecutors. But nevertheless, they made it through. Mitra, let me ask, something I find very interesting about Depp's testimony, and from a clip that we watched before, is he was on the stand and took responsibility for his actions. He's actually self-deprecating in many sense about his drug use, and he even said that this is not easy for any of us, kind of alluding to Amber Heard as well, where there had been an argument that Amber Heard took no responsibility for anything, even though those tapes clearly showed there was a mutual, at least at a minimum, combative domestic situation going on between them. Do you think that affected the jury to see the demure, willing to accept responsibility, and almost even saying it's not easy for any of us, Johnny Depp, versus the Amber Heard stoic, I'll look directly at the jury, not move my attention from them, not accept any responsibility? Do you think that was moving to the jury?
I think that was key. I think that Johnny Depp holding himself accountable for the flaws that we all saw, that was going to be undeniable to anyone who heard any of it, knowingly putting all of that on the stand, it was key that he held himself accountable to that. And with respect to Amber Heard, I think her biggest mistake was not holding herself accountable to any of it. It was purely seeing herself as a victim, not seeing her role, even despite the fact that we are hearing recordings that are telling us that she played a part in this. She still called herself the victim. She still said, I did these things because I was a victim. And I think had she not taken that stance, we would have been able to relate to her and have compassion for her in the way that people had for Johnny. He was very deliberate on the stand. I think it was smart for his lawyers to get him up there as often as they could, because he was the star of the show, so to speak. And the more he went up, the more he seemed believable, because he was very thoughtful with his words, and he was very convincing as someone that was real, whether you believe him or not.
It was real. We're all people. We all have problems. It reminds me of the Maya Angelou quote. It's not what you say, it's not what you do, it's how you make me feel. And he may have really related to people when he talked about his flaws in the way he did. But listen, he talked about how difficult it was for him, and Amber Heard on rebuttal did the same thing, how this instance, all these instances of behavior based on her allegations as well as this trial have meant in her life. Let's take a listen.
Amber, how did Mr. Depp's statements and threats to you that you were discussing, how do those continue to manifest themselves today?
In the harassment and the humiliation, the campaign against me that's echoed every single day on social media and now in front of cameras in this room. Every single day I have to relive the trauma. My hands shake. I wake up screaming. I have to live with the trauma and the damage done to me. My friends have to live with a set of unspoken rules about how to not scare me.
Objection, hearsay.
Yes, sir. Unspoken rules.
Overruled. Go ahead.
about how to not touch me, not to surprise me. My intimate partners have rules about how they can deal with me, how they can touch me. I have rules for doctors and medical professionals I see, gynecologists I see. I live my life with these sets of rules that I have to follow, my friends have to follow, for me not to have a panic attack or a triggering event where I relive the trauma. Even if I'm training to do my movie, for instance, if I'm training for Aquaman, a combat scene and a trigger happens, I have a meltdown and have to deal with that. The crew I work with have to deal with that because of the damage I walk around with every single day from what I've lived through, from what I've survived. I'm not sitting in this courtroom snickering. I'm not sitting in this courtroom laughing and smiling and making snide jokes. I'm not. This is horrible. This is painful. And this is humiliating for any human being to go through. And perhaps it's easy to forget that, but I'm a human being. And even though Johnny promised that I deserve this and promised he'd do this, I don't deserve this. I want to move on.
Adam, are you buying it? I mean, part of the testimony in this case is that she contacted people when she went for a TRO and potentially had fake bruising. I mean, this is what came out. She's the one who wrote the op-ed piece and put her life into the whole public arena, which created this. And now she's talking about these rules that she has and the meltdowns that she has. Isn't it kind of consistent with what Johnny Depp's psychologist was saying about the personality disorder? Not all people with that personality disorder do these kind of things. Were you buying that statement? Do you think the jury did?
Well, I think the jury didn't like her. You know, whether they bought it or not, I think let's start with that, because that's ultimately what the most important thing here is, I think. They didn't like her. I think it put them off by her constantly trying to look at them, and they clearly didn't connect with her, and she was really trying to connect with them. I think that's very different than, do I believe her? I believe that he beat her up, probably many times. I think that he is a better actor. He was much more poised on the stand. He had less to lose, quite honestly. And he had a much larger public media machine behind him than she did. So they were dealing with different types of harassment, regardless of who was guilty and who was not guilty of the offenses they accused each other of. But in that moment, yeah, you see genuine emotion, whether or not it's being amped up and presented in an uncomfortable way for a jury to watch is probably what ultimately happened here. But listen, if you ask me if I believe her, yeah, I believe her. I think it was the right result potentially, but I still believe her.
All right. Well, we'll have to see if those jurors start talking about whether or not that's where they came down on, whether they believed it or not. All accounts would be that they probably didn't, but reasonable minds certainly can differ. Listen, today is a show, it's like a minestrone. You got a little bit of this, a little bit of that, a little about the other. So we're going to come back on the other end and add another ingredient. Mariah Carey, lawsuit filed against her, if you can imagine, for a song that she's had out there for a long time and is very popular. We'll get to it on the other end of the break. Stay with us. Okay, we have another celebrity case to talk about. Mariah Carey, along with Sony Music, is being sued for copyright infringement for her hit, All I Want for Christmas Is You. You have to have heard it. It's been going on for 30 years, and it controls the radio airways every holiday season. Songwriter Andy Stone is looking for at least $20 million in damages because he wrote a song of the same title 5 years earlier for Vince Vance and the Valents. I hope I got that balance. I never heard of it. But anyway, this song also still gets played on Christmas radio. So, guys, Mitra, let me go to you. What is this about? Why is this suit being filed within 30 years ago? Why is it within the statute of limitations? Is it going to survive?
I want to know why it's being filed now. This is a case this is a song that was written in the 90s. And there was no attempt to even contact Mariah Carey or her team until 2021. So we got to ask that question. Why? I don't know the answer to that. But, it's very interesting because most copyright infringement lawsuits for songs are brought because there's a similarity in the melody. That's kind of one of the most common things that we see. In this case, there's arguably no similarity in the melody, no similarity in the lyrics, and really the same title, which, we know that copyright titles in general are not protected under copyright laws. They are sometimes. There's some cases where they are, but in this case, it would not qualify. And there are, in fact, many other songs with this same title. So it's really interesting. The timing is interesting. The arguments are interesting. I don't think they're strong. Where it's filed is interesting. I think there's so many elements of it that just kind of scream for a frivolous lawsuit.
Adam, if they get past that, I would imagine right from the beginning, if their procedures in this state allow, there's going to be a motion to dismiss it outright for failure to state a claim. We'll wait to see if that happens. But is it your opinion, being the transactional people that lawyers can be at a certain point in time, that the lawyers turn around and say, look, we're looking for nuisance money here. It's going to cost you all this money to litigate. Let's tie this thing up and go away and hope he puts a couple dollars in his pocket. Any thoughts on that?
Yeah, sure. That could be their hope, but that's like a stupid hope, right? It's much like this lawsuit, because Mariah Carey probably has a lot more resources and a lot better lawyers than what's his name, whose name I've already forgotten. And so I don't know why she would try to give him a bone on any of this versus fight it tooth and nail, because it's ridiculous. Even though, Mitra, I didn't like the tone she put on when saying the 90s. It wasn't that long ago, but it was a bit ago. You've had 28 years or whatever to file this lawsuit. If you felt aggrieved by this isn't the first year it's been popular, obviously. My wife will let me know every year when it's time to start playing that song, and then I hear it everywhere I go. It's fine. I love Christmas music, and I love the song. But he's clearly had plenty of time, clearly had plenty of opportunity. There's, no melody, no lyrics the same, a song title which doesn't seem protected. I wouldn't give a dime of nuisance money to this, and I would spend millions fighting it just to prove a point.
I got 15 seconds, Mitra, if you could tell me. No statement yet from her, and maybe she just doesn't want to get mixed up in this and let this add fuel to the fire. Give me 10 seconds of whether you think that it's just ready to part ways and get it over with.
Listen, if Led Zeppelin won the Stairway to Heaven lawsuit, then she could very easily file a motion to dismiss and win this lawsuit. So I think she's going to stay quiet on it and let her lawyers do their thing and slap this down.
Yeah, sometimes, when you're the big shot, you got to worry about getting, on the ground with the dog, because you may catch the fleas, as they say. We'll see what happens, but I'm sure the lawyers will be responding to it. Mitra, I know you got to go. I greatly appreciate your commentary. We're going to be back on the other end, so please stay with us. afternoon session. My name is Bob Bianchi. We'll be taking it to 5 o'clock today. So I want to let you know about some of the other things that are going to be going on this week. We got a lot on the plate. Jury selection is underway in Orange County, Florida for the trial of Danielle Redlick. She is charged with second-degree murder with a weapon and tampering with physical evidence in the 2019 death of her husband, Michael Redlick. Redlick called 911 and said her husband had a heart attack, but when emergency response personnel arrived at the scene, she told them that he stabbed himself after they had an altercation. However, the stab wounds were not consistent with self-inflicted stabbing. According to the autopsy that was done, she faces life without parole if convicted. 25 jurors made it through the media exposure round and will be back tomorrow along with 50 new panelists. And in Jacksonville, Florida, jury selection is also underway in the death penalty phase retrial of Alan Wade and Michael Jackson. Both defendants were previously convicted of first-degree murder, kidnapping, and robbery of James and Carol Sumner. The retired couple were buried alive back in 2005. They were both sentenced to death. However, that was thrown out after the state legislature passed a law in 2017 that required a unanimous jury verdict in the death penalty phase of the case, in which these two defendants were not a unanimous verdict. But right now, let's continue looking back at the Johnny Depp versus Amber Heard trial. So we are going to look at something from Whitney Henriquez, Amber Heard's sister, who posted on Instagram for the first time since this trial started. We'll share that post in a second, but let's look back at her testimony when she was testifying on behalf of her sister Amber about Depp's overall behavior with her sister.
What, if any, behavior changes did you observe when Mr. Depp had been drinking alcohol or using drugs?
Like I said, it was, a completely different version. He was almost unrecognizable when he was drinking and using to an excess. If it was alcohol and Coke, he would slur. He would go on these paranoid, delusional rants about things that didn't make any sense. His speech would be slurred. I almost never knew him to use cocaine without drinking. Those were generally combined. When he would smoke weed, he was much more relaxed. He was kind of what you would expect, happy on a couch, laughing. But when he was drinking, he would just get very angry, and he would just say really nasty, unkind things, and it almost didn't, usually about Amber, sometimes about me, but it almost didn't matter if she was in the room or not. He would just say really horrible, horrible, horrible things about her or to her.
Can you give the jury a few examples that you can recall?
Pardon my language. He called her a used up trash bag, slimy whore, saggy whore, was thrown out a bunch, just horrible things like that.
Well, as you can imagine, Johnny Depp testified about the relationship between Amber and her sister Whitney, who we just saw on the witness stand right now, and said, no. Amber Heard was actually abusive to her sister, testifying about an instance in which Amber threw wine in Whitney's face. Let's take a listen.
And how do you know that?
Well, I witnessed quite a lot of it. The wine in the face was something that happened in New York, which I think that even made it into the papers. I believe that even made it into the papers. It was in an elevator.
How did you first learn about that incident?
Missouri told me in detail.
What else did you observe of Ms. Heard and her sister Whitney's interactions during your relationship with Ms. Heard?
They were just constantly up and down, but I could sense, I could feel that Whitney was trying to please her sister, trying to be up to snuff, and it just seemed like she got shot down.
Objection, Your
time.
Honor. This has gone beyond the scope of the question or his foundation for knowledge of that.
Your Honor, I asked what he observed, between them. I think this is responsive to that.
And his testimony as to what Whitney felt is...
I'll sustain the objection. Next question.
Okay.
Okay, so keeping all this in mind, here's part of what Whitney Henriquez posted on Instagram. I still stand with you, sissy, yesterday, today, and tomorrow. I will always be proud of you for standing up for yourself, for testifying both here in Virginia and in the UK, and for being the voice of so many who can't speak to the things that happen behind closed doors. So this is definitely something that many other things that she puts in this very, very long Instagram post. So let me go to my guests right now. We have Adam Conta, that's still with us, a criminal defense lawyer, and Nicole DeBoard, who is a criminal defense lawyer and former prosecutor. The statement was rather lengthy on Instagram. Nicole, let me go to you first. Why? I mean, the whole argument was that we didn't want to relive this trauma, and I understand that there's been a verdict going on, but it seems like they want to still relitigate the case, and this is more about the court of public opinion than it is about the rights of people who are the victims of domestic abuse.
Absolutely. I mean, anytime you've moved over to social media to continue talking about this trial as one of the witnesses or participants in the trial, you're still seeking attention, in my opinion. And it appears that Amber Heard really can't get enough attention, and her sister posting about it is just one more piece of that, and even making statements that are very broad this time, but still definitely directed to the conduct, could potentially be problematic for them in the future.
Yeah, Adam, what do you think about this? I mean, are these ill-advised statements, or do you believe that they are working perhaps with a public relations team? We know that Amber fired her public relations people in the middle of the trial, got new ones, and they're just trying to counter the message out there because, at least from where I see it, when you look anywhere in any of the social media platforms, Johnny Depp is clearly, without any question, decimating Amber Heard in that court of public opinion.
Right. So why aren't we talking about that instead? Why can't it be a third option? That she's just a sister who saw her sister go through something horrible and is saying something genuine, that she's still going to support her sister and she's proud of her. Why can't it just be that simple? I don't think it's some shady, shameless plot for attention that should be careful, that she needs to be worried about litigation herself. What is she saying here? She's saying she's proud of her sister and that she's still going to stand by her. Johnny Depp released a statement afterwards, a very lengthy statement, taking her to task, and he should have. He just won the trial. But when you just said it yourself, right? The court of public opinion is not split on this. The court of meme opinion and Instagram and TikTok and Twitter opinion is even more biased towards Johnny Depp. Now, whether they should or shouldn't be, I've said what I think about that. But it's clear that the public has decided this case, regardless of evidence and facts. There are so many voices out there. To pinpoint this Instagram post, which only really says, I support you and I love you and I'll continue to do those things, and to try to make it seem nefarious, to me, it's just a sister, guys.
I don't think, Adam, certainly I didn't mean to indicate it's nefarious. What I'm saying is that there is a meaning and motive attached to it. Do you genuinely believe the sister put that out there without consulting Amber and her public relations team?
I think it's certainly possible. If Amber Heard had put it out there, I think that would be one thing. But, how many layers away do we get before we attribute every statement said to a carefully prepared presentation for the public versus just what most of us do is we post on Instagram or Twitter or TikTok when we're on the bathroom, on the subway, doing whatever else. I mean, this is obviously a more thought out statement, but I mean, if she had a really successful public relations team, then they would have prepared her to testify much better, and she wouldn't have acted the way she did on the stand, right? So I don't think we need to look too far into her public relations team and their success rate. Right
well, we all know, Adam. I love that commentary. It's beautiful, but we all know, and we've all been there, that you have witnesses sometimes that no matter how much you prep them, and no matter how much you tell them, they are who they be, and they're going to get up there, especially under the pressure. I'm curious what you think about this, Nicole. And no matter how much you tell them, like I'm sure somebody said, look, when you ask a question, turn and look at the jury and answer. I never do that personally. I want the person to be relaxed. I want them to be natural. I want to be conversational. And yet I have had cases where the witness, my client, who I have prepped or whatever, says something, and I'm just like, you've got, like, the beads start to sweat down the side of your head. Like, what are you talking about? What are your thoughts about all this?
Oh, totally. I have to agree. I mean, anytime a client takes the stand or a witness in your case takes the stand, you're, generally sweating bullets, wondering, what is about to happen up there, and will it be anything like what you've heard in preparation or in the retelling and accounting of the story as it was relayed to you. But I'll say this, too, about that Instagram post. I mean, absolutely, in my opinion, this was done as an attention-grabbing mechanism, because clearly this is Amber Heard's sister, and she certainly has methods of communicating with her own sister that are not in the public eye. She could text her, she could call her, she could send her an email, she could go over and see her in person. These are all ways that she can convey the same message to her sister without making it a public spectacle. So to me, this was on purpose.
Yeah, and let's be clear. She also put a hashtag, I support Amber Heard, to it. But to Adam's point, too, it could be a sister trying to support her sister. So, I mean, again, not necessarily quote-unquote nefarious, whether it's wise to do or not. Reasonable minds, I guess, can debate. But let's not forget about the reason why Whitney was brought onto the witness stand in the first place, and about this incident, the staircase incident that became a really, really big issue, both substantively but then evidentially, with regard to the incident on the staircase. Let's take a listen.
But I'm standing up there talking, or I'm standing up there, I'm at the top of the stairs with my back to the stairs, and that's when Johnny runs up the stairs. And again, I'm facing Amber, he comes up behind me, strikes me in the back, kind of just somewhere over here, he strikes me in the back. I hear Amber shout, "Don't hit my f***ing sister." She smacks him, lands one, and then he grabs, at that point, that's when Travis runs up the stairs after Amber landed one. But by that time, Johnny had already grabbed Amber by the hair with one hand and was whacking her repeatedly in the face with the other as I was standing there. Travis pulls them apart. I get Amber into mine. I close the doors behind me and lock them. I then hear Johnny's voice shouting.
Never mind, withdraw. Okay, sorry.
I hear Johnny's voice shouting, "You f***ing hate you. I hate you both. You f***ing whores." And I hear crashing. I hear crashing and banging and smashing, and he starts screaming like an animal. And I then just moved Amber into the next room, and I just kept her there all night.
My sister, all of a sudden put herself in between Johnny and I. She just threw herself like in the line of fire or whatever. She just all of a sudden was there and was trying to get Johnny to stop. Her back was to the staircase, and Johnny swings at her, and I just see my little sister with her back her back to the staircase, and Johnny swings at her, and I don't even wait for any other, I don't hesitate, I don't wait, I just in my head instantly think of Kate Moss and the stairs, and I swung at him.
Adam, Conta, Adam. I mean, come on. This is kind of like what we were talking about before. I don't know if this is bad witness preparation, bad lawyering, or whatever. But between those two things and bringing up the name Kate Moss, you saw the lawyers for Johnny Depp's team like high-fiving each other like, oh my God. I mean, we've had this happen in court. You opened the door to the very testimony you tried to exclude, but ultimately led to Kate Moss getting on the witness stand for Johnny Johnny Depp. How damning one was it, and where was the error? Was it in the lawyering or in the client?
Oh boy, it could have been both. I would like to give the lawyer the benefit of the doubt and say it was the client. But yeah, it's happened to all of us. You fight vigorously to keep something out that you think could damage your case, and then someone's a little too smart for their own good and opens the door, and there you are. You're stuck with it. You would like to think that the lawyer would have prepared for that, but at the same time, that's kind of a bright line, right? No matter what, don't say X, Y, Z. No matter what, don't bring up a staircase or Kate Moss or whatever else. Even if you think it's true, even if you think he pushed Kate Moss down the stairs, we know that she's not going to say that, and that's not going to help us. It almost doesn't matter. You know what the testimony is going to be if it comes out. And so it was a devastating moment. For sure.
Nicole, I mean, obviously, as a lawyer, like Adam indicates, if something's been ruled that it's not admissible, you could certainly tell a client, don't get into this area because it's been ruled inadmissible. But it is part of her story. Let's accept it for being the truth. Let's say that is what went through her head when this incident happened. And obviously, lawyers can't suborn perjury. Do you think they put her on that stand knowing she was going to go there, or do you think they were shocked, her lawyers?
I'm going to have to go with they were shocked, just because that would just be so completely unprepared to have her do that on purpose, because they would have to know the deluge of terrible evidence that would follow if they did that on purpose.
Yeah, wow, it's something else. Anyway, we're going to take a quick break. We'll come back with more of the Johnny Depp case and some other interesting developments that have occurred after the trial on the other end of the break. Please stay with us. back to afternoon session. So Amber Heard did eke out a little bit of a victory, having sued for $100 million for 3 statements that were made. The jury did come back and find that one statement was in fact defamatory. Here is the statement that Amber Heard won on, and it relates to Adam Waldman, who's the attorney that gave a statement on April 27, 2020, on the online edition of the Daily Mail. This involved a 2016 penthouse incident. As you can see, we have up on there on the screen, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine, roughed up the place, got their story straight under the direction of a lawyer and publicist, and then placed a second call to 911. Let's listen to a little bit about Amber Heard when she testified about that encounter when the police responded based on that 911 call.
And what, if anything, did you say about the identity of Mr. Depp?
Nothing.
Were you asked?
Yes.
But you refused to tell them?
Objection leading.
Sustained. Okay. Why did you refuse to tell the police officers Mr. Depp's identity?
Because I did not want them to arrest Johnny. I did not want this to happen. I did not want any of this to happen. I didn't want to get him in trouble. So I said, well, I can't. I just refused to cooperate.
Okay. Now, approximately how long were the police officers there?
I don't recall exactly. Maybe I'd say less than half an hour. I really don't know exactly, but they weren't there very long at all.
Okay. Now, after the police officers left, what did you do?
We cleaned up a bit because there was broken glass and we had dogs. So we tried to clean up the mess, and especially the glass. And Josh, Rocky, Liz, and I, we kind of just cleaned up and eventually sat on the couch, and they just tried to comfort me.
So, Nicole, there was that one verdict where they found in favor of Amber Heard for the statement made by Johnny Depp's attorney, a $2 million judgment. Interestingly, no punitive damages associated with that. What part of that do you think that the jury found? That Waldman had made the comment that they threw wine around and messed it up in order to kind of implicate him the next time around? Do you think that's where the jury went?
I think, it's really impossible to know exactly what they thought was not true about that statement. And it's interesting to me, too, because it's possible that maybe all of the jurors didn't necessarily agree on exactly what portion of that statement was allegedly false and done with malice. It's interesting, too, as you pointed out, that there are no punitive damages, because even if they believed it to be false and with malice, they certainly didn't feel that the lawyer or Johnny Depp should be punished for the statement. So that is indeed an interesting finding.
Yeah, Adam, do you make any connection to the fact that they awarded Johnny Depp a $5 million punitive judgment? Of course, under operation of law, that gets reduced to $350,000 in Virginia. But nevertheless, were they kind of making a statement? Because, for Depp to win, he's got to win by clear and convincing evidence, which is just below reasonable doubt. And then with it being a public figure, he's got to show actual malice. So I look at that as like a really, really high bar that he met on all 3 counts. And then they awarded punitive damages. You make anything out of that?
Yeah, I think the jury just bought into the idea that Johnny Depp's career was essentially destroyed by all this, and was done so. If they believe that she defamed him, then that is done. That cause and effect is sort of foreseeable, and so that's real malice. You're taking away millions and millions and millions and millions of dollars from one of the biggest stars in the world, versus his attorney, which, even if you believe that he didn't say something that was true, the cause and effect of it is really just saying, well, I don't believe what she said. Not that she had done something or that he had done something that would have also then required these sort of punishment funds that they thought that Johnny would have deserved.
Yeah, Nicole, I've got about a minute left. Any thoughts on collectability on a judgment like this, and where can you explain to our audience how this all works out down the road and how long it can take? And a little bit about pre and post judgment interest, if you don't mind.
Sure. I mean, it's going to take a long time for this to even be in a place where they can start collecting on either of these judgments. And depending on the circumstance, there could potentially be interest, which starts from the time that the judgment becomes final. However, that's not likely to occur until after all of the appeals in this case are finished, which we say exhausted. So it's going to be a very long time for any of these judgments to be in collection status, if they are ever collected at all.
Yeah.
And essentially, we're just waiting to see how the appeals shake out.
Yeah, it's going to be interesting, too. There's so many permutations about collecting a judgment like this at the end of the day. We're going to take a quick break. We'll be right back. Duke was found not guilty on all counts in the murder of Georgia beauty queen Tara Grinstead, except the 6th count of concealing her death, for which he was found guilty. He was sentenced to the maximum of 10 years in jail for that final count. He's eligible for parole due to the 5 years he's already served in custody. Now, he's been indicted in Ben Hill County, the county where he said he helped dispose of Grinstead's body. Again, a very fascinating case here, and remember that during Ryan Duke's first case, he actually testified. Also keep in mind, he gave a confession to police. Prosecutors arguing that only the person who committed the murder could have possibly known the detail that Ryan Dukes told the police. So he got on the witness stand. Let's listen to a little bit of the cross-examination of him in the case in which he was acquitted, actually, for the murder.
That on October 23rd of 2005, you were at the orchard in Ben Hill County, correct?
Yes, ma'am.
And we can agree that on October 23rd of 2005, Tara Grinstead's dead body was in that same orchard.
Yes, ma'am.
And we can agree that you saw her dead body, correct?
Yes, ma'am.
We can agree that you touched her dead body.
After I was told to pick
The answer
her
is
up.
yes, you touched her dead
Yes,
body.
ma'am.
Okay. We can agree that you helped move her dead body.
Yes, ma'am.
We can agree that you helped Bo Dukes get the pecan wood to be able to burn her body.
Yes, ma'am.
We can agree that you were in the truck when you drove Tara Grinstead back to the place where she would be burned.
I don't know if that's where he continued to burn her or not. I was only there that one time.
You were only there that time. But you were there because you've already admitted you helped put her lifeless body on top of that fire pit.
Yes, ma'am, I did.
And you don't want to admit to having seen the match struck, but you know that she was set on fire.
Yes, ma'am.
And you knew that on October 23rd of 2005.
Yes, ma'am.
And you knew that on October 24th of 2005.
Yes, ma'am.
And you knew that on October 25th of 2005.
And every day after.
That's right. Every day after. And you never told a soul.
No, ma'am.
All right, obviously prosecutor unsuccessful in the majority of the charges, including the murder case there, but with this new indictment, he is now facing concealing the death of another, hindering the apprehension or punishment of a criminal, concealment of facts, 2 counts of that, 2 counts also of tampering with evidence. Now, Bo Dukes, who's the other individual that's involved in this case, second trial for similar charges that he is already serving time for, starts in Ben Hill County at the end of the month. So let's listen to John Merchant, who addressed Bo Dukes during the defense's closing argument. The trial again, Bo Dukes, Ryan Dukes, basically pointing the fingers at one another in terms of who committed this murder. Let's take a listen.
Gentlemen, thank you so much for your service over the last 3 weeks. We know what an imposition this has been for you. It's been incredibly hard in your personal lives, I'm sure, and we appreciate your time and attention for taking such good notes. Bo Dukes should be sitting in that chair, not Ryan. Bo Dukes should be on trial for the murder of Tara Grinstead, not Ryan. Where was Bo Dukes in this trial? Why did the state not bring him? Why did we have to call Bo Dukes? Why did Bo Dukes not answer our questions? Be thinking about this as we talk about this case, because there's an important theme here. Ryan took the stand and sat in that chair and told you what he knew. He told you what happened. He didn't have to do that. He could have remained silent and sat over there this entire trial and not told you his story. And you saw him sit there and tell you that story from his own mouth, with his own words, with his own emotion, and you saw how it affected him when he talked. Don't forget that when the state gets up here and tries to tell you that he's a liar. You saw him. You can tell whether he's telling the truth from that chair or not. Keep that in mind as we go through the evidence in the case, because I think it's very important when we talk about his statement that he gave to the police, which you all have heard a lot about. There are a whole bunch of inconsistencies in that thing. And what did the witness yesterday, Mr. Posey, tell us? It was all over the place. Why was it all over the place? Because he wasn't there. He has no idea what the facts are surrounding her death because he was not there. He told you who was there. Bo Dukes woke him up and said, I killed Tara. Not, I killed Miss Grinstead. I killed Carol. Bo Dukes had her as, Bo Dukes was one of her students. Brian was not. Bo Dukes left that trailer that night with Ben McMahon in a black truck at around 10 o'clock at night. Brian was passed out on the floor. You heard from Jerry, famous Jerry now, I assume, picked him up by the belt and dropped him on the floor to make sure he was alive. And he groaned, and that's the last time anybody saw Ryan that night, passed out on the bathroom floor.
All right, I still have Adam Conta with me and Nicole DeBoard, both criminal defense lawyers. Nicole, Adam, let me go to you first on this. Talk to us about this double jeopardy issue. Let's understand what the legal framework is here, and how is it that they're being now re-indicted for these additional offenses after there's already been trials on these cases?
So you can't be charged and prosecuted for something that you've already been charged and prosecuted for, especially on the same evidence. So what they're going to have to do in order to substantiate this indictment, I don't know the answer. As I read it and as I look at the articles relating to this new indictment, all my brain is doing is going, this is double jeopardy, this is double jeopardy. So I don't know why it's not yet. But there has to be new evidence. And what they're going to say is that it's based upon his testimony and that it went into more detail in the county in which he's now being charged. And then that's what gives them the cause to now charge him with this new set of charges based on what they're going to say is new information. But it all stems from the same incidents, the same crimes, it's the same set of facts. So I'll be really curious to see if this survives a double jeopardy challenge, which I'm sure will be coming.
Yeah, Nicole, I had the misfortune, if you want to look at it from a legally, of working a case like a year and a half ago where I had to look at the double jeopardy laws of each state, and they were different in terms of, like, for example, in New York, where double jeopardy is very liberally granted if there's any connective tissue between the matter in which somebody's found guilty or pleads guilty and a crime, similar in nature that may have been committed also in the other state. And then some states, they do it by common law, some it's statutory law. But what were I think every lawyer that read this at first must have been, immediately the issue jumped to them that double jeopardy is involved in some way, shape, or form. Do you have any insights into that?
I do, and the reality is that as long as there are different elements to this crime, right, so you can have the same set of facts underlying the charges, but what they are charging the person with has a different legal element that needs to be proven, then they can charge that individual with a different crime based on those facts. So I know that's fairly complicated, but the prosecution may be on firm ground here with these additional charges because they are saying that they have to prove something different than what they had to prove in the murder case. Now, if they had to rely on the murder case as an entire fact scenario that they would have to be reproving, they would have a double jeopardy standard problem, quite frankly. But they don't in this case because they're only having to prove a different crime, that he concealed the death of another and did something to tamper with evidence ultimately. So I think that this case will make it all the way through to the finish line.
Let me play devil's advocate with you on that theory, though. While he may have testified to that, this is not something that the prosecution was unaware of. There were statements in this case, and I guess I'd like to get to the point, as a former prosecutor, I've never heard the thing where, well, I got him on murder, we got concealment, but let me hold off on tampering, let me hold off on these other charges, see what happens there. If I can't get a conviction on number one, I go to indictment number two, and if I can't get a conviction on number two, I go to number three. What responsibility at a certain point in time is there for a prosecutor to bring all the charges relevant to the facts of a particular case in one indictment so it can be adjudicated all in one space?
Right. I think that there's definitely an issue there, but that issue is speedy trial as opposed to double jeopardy. And the speedy trial issue is one that requires, in good faith, the prosecution address the issues in a time that allows for the defense and the defendant to examine the evidence of the charges against him and go out and talk to witnesses and gather information so that they can defend themselves. And if you lay behind the log and you wait to prosecute someone, then the defendant can say, you know, listen, I should not be prosecuted now because I was entitled to a speedy trial on the matter, and the case should be dismissed because the government in bad faith, or the state in bad faith, did not act when they could have because they knew about these charges. Just because he confesses to this additional case or these cases on the stand doesn't mean they didn't know about these very things when they were preparing their cross-examination to ask him about these very crimes.
Adam, I'd love to do an analysis around the country of how many motions for a speedy trial are granted by a court, because so far in my entire career of 30 plus years, they come out to zero, and some in pretty egregious situations. I guess I may have been doing it wrong when I was prosecutor. You know, Adam, what do you think? I should have charged for murder, and if there's not a guilty on murder, then I go to ag man, and then I go to manslaughter, because all those are different elements of the crimes. At a certain point in time, I think this double jeopardy analysis is also going to come to what similarity there are in facts of the case as well. What do you think?
I mean, to me, this is bad policy. What you're arguing to do as the Georgia prosecutors is bad policy. You're saying that you're going to keep trying under a new set of charges with the same set of facts and the same transaction. That's not how our justice system is designed. It's not what it's intended to do. And it's quite frankly an abuse of that system to try to make this some sort of normalcy to it. And yeah, I get that this is a high profile case. Yeah, I get it. You got your butt handed to you in trial by a jury. You should have done better. You know, I don't know what else to tell you. You should have prepared better, and you should have had better evidence instead of this. To me, this comes off as not a good look for the Georgia prosecution system.
Yeah, Nicole, to the point that Adam's kind of bringing up there, I mean, prosecutors, I'm saying we're not judge, jury, and executioner. I mean, there's a reason for a multi-tiered system here, but one cannot help but think, and you tell me if you think this is legitimate, because it very well may be, that the prosecutors genuinely believe that he committed this murder. They believe that. They believe an injustice occurred within the court, and that the sentence that he got for that one small charge is so woefully inadequate. Is it fair for prosecutors to feel that I need more time, I need more charges, consecutively sentence him because an injustice has been done, or should the prosecutors respect completely the verdict of the jury?
You know, there are so many questions wrapped up in that one question, and it really comes back down, in my opinion, to these two federal principles, which are, you know, you have double jeopardy, which is grounded in the federal Constitution, as is speedy trial, also grounded in the federal Constitution, right? So we have a Sixth Amendment right to defend ourselves against accusations by the government and to present a defense. And you have the right to do that in the context of a specific allegation. So even though I think that maybe legally from a double jeopardy standpoint, the prosecution may be on firm ground, the reason that I go back to this speedy trial issue, and by the way, I've actually won a case on a speedy trial issue, because there are times when the prosecution in bad faith can just sort of hide behind the clock and say, I am not going to proceed on this right now because I think I want to go for the bigger win and not prosecute this person for this smaller case. And now this prosecution team has lost the bigger case, and they're trying to go back behind the clock. And they have another problem here, and that problem is that they're actually outside the statute of limitations, if you don't count COVID delays. They're outside of these time frames in this circumstance, and there's going to be litigation about whether or not that time bar should prevent them from prosecuting these cases that they now seem to have sour grapes and wish they'd indicted in the first place.
Yeah, interesting how COVID is playing into tolling that statute of limitations in some tolling or stopping and then starting again, because the courts basically, at least in my state, were like, okay, statutes don't apply from now, they still don't apply for time against the clock, and then eventually they cut the cord and said, now you can start that clock back up again. Okay, guys, listen, I know both of you are experienced trial lawyers, and I personally think that everybody thinks the most powerful and important person in that courtroom is the judge, and in many ways it is, but there's also the court stenographer We're going to talk about what happened in the Johnny Depp case, but the court stenographer. Can you imagine it? Now she's in the news and getting beaten up. We'll be right back. You're going to B-roll while I'm reading that? When it comes down to the Johnny Depp Amber Heard case, no one gets out alive from scathing criticism, and that includes the beloved court reporter, by all estimations on all sides, Judy Bellinger. She has been getting a lot of heat because people think she was partying it up with Johnny Depp after the verdict, after the video started circulating on the internet, but that wasn't the case, okay? So it may appear to be one thing, but it turned out to be another. And if it wasn't, there you go, you see the video right now. She kind of quickly was with Johnny Depp and is hugging another person there. So she got a rash of criticism on social media. You can see her. She seems like a very, very nice lady. She was always smiling in that courtroom. But our very own Anjanette Levy, I mean, she was at the scene commenting. Anjanette was anchoring. She got a scoop with an interview with the court reporter, with the stenographer, to talk about, like, what was that all about and what was going on. Let's take a listen to the interview.
So after closing arguments, I finally decided I wanted to get out of the courthouse and just take a breather. We were supposed to go until about 5:30, maybe 6 if the jury wanted to. And so I thought, you know, I want to maybe try to go to Indiana this weekend. Let me run down the street and get my oil changed, and I'll come back and go back up. The courthouse closes at a certain time, and I didn't make it back in time. And Judge Ascarati just wanted to close the record, And I'm like, oh yeah, well, I'm stuck outside. I'm getting my oil changed. And she goes, oh, it's okay. Well, she didn't say it. I was getting messages. And I said, okay, just don't worry. My recording's going. It's just closing the record. I'll, transcribe it when I get back. But then I needed my equipment. So Mr. Chu and it was Rebecca. I think they were the ones that were there, and they were kind enough to pack up my computer for me in my backpack, because that's all I needed. I leave my machine there because it's just quicker to come in and just set up my computer and not have to set everything up every day all over. So they were kind enough. They said, okay, if you tell us how to, disconnect everything, we'll bring it to you, because we have an office right around the corner from where we are now, and this is where they were staying. And I said, hey, I have an office on Greensboro. I can meet you there and get my equipment, and I can get the transcript out this weekend. So they're like, okay. And then I guess Johnny had told them he would really like to meet the court reporter, which was like shocking to me. I'm like, I'm just the court reporter. And so when they brought me my equipment, well, they were going to bring it, and there was no one at our Greensboro office, and you can't get in if there's no one there. So
and it's Memorial Day weekend.
Right. So
it's a holiday weekend.
Yes. So they just brought it back to the hotel, and they said, hey, do you mind if we just take it to the hotel and you can pick it up here? And actually, it took me a minute. I didn't know how to get up here. I didn't know you had to come in the downstairs door and then go to another floor and then get to another floor.
It's a little confusing.
It is very confusing. And so they had my computer and stuff with them, and they were in the hospitality room, and Johnny was in there. And so I had to go in there and get my equipment, and I saw him, and they're like, he really wants to meet you. And I was in there for probably less than 10 minutes, and he just hugged me and thanked me again, and I hugged a couple other people there, and I got my equipment, and I came out, and I left and went home.
That's really funny, because a lot of people are suggesting you're just out at the after party hanging out, with Johnny Depp, and that's not what happened.
Not at all. I still had from here, I had about a 50-minute drive home, so no, that did not happen. Yes.
He gave you a hug?
Yes.
You picked up your stuff and you left?
Yes. But it was a moment that I'll never forget.
And you've got video to support it. Have the grandkids seen that video?
No, not that I know of.
All right, let's make clear what's going on here. She's a freelance reporter. She was actually hired by both sides who paid for her so that they could get daily transcripts. In other words, get them much quicker, which is a great asset when you're on trial. There's a recording machine that's going on that's preserved by the court. So, Adam, there's a lot of people talking about this. Even if she went there because she was starstruck or whatever, there's no insinuation that anything improper occurred. There's a backup record with the recording that the court maintains. A lot of hullabaloo here, or do you see a legitimate issue?
Is that social media is an undefeated beast that can and will attack anybody. And that goes right back to the Instagram story we were talking about earlier, right? Like, this is a woman who, look how giddy and happy she was just to meet Johnny Depp. Aside from whether she should have or shouldn't have been, there's clearly no impropriety here. She clearly is a woman who was hired to do her job and did it well. And there's clearly a backup audio of it. She couldn't have tried to doctor this or do anything with this, with the transcript if she tried. It's just everyone is looking to make everyone a villain at the drop of a hat. And this is just another example of that.
Yeah, Nicole, court reporters have a very special place in that courtroom, and we've all tried big cases and been there for weeks at a time. And the sheriff's officers or the bailiffs have a role to do, and the judge has a role to do, and the lawyers have a role to do, and the court administrators and the court clerk and the stenographer. After a while, if you're not a jerk, you will be kind of friendly with one another. And the court reporters, they're important because if you need data or information, they can say yes or no or slow roll it or not. But what do you think about this whole issue?
I think it's outrageous, and it is such a shame. This woman was there doing her job at the request of both sides. She's clearly a professional. It would be abnormal for her not to be friendly with either side who she was communicating with. It does seem like people who are just generally angry individuals looking for someone to blame for their own problems when they're going after someone like a court reporter. Very disappointing. This woman should be applauded for the excellent work that she did in a very long trial.
Adam, I got about 20 seconds left. Talk about how difficult their role is, especially when lawyers are talking over one another, rapid fire cross-examination. This is not an easy job.
No, and I'll answer in the reverse real quick. When you have a court reporter who can keep up with you, doesn't interrupt you to ask you to repeat something, and does her job well, she might literally be the most important person in that courtroom. And they should be applauded for their work. It's that little magic box. I'll never understand it.
I know, it's crazy. You look at it, they're reading it back word for word. All right, Adam Conta, Nicole DeBoer, thank you guys so much. You did a wonderful job as always. That's it for me, but don't go anywhere. Stay on the channel. I'll be back this Thursday from 3 to 5. Have a great rest of the week.